to the no contact provision proposed between Mrs. Crumbley and Mr. Crumbley, and I'm arguing on behalf of Mrs. Crumbley, obviously, and between Mrs. Crumbley and Ethan Crumbley. This is a family. They have, despite even having felonies on their records, they have a constitutional right to be a family unless the prosecution can articulate a reason that is valid and surpasses a certain standard to allow to disrupt the family from being able to have contact with one another.
Let me give you some information that I didn't previously have. I've consulted with the probation department, the Michigan Department of Corrections. They have indicated to me that if Mr. Crumbley and the shooter are in prison, the Michigan Department of Corrections will categorize them as enemies. And I put that in quotes. The reason being that they will not, it'd be like two brothers or something like that. They will not, they're characterized in that way, so they will not be housed in the same facility. So there is that factor. I think the other difficulty I'm having is that I got your sentencing memo at about 4:32 on Friday, and miscellaneous I got over the weekend. So the prosecutor didn't have a chance to respond to that. So I'm not clear if there's. I guess I'm going to ask if there's any objection, or if you'd like to file something supplementally. I honestly never faced this issue. So I don't know.
I can just respond. My only response, Judge, is that we're asking that these defendants be treated like any other defendant in the Michigan Department of Corrections.
Right.
And it's my information that because they are co-defendants, the no contact will be in place, and because the shooter is a related defendant, no contact will be continued. Again,
okay, you just mentioned two different issues. Because they're co-defendant, they're a man and a woman anyway, right? So they would, if they go to the Michigan Department of Corrections, they would not be in the same facility.
Correct.
Co-defendants are traditionally not housed together. There's that issue. She's asking about a no-contact order between Mr. and Mrs. and the shooter. So I don't know what your position is on that, or if you have any legal authority to support your position, if you want to respond to it later. I have frankly never faced this issue. So.
Well, yeah, that's probably true, Judge, and as the court indicated, this was objections made recently. I don't have anything at the ready as far as legal authority regarding that. My information is only from the Michigan Department of Corrections, and the reason why they put the no contact in place, and that is because of the nature of this crime and the fact that they are related defendants. Again, we're not asking for any special treatment one way or the other. We just want whatever the Michigan Department of Corrections would do in any other case.
All right, well, would you like to respond, Ms. Wheeler? I think you were the one who told me about the enemy status in quotes that would be maintained.
Yes, Judge, and there's certainly no guidebook for this situation again. Those are my thoughts on why I recommended the no contact order, but certainly the court can issue what they want. It was just my thoughts.
Would you like to respond? If not, I don't see a reason to have a no contact order at the moment. If the Michigan Department of Corrections was able to tell me the reason to have a no contact order, I'd consider it. I know you're going to have a chance to respond, but at the moment, I can't think of a reason for a no contact order. If the three of them are all in the Michigan Department of Corrections, it would then be up to the Michigan Department of Corrections. But should I be ordering that right now? Is what I'm asking. Is there legal authority for me to do it? The options are lifting the no contact order or allowing you to research further.
You just don't want the sentencing to be adjourned, Judge.
Me neither. I'm not hearing this answer.
In that case, Judge, could the court hold this in advance so we can respond?
Yes.
That would be my preference.
All right, I'm going to do that. All right, because they would have a chance to respond to that. Just the issue of whether or not the three of them would have no contact via. I think if all three of them were in the Michigan Department of Corrections, or if one of them was somewhere else at some given time, is there allowed to be contact either by letter or phone or visit? That's what you're asking about.
Yes, that's what we're asking about.
All right.
But obviously, if Michigan Department of Corrections is overseeing or if they're in a facility, there's rules they have to follow, and this court doesn't order all of the rules that have to be
Oh,
followed.
I agree.
So-
That's up to the Michigan Department of Corrections.
So the court obviously will give the prosecution time to file a supplemental response. We filed our response rather quickly because we were given the PSI last week. We were given the prosecutor's memo on Wednesday. And I mean, obviously I got mine Friday, but there wasn't much time. I would also like an opportunity to either respond to their argument or to be able to brief the issue first if the court would like, because it's my objection, more fully than I have been able to in here.
You may.
Okay.
It's not something I've dealt with.
Okay. I guess I'm just asking what time frame the court would like, or,
How long would the prosecution like to respond?
A week's time, but
Okay, so you are going to file something by April 16th, and then how would you wait till the 23rd of April to respond?
that would be great, thank you.
I mean, they might do some research and find out there's no basis for it. I don't know.
And Judge, I will look further into that and also provide the information.
All right, thank you.
Judge, I'll communicate with the court, then sounds good.
Thank you.
Just for the record, I'm just placing my objection to the no contact order for the reasons stated in my sentencing memorandum. I will also file a reply brief on it.
All right, thank you. All right, what else?
Your Honor, the remainder of the objections for Mrs. Crumbley are based on guidelines
All right,
scoring.
sure,
Would the court like me to?
sure.
Okay. Your Honor, Mrs. Crumbley is objecting to the scoring of offense variables 7, 9, and 13, all based largely on the same reasoning. And so those offense variables are scored the way they are proposed by Michigan Department of Corrections based on the number of deaths that resulted and based on the number of persons injured. And the problem with it is that Mrs. Crumbley was found guilty of completing an act of gross negligence or failing to adhere to a legal duty. But when the shooter got the gun and made the decision to shoot multiple people, that took any and all culpability for the number of victims and put it in his hands. So the shooter, if he had gone out and shot one person, which if it's reasonably foreseeable he would hurt anyone, okay, one person might be reasonably foreseeable, the guidelines would be scored far differently. And just as a matter of course, the guidelines don't take into account a situation like this, much of the law in this case has been novel and new. So we would ask the court to score those guidelines at 0 points because...
Can you be specific about which, you need to take each guideline individually, it's important for the record. Right?
Sure. Okay, so prior record variable 7 gets scored when there are 2 or more offenses that the defendant is convicted on. And the objection in this case is that the conviction is based on there being 4 deaths. The conviction is not based on Mrs. Crumbley committing 4 acts of gross negligence. And this is a case where we have an intervening factor. We have an adult who was charged as an adult, sentenced as an adult to life without parole, who took everything out of Mrs. Crumbley's hands and made decisions himself. So to charge Mrs. Crumbley, hold it against her that there are 4 deaths, that part of it was not reasonably foreseeable to Mrs. Crumbley.
Didn't the jury disagree with that?
No, the jury found that the jury did not find 4 different ways to say that there was gross negligence. The scoring is based on the number of deaths. At the end of the day, the shooter could have gone and shot 1 person, or 4 people, or 100 people. The problem is that even if it's foreseeable that something was going to happen, when the shooter intervened and made the decision what he was going to do as an adult that was convicted and held accountable for each of those 4 deaths and everyone injured, it came out of control from Mrs. Crumbley. So we object to the scoring that she committed 4 offenses. I agree with you, the jury entered 4 convictions, but the basis of it was 4 deaths. And it's not 4 acts by Mrs. Crumbley. This is a very unusual case.
Well, if there were specifically 4 deaths intended, she would be charged with homicide, right? Isn't that true?
That would be true. But as with involuntary manslaughter, so if a person drives a car and ends up killing 6 people, there could be 6 counts, okay? But this situation is distinguishable because we have a different person who comes in as an adult, makes decisions, and takes any of what could be possible out of Mrs. Crumbley's hands.
Okay, he wasn't an adult. He was charged as an adult.
I-
Isn't there a difference?
Well, yeah, you're right. I'm saying though, he was charged as an adult. He was held accountable for those crimes. He made the decision on how many people to shoot. He went in and made intentional choices. My point is just that Mr. Crumbley and Mrs. Crumbley, and I apologize because I'm arguing for Mrs. Crumbley, but sometimes I'll mention both. The decision on the impact of this case was absolutely not in their control. It was not foreseeable. And that's the basis of the objection. Even if we respect the jury's verdict, they found that gross negligence took place. We respect that. That's fine. We get that. But at the end of the day, Mrs. Crumbley shouldn't be sentenced as if she controlled the fact that 4 people were murdered, or if the shooter had shot 100 people. That's the objection, and this is a unique issue. It's a unique issue in that there is not case law, and it's going to be a matter of first impression.
Ms. Lehman, do you want to weigh in on this PRB 7?
I would, Your Honor. I also am objecting to this scoring at 20 points. I do believe that the proper score is for 0, for reasons similar to those that Ms. Smith stated. This is not a case where there were 4 separate grossly negligent acts alleged. It was one grossly negligent act. And quite frankly, we don't have the jury here to ask them what they found or if they found that there were multiple grossly negligent acts. There were 4 counts for the 4 deaths of the students. And Your Honor, I understand that having these conversations, I'm not trying to be callous to anyone, Your Honor.
I know.
But the 4 counts were for the 4 deaths that occurred, not for 4 separate criminal acts on behalf of James Crumbley. I understand what the jury's verdict was. I understand that, Your Honor. However, it's not as though a similar situation, Your Honor, would be speeding through 4 different stop signs and causing 4 different motor vehicle accidents resulting in death. That would be something similar to a concurrent or a subsequent felony conviction. In this case, it is arguably one grossly negligent act that resulted in 4 deaths. And obviously also multiple injuries and other issues as well, Your Honor. But my position is that this should not be scored at, PRB 7 should not be scored at 20 points because it is one act, not multiple acts. And I don't believe that the sentencing guidelines properly consider the facts of this case. Again, we've never seen a case like this before, and I don't believe that the sentencing guidelines properly consider the facts of this case, Mr. Crumbley's case, or even Mrs. Crumbley's case, to adequately score PRB 7, and I believe it should be scored at 0.
I'm going to ask both the prosecutor and probation if you'd like to respond.
Thank you, Judge. There is 0 support for counsel's argument that PRB 7 should be scored at 0. The case law is clear, the statute is clear. There were 4 separate homicide counts. 4 children were murdered November 30th, 2021. Because of that, each defendant was charged and then convicted of a homicide count, involuntary manslaughter, each with its own elements, Judge. We've argued back and forth about was this homicide or was it not. This is why the court issued the rulings the way the court did regarding the video and other evidence regarding photographs of what happened inside the school. The statute is extremely clear. 4 separate counts. They don't get to have a scoring of 0 as if 3 children weren't killed, Judge. It is clear what the law is. It has to be scored at 20 points.
Anything further from probation?
No, Judge.
Right, well, I have reviewed this thoroughly, the sentencing memos that you have submitted, as well as the pre-sentence investigation, the statute and the case law, and I believe PRV 7 is scored correctly with regard to both defendants.
Your Honor, the next objection that Mrs. Crumbley raises is on offense variable 9, which is the number of victims. This analysis is the same as the arguments I just made on prior record variable 7. When the shooter came in and made the decision on the number of victims, it became not a reasonably foreseeable conclusion that he would do what he did. And that is why scoring that at 100 points for multiple deaths, these guidelines don't take into account this very unique situation where a person, again, charged and convicted and sentenced as an adult, made that decision. And it violates due process and all of Mrs. Crumbley's constitutional rights to hold it against her that her son shot multiple people versus just one. So we would ask that that offense variable be scored at 0 points.
Ms. Lehman, do you want to weigh in now, or, yeah?
I can, Your Honor, and that way the prosecution can respond once, Your Honor.
All right, go ahead.
OB6, again, it's scored at 10 points.
Are we talking about OB6 or OB9?
I'm on OB6.
Oh, wait.
You said OB9 number of victims.
I'm sorry.
I can do OB9, Your Honor, if you'd like, and then go back to OB6.
All right.
I went to OB9.
I can do OB9, Your Honor.
Okay, go ahead.
OB9, similar arguments to PRV 7, Your Honor. It was not Mr. Crumbley who pulled the trigger on the firearm that killed the 4 students, Your Honor. I'm making the same arguments. I don't think that I need to reiterate them, but I believe that it should be scored at 0.
Thank you, Judge. Regarding offense variable 9, the jury did find it was reasonably foreseeable. It's jury instructions 1615, 1618, 1610, Judge. 2 juries, 24 individuals, 24 citizens found them guilty and found this act to be reasonably foreseeable. Had they not, they could have been found guilty. That's the law. Now, again, there is no justification for scoring at 0. They are homicide offenses. Each is a separate count. The statute is clear. The case law is clear. We provided supporting information and documentation in our sentencing memorandum. The scoring has to be 100 points.
Anything, Ms. Wheeler, in addition?
No, Judge, thank you.
All right, well, I agree. I've spent, even before receiving any of your sentencing memos, I spent an incredible amount of time going through all the guidelines, and I believe that OB9 is scored correctly to pursuant to the pre-sentence investigation, the statute, as well as the case law in this matter. All right?
Your Honor, Mrs. Crumbley's next objection is to offense variable 6, which is the offender's intent to kill or injure another individual. We would object to the scoring of this variable because Mrs. Crumbley did not have intent to kill or injure another individual, even if she was grossly negligent and obviously found guilty of gross negligence. That does not mean she intended to kill or injure another individual. We know who intended to kill or injure another individual, and that's the shooter. He was held responsible, he was charged, he pled, he was held responsible, and we would object to the scoring of OB6.
Okay, OB6 says, or there was gross negligence amounting to an unreasonable disregard for life, right? Or.
I agree with you, but the problem is that, again, these sentencing guidelines don't take into account another person coming in and making those decisions. So that's the problem, and that's what makes all of these guidelines not exactly fit with the circumstances of this case.
You know, did you guys read, I sent you a case named Albers. Did you read that case? I thought that was interesting. 258 Mishap 578. I thought that was telling. There was a number of victims in this apartment, and someone was a fire starter, a known fire starter, injured all kinds of people there. And I think that had more to do with OB3, but I thought that was a telling case. Ms. Lehman?
The difference, Your Honor, in that case, though, is that there wasn't somebody who was charged as an adult that intervened and made the choice to hurt everyone in that apartment building. That's the difference in this case, is that Mr. and Mrs. Crumbley did what they did or didn't do, but when their son came in and made decisions, again, it took it out of their hands. And if he had made the decision to do something different with that weapon, we wouldn't be here with that scoring. That's the difference.
I don't think they were charged based on what he did with that weapon. They were charged with everything they did and didn't do up to the time that he used that weapon, right? What he did from the moment he started shooting is not really the crux.
I agree with you, and that's why the problem is that because he got involved, the offenders in this case did not have any intent on their part, and so it just makes it very distinguishable from any other case of involuntary manslaughter. It complicates it enormously, and it really does become an issue of first impression in this case.
Ms. Lehman.
Yes, Your Honor. For OB6, it's currently scored at 10 points. The defense, Mr. Crumbley, requested it be scored at 0 points. The prosecution asserted 2 separate theories during trial, which were both read to the jury. We don't know which theory the jury relied on. If they all relied on the same theory, if they all relied on different theories, if half of them relied on one and half of them relied on the other. Unfortunately, Your Honor, we don't know the answer to that. So the issue that we have is that there are 2 theories under which Mr. Crumbley could be convicted during trial. We know that he was convicted because we're here at sentencing. But neither of them takes into account the fact that there was no evidence presented that Mr. Crumbley was aware of what his son was planning. There's the guidelines, and specifically OB6 doesn't take into account that there was no evidence presented during the trial that Mr. Crumbley was not aware that his son had obtained access to any firearms in the home. And again, for these reasons, it's the intent. I understand that gross negligence is a part of the scoring, Your Honor. However, it's disregard for human life. There was no evidence presented that James Crumbley had disregard for human life. Whether it's believed he was grossly negligent or not, Your Honor, there was no evidence presented during trial. Again, notwithstanding the jury's verdict, I understand what the verdict was, Judge, but the guidelines themselves, the scoring, which is what we're doing right now, this is not retrying the case, this is just scoring the guidelines, and the guidelines themselves, Your Honor, do not take into account the specific facts of this case and the evidence that was presented during this case. So for those reasons, Your Honor, I'm asking that OB6 be scored at 0 on behalf of James Crumbley.
Prosecution.
Thank you, Judge. In Jennifer Crumbley's memo, there was no objection to OB6. We did respond and articulate the reasons why. In James Crumbley's memo, I asked the court to take that argument from our memorandum into consideration regarding Jennifer Crumbley's case as well. First, I'd like to address the counsel's repeatedly calling this a case of first impression. This is a rare case. It's a unique case, but it's not a case of first impression. The legal duty in Michigan has been around for years, as has involuntary manslaughter and the law surrounding involuntary manslaughter. We actually cited Albers to the Court of Appeals as well as to this court in our response to the defendant's initial motion to quash in early 2022. That case is on point, as is People v. Cole, which is cited and attached to our sentencing memorandum. The jury instruction is clear, 1618 and 1615, Judge. OB6, 10 points are scored when there was gross negligence amounting to an unreasonable disregard for life. Compare that to our jury instructions in the case in People v. Cole, where the Court of Appeals specifically said, acting in the grossly negligent manner where it was apparent that serious injury could result implies that defendant Cole was acting with an unreasonable disregard for life. OB6 should be scored at 10 points.
Anything additional confirmation?
No, thank you, Judge.
I believe OB6 is correctly scored.
Your Honor, Mrs. Crumbley's next objection, and again, this is along the same analysis as the prior objections, is to offense variable 13, the continuing pattern of criminal behavior. This case is scored based on there being 4 resulting murders and multiple injuries in this case. And again, this factor was ripped out of the hands of Mrs. Crumbley when the shooter decided to make a continuing pattern of behavior and resulted in multiple harms and murders. Mrs. Crumbley did not exhibit a continuing pattern of criminal behavior. There were not 4 or multiple counts of gross negligence, and therefore we would just object to it being scored at all.
Ms. Lehman?
Yes, Your Honor. For OB 13 for Mr. Crumbley, a single felonious act cannot constitute a pattern. People versus Carl, 322 Mishap 690, is a Court of Appeals case which indicated that a defendant's multiple convictions for reckless driving causing death or serious impairment arose from his single act of driving recklessly. He had passengers who were injured. There was at least one death that occurred. The Court of Appeals found that it was error to score OB 13, even though the driver of the car, who was the defendant, struck and killed someone, and passengers in the defendant's car were seriously injured. So, Your Honor, this would be something similar. This is arguably one act that resulted in 4 deaths. This is not 4 separate acts. Going back to my discussion, and I believe PRV 7, Your Honor, running 4 different stop signs. Those are 4 separate and distinct acts resulting in injuries or deaths. In this case, we don't have that. It is arguably one grossly negligent act that resulted in 4 deaths. And Your Honor, I'm not in any way trying to minimize that those students were killed, Your Honor. But in scoring the points, it's currently scored at 25 points for the 4 deaths, and not 4 separate acts. Those 4 separate acts were committed by Mr. Crumbley's son, based on, according to the jury, his one act of gross negligence. And again, we don't know what act the jury relied on. We don't know if they believed that there were multiple. We don't know, quite frankly, Your Honor. But there aren't 4 distinct acts, 4 separate acts of gross negligence that resulted in each of the 4 deaths of the students. So again, Your Honor, for these reasons and the reasons that I stated in my memorandum, and I do cite additional case law for the court, I believe that OB 13 should be scored at 25 points on behalf of James Crumbley.
Well, I did read the case.
I'm sorry, 0 points, Your Honor.
I did read the case law in your briefs, but I think there's some more recent case law provided by the prosecution in their brief. I don't know if it's Herman or Gibbs. Do you want to respond?
Yes, that's great. Thank you. First of all, OB 13 does permit the court to score 25 points when the incident occurred on one day. There was substantial evidence presented to the jury to show this was not one isolated act. Gross negligence occurred over a period of time. There was absolutely a pattern of gross negligence that culminated in the shooting on November the 30th, 2021. Just off the top of my head, buying the gun, not locking the firearm up, not taking him home when asked, not asking him about the gun on November the 30th, not reacting in a variety of different ways when shown that math worksheet on November 30th. There wasn't one single act of gross negligence. It occurred over a continuum. We presented evidence in the Jennifer Crumbley case from March 2021 till December of 2021. In the James Crumbley case, again, March from 2021 to December of 2021. Over the period of those 8 months, Judge, there were a number of acts for this court to rely upon. We do believe that OB 13 is appropriately scored at 20.
Anything else from probation? Again, I have reviewed all the PRVs and OBs and the case law in the statute, and I believe it's correctly scored.
Your Honor, the next objection Mrs. Crumbley has is to offense variable 19. This is a different type of argument than the prior argument, so I just want to let the court know. This offense variable is to be scored when a defendant interferes with or attempts to interfere with the administration of justice. And the reason this was scored against Mrs. Crumbley is because of the claim that she tried to run and tried to avoid arrest. On the night before charges were issued, I texted Miss McDonald directly, which I attached to my memo, and said,
Judge, I know it's argument, Judge, but we've been over this before a number of times. And the court's a charged felon doesn't get to text somebody
We've had this discussion.
and the court has already indicated that, Judge. I ask we move on.
I'm going to let her make her argument, but we've had this discussion before. Law enforcement does not have to ask for permission to arrest someone. If I have an outstanding warrant, one of these deputies could come up to this bench right now and cuff me.
I understand that, but what the prosecution has done is put together a false narrative that's been repeated by the media over and over and over. And it's been repeated in court. Miss McDonald is the one who said they were in an industrial building. She's the one who used the word abandoned.
It was a warehouse, a non-retail place that was closed at night. Right?
It was not a warehouse. It was a building that had businesses in it.
It was a non-retail building.
No, there are retail businesses in there, and there are businesses in there that are not retail businesses. Either way, it was not an abandoned warehouse.
Okay.
Okay? And then the prosecution argued and put on the record.
I guess it's hard for me to understand why it matters whether it was abandoned or not.
Okay, because the narrative the media has played over and over and over repeats inaccurate information.
I can't control the media, trust me.
I understand. However, the prosecution also stated falsely and knowingly falsely, based on the fact they had a video of when Mrs. Crumbley and Mr. Crumbley were found. The prosecution claimed they were crouched under a mattress, which is just not true.
They were laying on a mattress.
Right. At the time, though, they made it sound like they're crouching and hiding, and the media reported that over and over and over, and that has been a major problem throughout this case, and why I asked this court for a gag order. And we were thankful for the gag order. It did eliminate some more of the narrative coming out. But the prosecution very successfully painted this picture of people on the run. Meanwhile, Miss Lehman and I can't do anything more to get our clients turned in. We are desperately calling the prosecutor's office, filing appearances with the court, making arrangements. Our clients are being threatened so badly, they are terrified to just go walk into a jail where everyone is looking for them in Michigan. We plan to be with them as their attorneys, and it's complete garbage that the prosecution has been able to carry this narrative out through trial. And that's why I did attach my text messages to Ms. McDonald letting her know. All she had to do was say, I am charging. She did not let me know.
She does not have to do that.
It's a professional courtesy that most prosecutors do. It just is.
Not in a case like this.
Evidently.
Ms. Lehman?
Because, well, there's different arguments for each defendant.
That's correct, Your Honor. They are different arguments.
Okay.
So I just want to address this briefly, Judge. First of all, this court may recall the text messages that the court allowed to be admitted in the Jennifer Crumbley case.
At 11:16 p.m.
That's correct, Judge. Text message between Shannon Smith and the defendant. We're hiding out. We may have been found. And then the response was, oh shit.
Judge, I object. That's not what it was.
That's admissible evidence.
Right, but that was not texted by Mrs. Crumbley.
Okay, well,
she was already asleep.
Okay, here's the problem with that. Because the evidence has shown, both of the defendant's sentencing memos address the arrest in Detroit. You've suggested on numerous occasions that the prosecutor was required to make arrangements with one or both of the defendants to turn themselves in. I know that in circumstances where someone is charged with a retail fraud, something like that, you might get a come-in letter. They're not required to do it. Do we all want things to happen the nice way? Sure, but it's not true. Law enforcement is not required to ask permission to arrest people. The fact of the matter is the charges were announced at noon. They knew about the charges. You knew about the charges, right?
Not until after the press conference.
At noon.
And then we were trying to make arrangements.
It's my dime.
Sorry.
They do not have to make arrangements with you. I know that's the nice way. That's the safe way. The fugitive apprehension team was in contact with you. The defendants were aware and did not turn themselves in. They went to a non-retail establishment in Detroit and hunkered down. It's unclear to this court, to this day, whether they intended to flee the state. But the fact remains that they brought the circus to the city of Detroit. They did. There's also been testimony by Mrs. Crumbley and an allegation by Mr. Crumbley in the sentencing memo that the defendants were not avoiding detection in that building. That allegation flies in the face of the testimony at each of the trials. We had testimony from Luke Kirkley. He testified that he made eye contact with Mr. Crumbley in the parking lot. He went back into the building. We see that on the video at the art studio building, industrial building, whatever you want to say, that the defendant, Mr. Crumbley, followed Luke back into the building just after that. Luke immediately called 911 at 10:43. I reviewed all the testimony in this area. The Detroit police arrived 20 minutes after that 911 call. Their text from Mrs. Crumbley's phone at 11:16 p.m., despite the fact that she testified she took 4 Xanax, drank vodka, and was asleep by 11 p.m. That is simply not true. Numerous agencies, including the Detroit Police Department, Border Patrol, SWAT, the Oakland County Sheriff's Department, and the Oakland County Fugitive Apprehension Team descended on this industrial building. The Detroit SWAT team entered the building at midnight and started breaking down doors with a steel ram. They started on the 2nd and 3rd floor. They obtained a key to the door where the defendants were on the 1st floor an hour and a half later. The suggestion that the defendants were asleep and did not hear this is highly improbable.
Thank you, Judge. The only addition I have to that is the court referenced the testimony from the trial judge, and I appreciate that because retired Sergeant Hendrick as well as Lieutenant Willis testified very clearly upon multiple questions. Is a sheriff's office function to trigger the fugitive apprehension team? It is a law enforcement function. It doesn't happen because of a request or demand by the prosecutor's office. It's wholly separate and distinct. That was clear in the testimony. I just want that to be part of it. Thank you, Judge.
Did you want to make a different statement about that?
I did, Your Honor. And it's because I don't believe that Mr. Crumbley was assessed 15 points for OB-19 for the same reason as Mrs. Crumbley was. Mr. Crumbley was assessed 15 points for, it says in the guidelines, the offender used the force or the threat of force against another person or the property of another person to interfere with, attempt to interfere with, or that results in the interference with the administration of justice or the rendering of emergency services. Your Honor, I read that scoring to be scored because of the claims made by Ms. McDonald's office that Mr. Crumbley has made threats and threats of physical harm to Ms. McDonald over the phone at the jail. Your Honor, I'm disputing, and I have disputed, I did it during the trial when this was originally raised, and I've done it since then, that Mr. Crumbley has ever made a physical threat against Prosecutor McDonald. He has vented, he has been angry. He has been angry for the reasons that I cited it in my sentencing memorandum, but he has never threatened to physically harm Ms. McDonald. He has never said that if you continue with this prosecution, I'm going to hurt you. He has never said, if you don't stop this right now, I'm coming after you. Instead, as I indicated in my sentencing memorandum, the statements made by Mr. Crumbley, although there has been some language that may not be very respectful, that may be angry out of frustration for being incarcerated and on lockdown for 23 hours a day for the last 2.5 years, for something that Mr. Crumbley and I maintain that he did not do illegally or wrong. But he vented his frustrations, Your Honor, and he never threatened harm. He never said if Ms. McDonald continues that he's going to do something, or Mr. Keese, or Mr. Williams, or anyone else at the prosecutor's office or law enforcement. So he scores 15 points, presumably based on these claims of threatened physical harm against Ms. McDonald, which we dispute ever happened. Mr. Crumbley and I maintained that OB-19 should be scored at 0. Again, we also dispute that he was ever fleeing, so even if the prosecution wanted to change their theory to the flight, we would dispute that he was even fleeing, although I understand what the court just indicated and what Mr. Keese has indicated previously. So for the purposes of scoring, OB-19 should be scored at 0. There have been no threats of physical harm. There have been no interference with the administration of justice.
There is a thumb drive of the threats. We could play them, or Mr. Keese could read them into the record. I don't know to what extent the prosecution would like to address.
I do. I hope not to, Judge, but I do need to respond to the argument. I'm not going to read all of them. They're on page 4 of our sentencing memorandum. And we did attach them as the court indicated. So I know the court has listened. OB-19 should be scored at 50 points if the offender used force or the threat of force against a person to interfere with or attempt to interfere with the administration of justice. I don't know any other purpose for what James Crumbley did other than to interfere with the administration of justice. He knew specifically that his jail calls were recorded. He knew, or at least he believed, that the elected official, Ms. McDonald, was listening to him because he sent a message specific to her. He did it not just in an abstract sense, Judge. He did it while she was actively prosecuting the case. I have had a number of instances where defendants threatened witnesses Rarely do we see a defendant threatening the prosecutor, let alone a member of a trial team, let alone the elected official. There will be retribution. She's going to be fucking sucking on a fucking hot rock down in hell soon. I am fucking on a rampage, Karen. Yes, Karen McDonald, your ass is going down, and you better be fucking scared. I didn't want to read that, Judge. That was just a few weeks before the trial. I don't know any other definition what that could be other than a specific threat made to a member of the trial team. We ask that this defendant be treated no differently than any other defendant who would make a similar statement to any prosecutor or defense attorney or judge in this building. OB-19 is certainly correctly scored at 15 points.
I believe that it's correctly scored with regard to Mrs. Crumbley and Mr. Crumbley based on their avoiding law enforcement while at the art studio, industrial building, whatever you want to call it, on that evening for a long period of time. But in the alternative, there's alternative theories for scoring OB-19 with regard to Mr. Crumbley. Regardless of his ability to make good on those threats because of his incarceration, I still do believe that those were threats against the prosecutor.
Thank you, Judge.
Your Honor, Mrs. Crumbley has no further objections to the scoring at this time.
Ms. Lehman.
Mr. Crumbley has no additional objections to the scoring, Your Honor.
I have a number of written statements that were provided by various individuals. I'm going to read the names of the people. Could you tell me the pronunciation of Madison Baldwin's mother's name, Nicole Beausoleil?
Yes.
Beausoleil. And the mother of Hannah, Ms. St. Juliana, is it I? St. Juliana, Kristen Baldwin, Raina St. Juliana, Steve St. Juliana, Jill Suave, Molly Darnell, Danielle Krozek, Andrew Muska, Marla Lay, Olivia Upham, Renee Upham, Megan Gregory, Patricia Cunningham, Linda Russo. Those are individuals who provided written statements, and I have copies of those. I wasn't sure who had what statements, so they were scanned by my office and sent to everyone yesterday. I know that there are a number of individuals who want to address the court. I guess I should ask if at any time anybody feels like they need a break, they should tell me. All right? All right, so you have not objected, correct?
Yes.
All right.
correct.
Do you want to do that at this time?
Could we take a break now, Judge?
Yeah,
Before the impact statement.
Yeah, do you need a break? I guess I would ask, you've had time to review the written statements, correct?
Your Honor, we did get them late last night. I'm going to read over them during this brief break again. I have read over them once, but I'm going to read again just to ensure that there are no objections.
Yeah, I didn't have reason to believe that you didn't have copies of them, but they weren't necessarily funneled to the probation department. Some of them were sent directly to us. I've gotten letters from people from across the country that were very interesting. So,
Your Honor, may I say one thing regarding the victim impact statements? The victims are not in the courtroom required to provide their oral statement to us before they deliver it.
Correct.
And some chose to do that.
Correct.
Some chose not to. Based on our prior experience with the shooter sentencing, sometimes they chose to submit it, and it was different when they delivered it. So I just want to make it clear that we, under the Crime Victim Rights Act, nor do I think it's appropriate, have any control or edit or of what they're going to say, because it's their impact statement. So.
Yeah, I understand, and I have gotten some written statements from individuals who I believe intend to make an oral statement as well. So, yeah, that's up to the individual. All right.
Your Honor, with respect to the statements, initially, the defense for Mrs. Crumbley was concerned about the number of statements.
we believe that the court can sort through what to take into consideration for this sentencing, and plus the court has lots of experience doing so. And so we do, if at some point there was an objection in terms of discussion, we don't have an objection at this time.
Yeah, you know what, you guys were on this email yesterday that discussed all of the individuals who would be giving oral statements.
Correct, Your Honor.
Yes.
Correct? And I know we all went back, I think we've all discovered a little glitch in the Crime Victims' Rights Act that it's not specifically clear who's considered a victim under the Crime Victims' Rights Act. There's some difference of opinion maybe, but I'm again relying on Albers that discusses OB3 and gives a broad definition of who a victim is. In any event, I am inclined to hear oral statements from all the individuals that were listed in the email that went to all of you last night. All right?
I have no objection to the individuals on that list, Your Honor.
All right.
Yeah, same here.
And I certainly would appreciate you making any objections to their statements at the end of their statement, right?
Your Honor, I don't know if we need to approach on that, because there was some discussion by email about the objections.
Okay, well...
Or maybe we can handle it during the break, Judge.
All right. When you say making an objection while the individual... I'm going to insist that everyone keep their statements directed at sentencing, for sure. All right?
Your Honor, I don't anticipate, and I don't believe Ms. Smith would anticipate making objections to a victim impact statement. Obviously, things could arise, Your Honor.
Excuse me.
And obviously, we have duties to our clients as well. We wouldn't be doing it in a disrespectful way to anyone, Your Honor. But we would just ask, again, you've already reminded the court, I'm certain that the prosecutor's office has reminded anyone making a statement what the guidelines are in relation to those statements. So I don't anticipate having to make an objection, Your Honor, but obviously, if one arises, an objection would have to be made, Judge.
All right. Do your clients need to go downstairs?
Yes.
Yes, Your Honor.
Just two things briefly. There are no guidelines in the victim impact statement. It's how the victim's impacted. It's personal and unique, Judge.
Sure.
You know, obviously the court knows that. I just wanted to make sure we were clear on that.
But we have to be directed at sentencing, the statements.
And one housekeeping matter, we just need to add in, we can stipulate, with the defense will stipulate, we add in the additional victim impact statements received last night, as well as James Crumbley's GED verification, just for the PSI.
Oh, I didn't ask you if you had any additions to the PSI.
That's all.
Did I? I'm sorry. Okay. His GED, and what else did you say?
His GED verification and the additional victim impact statements that weren't received by the department.
Yeah, I think we got some at about 6 o'clock last night, right?
Right.
So, yeah. If you're not in receipt of something, you should let me know. It was hard to determine at one time who was receiving what. So
If maybe we can discuss with the prosecution who we should have impact statements from and determine whether or not we are missing any impact statements, the written impact statements, because we did receive some later last night. I don't know if...
yeah, we sent those last night.
I received what the court sent and what's in the PSIR.
Correct. That's what I've received as well.
I don't think there's anything else
We received one this morning.
from Mr. Schilling.
Yes, sir.
But I believe Mr. Schilling is going to make an oral statement.
Correct.
Is that correct?
Yes,
So
sir.
I wasn't concerned about that.
Thank you.
I was referring to the written letters received by the court.
Okay.
That's what we got last night, correct, Your Honor? Okay,
Everything in
thank
my possession was sent.
you. Thank you very much for clarifying, Judge.
All right. All right. So both of the defendants are going to go downstairs. So I want everyone to remain seated during that. All right. Thank you.
All rise.
Good morning, you may be seated.
Recording in progress.
Your Honor, calling People v. James Crumbley, case number 22279-989FH. Calling People v. Jennifer Crumbley, case number 22279-990FH.
Thank you. Good morning. Mark Case on behalf of people.
Karen McDonald on behalf of the people.
Good morning, Your Honor. Marielle Lehman on behalf of James Crumbley, who is seated to my right.
And I'm Shannon Smith on behalf of Jennifer Crumbley, who's seated to my right.
Good morning. Now we're going to conduct the oral victim impact statements, correct?
Your Honor, if I could have just a couple of very brief moments. I neglected to make an argument on OB9 earlier. If the court could just allow me to make a very brief record, I would appreciate it.
Okay, go ahead.
Thank you, Your Honor. Very briefly, People v. McGraw 484 Mich 120 is a 2009 case which indicates that the sentencing guidelines and scoring of those guidelines are limited to the sentencing offense. Obviously, we have 4 separate counts in the information in this case.
Mm-hmm.
People v. Vanilla Machado, that's a hyphenated name, 489 Mich 412, is a 2011 case which states that you cannot aggregate offenses for the purposes of scoring. So where they're separate, in that case, it was assaults. They couldn't aggregate the assaults for the purposes of scoring, that each assault had to be scored separately. In this case, the score for offense variable 9 is 100 for the multiple deaths that occurred for the deaths of the 4 students.
Mm-hmm.
I'm objecting to the scoring of 100 under Bonilla Machado because each death is supposed to be counted separately and individually and not aggregated for multiple deaths. And that was the only objection I wanted to make, Your Honor.
Mr. Keese, I'm going to allow you to address that. I think you already did, but
I did, Judge. Yes.
Okay.
And if probation has anything to add to it, for Ms. Wheeler, but
all right.
we've already made this argument.
Ms. Wheeler, anything else?
Judge, only the sentencing guideline manual states that you cannot aggregate victims of separate crimes, but I think the defense argued earlier that this wasn't a separate crime. And the shooting occurred in a span of 8 minutes. It was not one shooting and then a half hour later. It was a very quick procession.
Excuse me, I'm sorry. All right, again, I believe it's correctly scored, but
Thank you for allowing me to make the record,
sure,
Your Honor.
no problem. All right, and then with regard to victim impact statements.
Yes, Judge. Yeah,
Sure. Good morning. I wasn't doing a great job at the French pronunciation of your name, Nicole Beausoleil, correct?
Correct.
Was that right?
Yes.
All right. What do you have to say? All right. What do you have to say?
I would like to start with the person that matters the most. Madison, she was a kind soul. She always had a smile on her face. She lit up the room when she walked in. Her laugh I could listen to all day. It was infectious. Her big sister skills were undeniable, and she took that role very seriously. Madison was smart, funny, loving, passionate, determined, and genuine. Her expectations were high, and at times we needed to let her fall. She needed to be reminded that not everything is perfect, even if she wanted it to be. Madison had an influence that most never achieved. Sometimes I would listen to a poem she wrote or watched her create art with no tracing, just pure talent. She would talk about college and what majors she would like to do and what would be most helpful to society. The passion that she had for everything and everyone was remarkable. I would catch myself watching her and thinking to myself, how lucky am I? I'm the one that gets to be her mom. What did I do to deserve a perfect person? She will be the best thing to ever happen to me at such a young age myself. I grew up because of her. We grew together. I learned from her. I mattered because of her. From the moment she was born, I promised myself that I would be there no matter what. Through the falls, heartbreak, letdowns, and struggles, I would be there. I would listen, learn, and love every moment. I wouldn't miss a thing. I would always protect her. On November 30th, 2021, exactly 17 years, 6 months, and 13 days made me break my first promise, and it will hurt for eternity. As her mom, I didn't protect her. First, I'd like to say thank you to the prosecution team. I say thank you to you all. Saying thank you really doesn't seem enough anymore. The countless hours you've worked, the time away from your family, and always taking our feelings into consideration. Karen and Mark, the work you've put into getting all the facts, speaking to us like we matter, and never wavering from your goal. It speaks volumes of the people you are, and I'm proud to call you a part of Madison's voice. Advocates and Jen, I'm not sure where to start. You've all seen me hit points in this tragedy that some days I wasn't sure who I was. One minute I'm laughing, next I'm crying, and sometimes I'm just silent. Either way, one thing stayed consistent. You always listened. Jen, you're not just a friend, you are family. My mind keeps going back to something during the trials. Something that is almost on repeat like a broken record. It's something as a mother I can't understand, and honestly, I don't think any mother would understand. It was when Jennifer said, I wouldn't do anything different. I'm putting a little emphasis on different, as I know life throws us things that are out of our control. But life takes turns and eventually puts them back in our control. Like giving you a hint when something needs to change. I want to compare a few things to see through my perspective. As I know things are different about the events and how we see them from the events on November 30th. While your son was hearing voices and asking for help, I was helping Madison pick out her senior classes. While you were purchasing a gun for your son and leaving it unlocked, I was helping her finish her college essays. While you dropped him off at school, upset that he was failing class, I texted Madison, drive safe, it's slick outside, have a good day. When you got a call to me at the school about your son and how it interfered with your day, I was rearranging my schedule so I could take Madison to get her oil changed for the first time. When you left without hesitation and not taking him home, I was worried if she'd be okay driving in the first snowfall of the season and if she brought a coat. When you walked out of the office with a steady pace after hearing an active shooter, I ran from my home and started driving, trying not to break the law. When you were on the phone for 10 minutes with each other trying to figure out where the gun was, I was on the phone with her father and family trying to figure out where she was. When you left the Myers without knowing where your son was, I was desperately trying to get there as soon as possible. When you knew the gun was missing, you called the police, knowing it was your son who took it. I was having family call every hospital describing what she looked like. When you texted, Ethan, don't do it, I was texting Madison, I love you, please call Mom. When you found out about the lives your son took that day, I was still waiting for my daughter in a parking lot. When you questioned the reasoning on why you would do this, I was questioning if I was doing enough to find her. When you got a chance to speak with your son, seeing him alive and showing no support, I was watching families reunite with their children, waiting for my moment. When you asked him why, I was waiting for the answer onto why the last bus never came. When the police showed up at your house, you didn't understand why they were there. And I was asking police if they checked every possible location and if I could go search too. When you texted about not losing your job and you needed a lawyer, I was still calling my daughter because she came first in all parts of my life. When you could leave your house, I was still a prisoner in Myers. When you worried about what people thought of you and feeling threatened, I was learning your son threatened my daughter and fatally shot her in the head. When you drove to get your burner phones for communication, I was laying on the floor in Myers for hours crying because I forgot how to speak. When you checked into your first hotel, I was telling Madison's 11-year-old sister she was gone. When you cared more about yourself and getting alcohol and supplies, I was identifying my daughter in a medical office wishing I could take her place. While you were hiding, I was planning her funeral. And while you were running away from your son and your responsibilities, I was forced to do the worst possible thing a parent could do. I was forced to say goodbye to my Madison. We all see things different. Some prioritize and some don't. Accountability can only be given if you actually try it in the first place. As a parent, we all make mistakes. This is a normal way of life. Usually when mistakes happen, we learn from them. We try to fix it or talk it over. But continuing to make the same mistake over and over again is no longer a mistake, it's a choice. That becomes a decision. Those decisions that you made ultimately took my daughter's life. Because you decided that you didn't want to parent and listen to your son. You took the right away for me to be a mother. You do not get to decide that. You do not get those privileges. You are not above anyone. I love being a mom. It's the one thing that I'm truly great at. You cared more about your well-being than the one life that you should put above anyone, your child. And because of that, you both took 4 beautiful children away from this world. Being a parent is the part of life that you should hold to the highest level. It's an honor to be a mother or a father. Even when you think you have done your best, you continue to do more. Unfortunately, you never made it to level 1. You say you wouldn't do anything different. Well, that really says on what type of parents you are, because there's a lot of things I would do different. But the one thing I would have wanted to be different was to take that bullet that day so she could continue to live the life she deserved. You show no remorse, no respect or compassion for our family. The same traits that you've bestowed upon your son. The traits that you have torn my family into pieces. The lack of compassion that you have shown is outright disgusting. Not only did your son kill my daughter, but you both did as well. The words involuntary should not be a part of your offense. Everything you did that day, months prior, and days after were voluntary acts of your son to commit a murder. Not just one, but multiple. Shaking your head during a verdict is the utmost disrespectful thing I have ever witnessed. At that moment, you felt your life is more valuable than my daughter's. I will say that will never be true. You created a life that you took for granted. You decided that parenting wasn't a priority. Putting your child first should be the only priority. You didn't, and because of that, I've lost my daughter. I had to get answers after her death. Watching the video, hearing testimony on how your son executed my daughter, watching him put the gun to her head as she covered her head and pulled the trigger. Seeing pictures of her laying in her own pool of blood, knowing her body sat there for hours, that rigor mortis had already started to set in. So that when I identified her, her body was in a state I couldn't imagine. Hearing her sister scream over and over again night after night, watching her family and her friends fall apart. You created all of this. You created your son's life, which then allowed this to be his path, which should be yours as well. You don't get to look away. You don't get to cry. I didn't get that choice. You failed as parents. The punishment that you face will never be enough. It will never bring her back. It will never be a loss that you have suffered, and it will never heal the pain. Because one day you're going to be able to see your son, visit, hear his voice, possibly laugh, maybe see him grow. I will never see that again. The so-called loss that you say you have suffered doesn't even compare to the loss of a child. Your Honor, I request that the maximum sentence be enforced, as it will never come close to the life sentence I was given. A life sentence that I didn't ask for, but a choice that was made for me. A life that I will suffer because of their negligence. Thank you.
Thank you for being here. Good morning. Can you tell me your name?
Yes, Jill Suave.
All right, go ahead.
Yes. Thank you, Honorable Judge Cheryl Matthews, for your time on this case. I know it hasn't been easy on both. Thank you also to Karen McDonald and the entire prosecution team. We appreciate your efforts. Your Honor, my trauma and devastation is hard to put to words, but I have done so in my letter to you. I would also like to mention Justin's brothers, Nathan and Clay. They are now forced to live a life without their beloved middle brother, Justin. My son Justin was the least deserving of his fate. He was the best son that any mother could pray for. Justin was brave, spending his final moments protecting a fellow student. He was hardworking, a lettered athlete, a top honor student. He was kind and inclusive to all. He was full of love and joy. His future was so very bright and full of possibilities. His passing has touched so many family members, friends, students, and the community in general. The ripple effects of both James and Jennifer's failures to act have devastated us all. This tragedy was completely preventable. If only they had done something, Your Honor, anything, to shift the course of events on November 30th, then our four angels would be here today, and Justin would be getting ready to celebrate his 20th birthday on the 18th of this month. If only, Your Honor, they had taken their son to get counseling instead of buying him a gun. If only they had secured that gun. If only they had spoken up that day in the counseling office. If only they had checked his backpack. If only they had taken him home or taking him to counseling instead of abandoning him at that school, I wouldn't be standing here today. Your Honor, I don't know what's in their hearts. I'm not a mind reader. But I only know the facts of this case. And the facts of this case, both cases, have been deeply disturbing. What I would like to share with the shooter's parents is an example of what love looks like between a mother and her son. This is what Justin wrote to me on one of the last birthdays that we celebrated together. Dear Mom, Words cannot describe how thankful I am for you. You have been nothing but an amazing mother for as long as I can remember. Thank you for being a role model. Thank you for showing me what it's like to never give up. You inspire me to do better each and every day. I love you so much. Love, Justin. It is devastating and heartbreaking that it doesn't appear that either of you cherished or even wanted your son. But I wholeheartedly wanted and cherished mine. You have failed your son and you have failed us all. This failure had deadly consequences that can never be undone, that can never be made right. I am asking, Your Honor, for the maximum sentence allowed. Thank you.
Thank you for being here.
Thank you.
Mr. Schindler.
Good morning, Craig Schilling, Justin's dad. So Honorable Judge Matthews, for the second time in 6 months, I find myself standing in front of a packed courtroom, a victim. This time, I'm here to address a different judge and the parents of the deeply disturbed teenager that murdered my son. This is my opportunity to try to describe just how much the horrific event that took place back on November 30th, 2021 has impacted my life. It's my belief that an impact statement should not just describe how this particular event impacted me. I feel that it should also be impactful towards all who hear it. And in your case, Judge, I hope these words impact you in a way that influence your decisions here today. As I look around at all the lawyers, police officers, media folks, and the other victims, I can't help but ask myself, what could I possibly say that this whole scenario doesn't already say? This is messed up. Most people will never have to make a victim impact statement throughout the course of their lives. And the fact that the victims speaking here today are doing so for the second time in 6 months should speak volumes in and of itself. This is not normal. Living a life like this is not normal. So how does it affect a normal guy? To be completely honest with you, it remains a rather difficult and uncomfortable question to answer. In my previous impact statement, I've expressed many of my day-to-day struggles, from uncontrolled emotional outbreaks to sleepless nights to not being able to focus on the normal daily tasks. Yeah, it's fair to say that I live every day with pain, anger, heartache, regret, anxiety, stress, you name it. They are all there, wreaking havoc in my once normal life. They say that time heals all wounds. Well, we're coming up on 2.5 years now, and I can assure you that the wounds are still as fresh as they were on that tragic day. And with this hole that has been left in my life still glaringly obvious, I fight every day to not lose more of myself within that very hole. I have spent the last 30 years of my life busting my butt to support a family, raise children, and try to set myself up for some peace and quiet in the golden years of life. But the unthinkable has happened. And that peace and quiet I've worked so hard for may never come to be. At least not to the degree that I've always imagined it. Literally every single aspect of my life has been affected by this tragedy. And I could spend a long time describing in detail just how it has impacted me, but it seems like it would be way easier for me to just tell you how this tragedy hasn't impacted me, because there's simply nothing on that list. Now that the verdict is out on this monumental case, I feel strongly that it has caught the attention of most parents across the country. The overwhelming facts in this case were all that was necessary to prove that James and Jennifer Crumbley not only neglected their son by failing to get the necessary mental care that was clearly needed, but also provided him the very tools necessary to carry out those heinous acts of violence. It was these very facts that allowed not just one, but 2 full juries to find both of them guilty of involuntary manslaughter. I will always maintain the opinion that the facts that were presented in these cases were strong enough to convince any jury of their guilt, and that the verdict would have been the same regardless of where the trial was held. As I have maintained throughout the course of the past couple years, being the parent of a murdered child tends to cause you to seek out the maximum penalties allowed for each guilty verdict derived from any of the criminal charges. I think this stance is completely justified, and would be so for any parent in the same position as mine. However, this is a court of law where a person is innocent until proven guilty, and the defendant has the right to dispute the facts of the charges against them. That being said, during the course of both of these trials, I did my best to capture every word and process all the facts. This is important because there is value in these facts, not just in the thousands and thousands of man-hours invested in gathering, processing, and organizing the evidence, but also for being able to use that evidence to establish the cold, hard truth of this tragic situation, that James and Jennifer Crumbley failed in their parental responsibilities as they pertain to the shooter, who was their son. The cold truth that shows that they did nothing to address the obvious signs of the deteriorating mental state of mind clearly present within their son. And of course, the very hard truth that shows that they provided their son with exactly what he wanted to use to do what he did, and failed miserably to secure it properly. One would probably think that in order for something like this, or something of this magnitude to even happen at all, there would have to be a ton of things that went wrong. Although there were some things that definitely went wrong that day, for several of those things, I believe that if they had been handled correctly, we wouldn't be here right now. And James and Jennifer Crumbley carried the bulk of the responsibility needed to handle those things. During their trials, the overall similarities between the two were evident, and I believe this is why they were both convicted. Numerous facts that were the same for both trials showed clearly that the parents failed their son, and ultimately the entire community. With Jennifer, the thing that resonates most is that she stated that even knowing what she knew now, she still wouldn't have changed a thing. I almost died when she said that. 4 precious lives were lost at the hands of her son, by means that she helped provide. She saw the drawing of murder, drawn with the hands of her son. She sat and heard the request of the counselor and did nothing. And she still says that she wouldn't have changed a thing. I just don't understand how someone can be that heartless to make a statement like that. The blood of our children is on your hands too. This is but one reason why I feel that Jennifer should receive the maximum amount for her sentence. The facts presented should be all the others that you should need. With her distinct lack of remorse and overall unethical understanding of the tragedy, I feel that the maximum amount of time available is needed for her to be able to fully comprehend the gravity of her actions and the lack thereof. With James, there were a couple of things that jumped out at me in particular, but one thing that is the toughest to digest is the fact that when the verdict was being read, he sat there and shook his head in total disagreement, as if to suggest that the jury was wrong and that there were no grounds for a guilty verdict. I was dumbfounded to see him shake his head with such disbelief, an action that only suggests that he truly believes he did nothing wrong. How could you possibly think that? 4 precious lives were lost at the hands of your son by means that he helped provide. He saw the drawing of the murder, drawn with the hands of his son. He sat and heard the request of the counselor and did nothing. I just don't understand how someone can so arrogantly dawdle in a pool of self-pity without being able to say one thing to justify themselves. The blood of our children is on your hands too. This is but one reason why I feel James should receive the maximum amount for his sentence. The facts presented should be all the others that you need. With this distinct lack of remorse and overall unethical understanding of the tragedy, I feel that the maximum amount of time available is needed for him to be able to fully comprehend the gravity of his actions and the lack thereof. Throughout the course of all of this, and I'm talking from way back in the beginning, I just can't get over the fact that this tragedy was completely avoidable. There were some pretty obvious signs that were completely overlooked, and the bulk of the responsibilities to address those signs lied on the parents, and they failed. Across the board, failed. They willfully ignored the cries of their child and selfishly put themselves before helping him. This type of blatant disregard is undeniably unacceptable. It is a large reason why the events of that day were able or were allowed to happen, and another reason why I feel they both need the maximum amount of time available to be able to fully comprehend the gravity of their actions and the lack thereof. We all know that having children is a big responsibility. Although extremely rewarding, it starts out pretty scary. I mean, let's face it, they don't exactly come with instructions. There's no mute button, and unfortunately, no pause or rewind buttons either. Oh yeah, and there are times in the beginning that they really snap. Yet we still have them. We still want that responsibility, even though it's not very clear what it all entails. But how can we accept that responsibility and not act responsibly towards that child? It doesn't add up. A child, even if he is an oopsie child, deserves the same amount of love, compassion, and care that every other child gets. A child deserves someone who is confident enough to lead by example. Because let's face it, it wasn't that child's choice to come into this world. You made them, and it's your responsibility to teach them how to live. It's your responsibility to set a good example. It's plain and simple, just like that, ladies and gentlemen. And the sooner we can figure that out, the better we all will be. Being a parent is hard work, but if it's done correctly, it can be the most rewarding work you ever do. There is no one that can tell you how to do it, because each child is so precious and unique. I mean, there's no other one like them in the entire world, and that says a lot. So cherish your one and onlys, and never give them up. Never give up on them. The results of doing so can be catastrophic and can affect the lives of so many other people. So I ask for you all to go home today and hug your kids and make sure they know you are there for them and make sure that they are all right. It's so crucial for the whole of our society. Thank you.
Thank you, Mr. Schilling. Raina, right?
Yeah.
Raina St. Julian.
Our 10-year-old little brother had to learn how to write a eulogy for his sister before he even learned how to write essays. November 30th, 2021, all our parents did was send us off to school. Yet the next time they see Hannah is to recognize her lifeless body in a medical examiner's office. I met up with Hannah and a friend during school that day. When we split ways to go back to class, I just looked back and smiled. I didn't say goodbye. I never got to say goodbye. I never got to remind her that I love her, that she's my everything, the person I want to walk through life with side by side. I thought our future was a given. Of course, she'd play her first high school basketball game that night, get ready for all the other school dances, have her JV and varsity season for all the sports she played, get her driver's license, play her lacrosse season, have her first date, prom, graduation. She never got a chance for any of that. She didn't even get her 15th, 16th, 17th, or 18th birthday. These are only some of the high school experiences she never got to have, but it is absolutely nothing compared to the rest of everything she had going for her future. That list is eternal. Hannah's life had only started to begin. 12:51 p.m., November 30th, 2021, that was the moment I became aware of the fragility of our mortality. Hannah, who was healthy, Hannah, who was only 14, shot 4 times. 12.5% of the bullets shot that day were at her. She took her last breath in her own pool of blood in a school she hadn't even been in for 3 months. Alone for 7 minutes while police passed by her, bleeding out as a security guard failed to put a tourniquet on her, dying as EMS took more than 10 minutes after the shooter had been detained to even give aid to her. Our Japanese grandma would often worry about anything bad happening to us because she knew how dangerous it is here compared to Japan. She told me on FaceTime that Hannah would respond with a laugh, saying, "Don't worry, I'm a fast runner, I'll outrun them." It wasn't possible for Hannah to outrun the bullets spot by you, Jennifer Crumbley, which were fired by the 9mm Sig Sauer that you, James, gifted to your son. Both used to murder Hannah, Justin, Tate, and Madison. The fact is, no matter what you try to make yourself believe, Jennifer, you did fail as a parent, both of you. To love and to be loved, that is the human experience. It was up to you guys to show your son that. Instead of giving quality time and compassion, you gift your son a gun you knew caused extraordinary damage. There's a reason your kid didn't use the other 2 firearms or the .22 ammunition you own. I believe your actions cannot even be confined into the word failure. Your mistakes created our everlasting nightmare. So yes, you are still a danger to society because even after serving 2 years, you have yet to admit to your wrongdoings. And we know that when we do not learn from our mistakes, we repeat history. You call yourself a victim. The difference between you and Hannah, Justin, Tate, and Madison, you and my family, you and all the students there that day, is that we didn't have a hand in causing this. You caused the most cruel thing I could ever imagine. You guys made loving Hannah so painful. That is not a narrative, that is reality. For that, unless you have a time machine or the ability to stop time, there is no existing punishment or rehabilitation that will ever be enough. Because there is no way that the one life I have, I now have to live without Hannah, my little sister, my best friend, my other half. To me, that makes the maximum sentence being 15 years too short. Hannah didn't even have 15 years to live. Jennifer, you stated that even after knowing everything you know now, you wouldn't do anything different. I cannot fathom that. I would do anything to hear her footsteps coming up the stairs. You don't have to roll your eyes, it's on video that she said that. To not have an empty seat at the dining table, to have her come into my room and ask which clothes to order, to see her napping on the couch, to laugh and share a look when we accidentally say the same thing at the same time. There's not a day that goes by that I wish I hadn't run out of that building. If I knew what I know now, I would do everything differently in a heartbeat. I hope time makes you think differently. One day, I hope you would have chosen to care for your son, teach him how to love and to be loved, that you would not choose to buy the bullets that enter children's bodies, that you would not choose to omit relevant important information to the counselor Sean Hopkins and Dean of Students Nicholas Ejak that could have helped their incompetent brains in one shared brain cell to decide to act and search the backpack, that you wouldn't still choose to hide from accountability when you're the reason we had to hide for our lives, that you would choose to save Hannah, Justin, Tate, and Madison. Like my mother said, both of you should implore that even on your worst days, it's the tomorrow Hannah doesn't get. The tomorrow she wanted to live so badly, the tomorrow that she should have. I can never do Hannah justice when talking about her. She's all I want to talk about, and yet I would need a lifetime and still wouldn't have the right words to capture incandescence, humor, thoughtfulness, kindness, or loyalty. She's always there for you, helping without a second thought. She's always sharing, whether it's her smile, her food, her clothes, her crafts, her joy. She's funny. It's a given. She brings people together. Whether it's her contagious laughter or sarcastic wit, you will be laughing right along with her. She's noticing the small things, new shoes, new haircut, cute jewelry, but even more importantly, she makes you feel seen. She's extremely spirited. Her energy is unmatched on or off the court. She dresses up every holiday, every spirit day, the first one to put up Christmas lights, or any lights for that matter, not even realizing she was a light for so many others. She's the one who would not only playfully roll her eyes and smile when I would say I'm taller than her as I look up to her. Not only did I look up to her physically, because yes, she was taller, but as a whole, as a human being. She isn't perfect, but she's Hannah, and to me, that's as close as you can get. I can't convey what losing Hannah has done to me. I miss her with every breath I take. I think going forward without her is something I'll never be able to fully navigate. I believe the word sad is inappropriate to use because it does nothing to capture the hurt or the way my soul shattered. I didn't know. I've never felt every atom of my body igniting from anger until Hannah was murdered. I didn't know what it was like to want to stop waking up in the morning until she wasn't here. I have never known pain that is forever until seeing Hannah in a casket. I didn't know it was possible to feel so isolated even when you're surrounded by people. I didn't know how it feels to not know yourself at all. I have no idea who I am without Hannah. She's my happy, she's my home. I look for Hannah in everyone I meet, every place I go, and it's exhausting when I'm met with disappointment every time. But it's the world, it's all the people she would have met. I grieve for them too. To have that chance of Hannah being in your life taken away from you is a tragedy in and of itself. She's more of a person than you two combined times a trillion could ever even hope to be. But when the day comes that you re-enter society in 13 years, I hope you live more like Hannah. I hope you live every moment to the fullest like Hannah. I hope you laugh every day like Hannah. And I hope you love unconditionally like Hannah. That's it.
Thank you, Ray. Mr. St. Julian.
Thank you. I find myself in a rather odd state of mind today. Rather emotionally blank right now. Part of that is having to do this again. Part of that is I'm mostly a private person, and the idea of having to pour my heart out again is irritating. And I can't match the eloquent words that have come before me in the previous impact statements. So I'll limit my words today. The defendants, through their choices, through their indifference and gross negligence, enabled their son to murder my daughter Hannah and 3 other children. They chose to stay quiet. They chose to ignore the warning signs. And now, as we've heard through all of the objections, they continue to choose to blame everyone but themselves. Every single objection, I think, that the council said this morning put the blame somewhere else, their son, not them. I stood before the court several months ago and spoke about the impact that Hannah's murder had on myself and my family. Nothing has changed since then. It's impossible for me to truly convey the complete impact of my daughter's loss. Hannah's murder has destroyed a large portion of my very soul. I've said these words before. It's still the truth. I remain a shell of the person that I used to be. I think of her and miss her constantly. Every day is a battle to attempt to move forward, struggle to get out of bed, to go through the motions of everyday life. Simple everyday sights and actions bring pain, as I think what it should have been like with Hannah there with us. I think of all the good times that we've shared together as a family, and more on all of the memories that will never be. I will never think back fondly on her high school and college graduations. I will never walk her down the aisle as she begins the journey of starting her own family. I am forever denied the chance to hold her or her future children in my arms. A few words describing Hannah can in no way fully capture her truly beautiful, caring soul or impart her unlimited potential. Hannah was absolutely beautiful and thoughtful person. She was always the first person to notice when someone had a problem and the first to go out of her way to offer help. She was incredibly curious and talented. She continually tried new things. She crafted homemade jewelry, tried cooking her own recipes, and played several sports. She was a record holder in track and a leader of her school volleyball and basketball teams. She also hoped to join her older sister on the lacrosse team in the spring. She had aspirations of a career dedicated to helping people. All of this is lost because of the defendant's actions and choices. My position regarding the defendant's sentencing and their future has evolved through their trials. At first, I was focused on the importance of getting a guilty verdict, to have the message conveyed to the public that this type of behavior and choices are not acceptable. I didn't have strong feelings about their sentencing. It was just something that would be determined by the system. My view, however, has changed as the defendant's level of defiance has grown. Instead of acknowledging any mistakes, they continue to show no remorse. They take no accountability. They and their lawyers continue to try to change the narrative and portray the defendants as victims of the prosecution team. They blame everyone but themselves and make threats of retribution. The facts have already been presented. The jury has found them guilty. Multiple juries have found them guilty. Hannah, Madison, Tate, and Justin are the ones who have lost everything, not the defendants. As such, I ask that this court to sentence the defendants to the maximum allowable penalty of 10 to 15 years in prison. Thank you.
Thank you, Mr. Secretary. Thank you for being here. Mr. Meir.
Tate Meir's dad. First of all, Mark, Karen, the whole team, strong work. Everybody said you couldn't do it, and you did it. For our family, it's not time to celebrate. This tragedy has taken an incredible toll on our family. So our family's not going to give the Crumbley family a second of our time up here. It's time to turn our focus now. This is the low-hanging fruit. Now it's time to turn our focus to Oxford schools who played a role in this tragedy. You know, I hear this morning when we're listening to all the objections, you can hear Sharon talking about protecting the criminals' civil rights, constitutional rights. Where's my rights being protected? I fight for everybody in this room. My rights aren't being protected. Criminals' rights are more important than our rights, my rights. we are ready for our government to perform an investigation on this tragedy. Many don't know that our government has not investigated this murder. A pre-shooting investigation, a day of the shooting investigation, and a deep dive investigation into the horrible response to this tragedy, the disrespect shown to us families, the simple things like trauma training for somebody like a Sheriff Bouchard, who we got to talk to on the day that we got to go identify Tate. And he referred to Tate as a girl because he was too busy that night working to cover it up, instead of learning about every kid, Tate, Hannah, Justin, and Madison. It's time for the whole truth to come out. It's time to learn from this, from the purchase of the gun to the response. That's when real change happens, is when we can look at something and we can evaluate it, apply lessons learned. That's when real change happens. Is Hannah St. Juliana's family ready for the truth? Justin Shelley's family ready to hear the truth? Nicole Baldwin's family ready to hear the truth? Tate Mears' family's ready to hear the truth. Quit denying us that. It's time to drive real change from this tragedy.
Thank you, Mr. Mayor.
That concludes the victim impact statements.
There's no one else. You're not presenting anybody else.
Correct.
Ms. Smith, what would you like to say on behalf of the client?
Your Honor, my client would also like to make a statement. Would you like me to?
Of course.
Okay.
Of course. You may both allocute, for
Thank
sure.
you. I didn't know which order you wanted to go.
Either way, either one first. It's up to you. You or your client.
Would you like to go first, or would you like me to go first? I can go first. Okay. Do I stay here?
You can stay there.
Your Honor, is there any way she can have this handcuff off? Because she has multiple pages.
I'm okay, but I'm right here, I don't have to shuffle.
You're okay? Okay.
I don't know if I'm allowed to.
Okay.
It's okay.
She said she's okay.
It's okay.
Go ahead, Ms. Crumbley.
I sit here today to express my deepest sorrow for the families of Hannah, Tate, Madison, Justin, and to all those affected on November 30th, 2021. The driving weight this has taken on my heart and soul cannot be expressed into words. Just as I know there is nothing I can say that's going to ease the pain and suffering of the victims and their families. There's a quote I heard that rang true. Grief. For those of you who understand, no explanation is needed. And for those of us who do not, no description is possible. I've taken countless nights of lament over the anguish and shame I carry, knowing what my son did, the harm he caused innocent lives, the families, and to the entire Oxford community. I pray all the victims are the embodiment of God's mercy and peace, and that He heals your broken spirits. When I was on the stand, I was asked if I would have done anything different. I was horrified to learn my answer I would not have was completely misunderstood. That answer is true because my son did seem so normal. I didn't have a reason to do anything different. This was not something I foresaw. That was the intention of my answer and how I interpreted the question. With the benefit of hindsight and the information I have now, my answer would be drastically different. If I even thought my son could be capable of crimes like these, things would have absolutely been different. Even worse, when I learned during the police investigation that he had been planning a school shooting before November 30th. He was not the son I woke up. He was not the son I knew when I woke up on November 30th. The Ethan I knew was a good, quiet kid. He loved his pets, family vacations. My husband and I used to say we had the perfect kid. I truly believed that, and that's who I saw and thought I knew. As the details started emerging during discovery, I was horrified to learn concerning behaviors my son was reported doing at school. Refusing to take a makeup test he told us he took. Sleeping in class. Drawing pictures of guns on his assignments. Writing, quote, "My family is a mistake." Watching a video in class of a mass shooting that fatal day, along with internal communications that took place between his teachers and counselor, Mr. Hopkins. That he is, quote, "on my radar," and, quote, "he seems to be having a rough time," was never disclosed to us, his parents. The school claimed this was not abnormal behavior because of the pandemic and Oxford being a, quote, "gun community." To say I was furious to learn this information is an understatement. This is not normal behavior to us and very different than what Ethan led us to believe was happening at school. Not only were you left in the dark about previous concerning behavior, but in the counselor's office that morning, none of those previous issues were brought to our attention. I can't stop thinking, had they been, the conversation that morning would have been much different. That we would have taken a deep dive into what's really been going on with my son. I wonder if Hopkins and EJAC have those same regrets too. Instead, we are led to believe, not only from Hopkins and EJAC, but from Ethan as well, that this was an isolated event. We felt confident in trusting the professional's advice to let him stay in school that day. Quote, he does not pose a threat to himself or others. It was suggested that him being around peers would probably be good. We agreed. We were never asked to take him home that day. If that was discussed as the best course of action, we would have obliged. The prosecution keeps saying we didn't give them the big picture that morning in the counselor's office. But what they failed to acknowledge is the bigger picture the school did not give us. I'm not the same person I was prior to November 30th, 2021. This tragedy has changed who I am and has taught me some very valuable lessons. It's said in suffering we gain wisdom. I've also gained God. In the quiet hours of myself, I prayed to Him about the deep impact this tragedy has had on the families and the endless pain no one should ever have to feel. For it is God who holds a true understanding of our pain. I've also learned to depend on Him for peace and strength. Alone, I'm not strong enough. I've learned that we cannot tell or predict what will happen to us in this life. One day you wake up and everything can change. We can, however, decide what happens in us, how we take it, what we do with it. And that's what really matters in the end. That's the test of living, is how we take the unimaginable, the tragedies, the raw hardships, and make them a thing of worth and beauty. I've also learned to never think this could not happen to you, and stereotype that bad kids come from bad parents. The prosecution has tried to mold us into the type of parents society wants to believe are so horrible, only a school or mass shooter could be bred from. This is a very trivial assumption to have. We were good parents. We were the average family. We weren't perfect, but we loved our son and each other tremendously. Everything we strived for was to make sure our son had the best life we could give him, to grow up with traditions and experiences we had, to be the best person he could be. I know we did our best. The love I have for our son, mixed with regret for not seeing what was ahead, weighs heavily on me. My point is, this could be any parent up here in my shoes. Ethan could be your child, could be your grandchild, your niece, your nephew, your brother, your sister. Your child can make a fatal decision, not just with the gun, but a knife, a vehicle, intentionally or unintentionally. If there's anything the general public can take away from this, is that this could happen to you too. The tragedy has taught me the true meaning of unconditional love as I watch my parents still love and care for me wholeheartedly, no matter what has happened. If there's nothing else I can do right in life, I do still love my son unconditionally, and perhaps that is my purpose. Your Honor, I don't envy the decision you have to make today. I understand this is a novel case, and punishment expectations are high, not just from the prosecution, but from all those affected as well. The heartbreaking journey these families have endured. Hang on, I have to back up. I missed my most important. I need to cross. The most valuable piece of wisdom I gained is the power of forgiveness. To forgive the prosecution for the slander and hate against me and my husband. Ms. McDonald, Mr. Keys, I have hated you with deep anger, but hate is too heavy of a cross to carry. I need to be set free of that burden and recognize that you are people just like me, imperfect, but a child of God. I know He wants good things to happen to you, and in any conflict, whatever the circumstances, He is there loving both sides. To the victims and the families, I stand today not to ask for your forgiveness, as I know it may be beyond reach, but to express my sincerest apologies for the pain that has been caused. Your Honor, I don't envy you in the decision you have to make today. I understand the punishment expectations are high from all sides. This heartbreaking journey the families have endured is more than anyone should have to bear and acknowledge in its full depth. My time in confinement has been filled with deep remorse, regret, and grief over this tragedy. I have taken this one day at a time, trying to survive, navigate, and cope with the endless heartache, pain, and grief I feel for the families of Hannah, Justin, Madison, and Tate. I have also lost myself over my son's wrongdoing. I've been shredded by the public opinion of me, shamed as a horrible parent, pained to be a terrible person. But the worst hell I carry is my own self-judgment, remorse, and deep regret. I've been criticized I don't show emotion, I'm unsympathetic, I don't cry enough. But alone I grieve. And if you were to look into me internally, you'd find I've died on the inside. I will be in my own internal prison for the rest of my life. Your Honor, I ask you to take consideration that I have been locked in a cell 23 hours a day, essentially in solitary confinement, for over 28 months, and that the court finds a fair and just sentence for me.
Thank you.
Yes, Your Honor, thank you. Your Honor, as I pointed out in my sentencing memo, this was a no-win case. When we walked in the door, there are no winners here. Every single person goes home and here.
Agreed.
And there's also no limit on the amount of sadness, grief, and horrific emotions that are felt across the board in this case. And when Mrs. Crumbley does express remorse, when she expresses sadness, there's a tendency, and there has been a tendency, for people to say she's shifting from sadness to the victims and putting it on herself. She's not doing that. There's an abundance of sadness. There's enough sadness to go around for all of the victims, for Mrs. Crumbley, for everyone involved in this case. It's not surprising that the victims have come in and obviously want the maximum sentence. There has been a narrative throughout this case that they believe is true. And this court knows that there is other information that was not a part of this case. And I believe this court knows the defense was hugely hamstrung, and I think the court was pained at times over what to do.
I guess I'm not sure what you mean.
I'm talking about not being able to call the medical professionals, not being able to call the shooter to the stand, not being able to cross-examine on various pieces of evidence.
I'm not convinced the shooter would have helped you.
Okay, well, all of those are obviously issues, but there were things that hamstrung the defense. And I do believe
the forensic records?
I do believe the shooter would have helped, and I do believe the forensic records would have helped. And I understand the court has already ruled on that. I understand that. The tendency, though, after hearing the narrative that has been made public, has been to make Jennifer Crumbley sound like a monster, to vilify her, to make her sound like a horrible mother, an evil person. And the truth is, it's an effort to put her in a category of other, to say this is not something that could happen to any of us. And it is. It is something that could happen to any of us. And people fail to realize what the sentencing memo shows the court through numerous letters of support, that Mrs. Crumbley does have a kind heart. She does have compassion. She has spent night after night crying, not for only herself and her son, but also for the victims and for what her son did and what she will live with, knowing he did, and what she missed all the years forward. At the end of the day, we ask the court to look at Mrs. Crumbley's role in the offenses. We ask the court to consider that while she did not oppose having a gun in the home, she was not the person who was responsible for storing the gun and believed it was being stored properly and that it was locked. Mrs. Crumbley obviously testified, and all of the evidence at trial showed she believed there was a string lock, a cable lock placed on the gun, on the weapon.
You know, I don't mean to interrupt you, but that has really troubled me from your sentencing memo, because you spent a lot of time talking about the fact that she didn't know anything about the gun. She didn't lock it, she wasn't responsible for it. But at one time, she was texting her husband to see whether or not he got the gun and how much it was. She posted pictures of it as her son's Christmas present. She shot the gun. And I don't know if you're aware of this, I don't know if either side was aware of this, but the first jury determined that there was a claim that the gun was the responsibility solely of defendant James Crumbley. And Mrs. Crumbley testified that when she returned from the range with the shooter on November 27, it was the defendant James Crumbley who was responsible for the 6-hour retrieve from the car and was supposed to keep it safe. The first jury recognized that the GPS admitted in the case shows that even prior to the defendant James Crumbley returning to the house, the shooter was videotaping the unlocked 6-hour in the kitchen of the home. So that's not true. That's not true. She also testified that a key to the cable lock was kept in a beer stein in the kitchen, but it's clear that the cable lock was clearly never opened.
Your Honor, first of all, the jury's finding about the timing of the GPS and when the gun video was made is not correct. The evidence at trial did not support that. We know that's not correct. Mrs. Crumbley left the gun in the car so that James Crumbley could put the gun in the house and store it correctly. Mrs. Crumbley, there were multiple cable locks in that house because there was more than one cable lock. There was not just the cable lock that was on the Sig Sauer. There was more than one.
I didn't recall that.
There were not more than one found, but whatever Ethan Crumbley did with the cable lock from the Sig Sauer, we don't know.
The gun wasn't locked.
Your Honor, factually, during Mrs. Crumbley's trial, it was not proven that the gun was not locked. I don't know what happened at James Crumbley's trial.
You know about his statements? The gun was never locked.
Whose statements?
Mr. Crumbley's statements.
Mr. Crumbley and Mrs. Crumbley talked about how the gun had been locked in all of the evidence I saw. Well, Your Honor, obviously we have factual disputes.
Go on. I don't think the evidence has shown that she had no involvement with the gun.
I'm not saying no involvement. I said she supported the gun. She didn't object to the gun. But when it came down to it, probation writes in her narrative that she taught her son how to use the gun, and it's very obvious watching the evidence in the trial that she was not the one teaching him how to use the gun.
There was no evidence that she taught him how to use the gun.
When Mrs. Crumbley spoke, she acknowledged what the testimony was at trial about all of the different things that she wished had come to her attention from the school employees. And the prosecutor's office has said that the proposal the defense has made regarding Mrs. Crumbley is a slap in the face. And what's truly a slap in the face, not only to the victims in this case, but also to the Crumbleys, is how much the Oxford schools did fail the Crumbleys and all the victims. Because if Mrs. Crumbley had been presented any of those 5 things, things would be different and we would probably not be here today. I am asking this court, I know the court of public opinion is running high right now, emotions are running very high. There are many, many complicated issues with this case. It is a dynamic and different case than most cases. Mrs. Crumbley does have a good heart. This is a woman who had no felony history. This is a working mom who was very busy, did have a hobby.
I don't think there's anything wrong with those things.
I'm just saying, largely the evidence at trial were some of those things, and Mrs. Crumbley did have an enormous amount of love for her son, and what she has been painted out to be in the media and throughout this case, and even throughout the victim impact statements today, is just not congruent with the people who know Mrs. Crumbley and know her heart. It's also not congruent with the text messages she sent right after the shooting about how she wished she would have died instead of one of the kids.
I don't think the verdict was about how feeling she is or how sad she is. I think the verdict was about behaviors that led up to that day.
Well, there has been an enormous amount of criticism about whether or not she's sad enough, and there was cross-examination extensively about whether she cried or not enough on the stand, or when during the videos that were played of police interviews and things like that. And then, on the same hand, when
I don't doubt that they were both in shock. I don't doubt that.
And at the end of the day, though, when she did cry, there was an objection about crying. And so Mrs. Crumbley from the very beginning has been damned no matter what way she went. This was the most horrific thing that could have happened to the community, to the victims, to these families. Absolutely horrific. At the end of the day, however, it's a unique and complicated case, and that is why I proposed the sentence I did. I don't believe the sentencing guidelines take into account the very unique situation that we have in this case with a young man who will be in prison forever. I'm asking the court to keep that in mind, and please keep in mind the other arguments throughout the memo.
I think you know that I read everything you send me.
I do, and I appreciate that. Thank you.
Do you want to respond now, or do you want to get a counter from the signing first?
I prefer just to be able to respond once, Your Honor.
Are you okay with that?
That's fine, Your Honor.
Would you like to address the court, or would you like a client to address the court first?
Would you like to address the court, James?
I would.
Yes, Your Honor. Mr. Crumbley will address the court. For the record, he does have something typed out that I typed out for him, so it's bigger. It's easier for him to read, Your Honor.
Okay.
You can't read. No, she said she cannot tell them to.
Let's
He would, Your Honor, there was some confusion about whether or not he could get his second handcuff off. I was just clarifying. The court said she cannot tell the sheriff's
I
office.
does he have to keep on the
Yes. I was just clarifying, Your Honor. Thank you.
Before I address this court directly, I want to do something that I had never been able to do throughout this time until now. I want to say I can't imagine the pain and agony that for the families that have lost their children and what they're experiencing and what they're going through. As a parent, our biggest fear is losing our child or our children. And to lose a child is unimaginable. My heart is really broken for everybody involved. I understand my words are not going to bring any comfort. I understand that they're not going to relieve any pain. And quite frankly, they probably just don't believe me. However, I really want the families of Madison Baldwin, Hannah St. Juliana, Tate Meyer, Mir, and Justin Schilling to know how truly sorry I am and how devastated I was when I heard what happened to them. I have cried for you and the loss of your children more times than I can count. I know your pain and loss will never go away. Part of you will be missing forever. But please know that I am truly very sorry. I am sorry for your loss as a result of what my son did. I cannot express how much I wish that I had known what was going on with him or what was going to happen. Because I absolutely would have done a lot of things differently. Again, my heart pours out to every single one of you. It really does. Judge Matthews, I'm not gonna overdo a lot of things that were already said. But I know the full amount of pressure that you have on you and the responsibility that has been placed on you throughout this case. I have the utmost respect for you, and I'm simply going to ask that you sentence me in a fair and just way. You presided over my trial and heard the evidence that was presented against me. You know that what my son did, I was not aware of, or that he was planning it, or that he obtained access to the firearms in my house. There was absolutely no evidence that suggested that. As my attorney has told you, I've been on lockdown for 23 hours a day. I've not been able to speak to my son since November 30th, and I have not been able to speak with my wife since December 3rd. I know that I have experienced pales in compassion to what those families who've lost their children and countless other victims experience every day because of what my son did. But I want you to know I too grieve for everyone, as I have explained. For everyone that's been affected by what my son pled guilty to doing. And I'll continue to feel this pain for the rest of my life as well. If I could go back and change things, if I could go back and do things differently, and maybe none of us would be here today. So again, I ask Your Honor to impose a just and fair sentence based on the truth about what you heard during my trial. I'm asking the court to sentence me to time served and place me on probation for the maximum time allowed with the GPS tether for as long as the court deems necessary. I also want to address one last thing. And that's to what Tate Mears Dad said, it is time that we all know the truth. We have been prohibited from telling the whole truth. The whole truth has not been told. And I'm with you, Mr. Muir. I too want the truth. Because you have not had it. You have not had the truth at all. The truth has not been presented to you. Thank you.
Thank you, Mr. Crumbley. Ms. Lehman, are you wanting to say? Go ahead.
Thank you, Your Honor.
Ms. Lehman?
Thank you, Your Honor. I did submit a sentencing memorandum, Your Honor. I'm not going to belabor the points that I made in my memorandum, as I do believe that it was thorough. However, I do want to note for the court that, especially in statements that have been made about James, that he lacks remorse, that he doesn't feel bad, that he's trying to put off responsibility on everyone but himself, that he's allegedly made threats toward the elected prosecutor. Your Honor, in some of the same calls that the prosecution has tried to use and has quoted in their own sentencing memorandum and attached as exhibits to their memorandum, as I noted in my sentencing memorandum, Your Honor, James also said in those very same calls that he wished that he had known what his son was capable of. That if he had known, if he had been made aware of these things, if he had known that his son had obtained access to a firearm, then maybe he could have saved the 4 children's lives. That maybe he could have saved a lot more than that. Your Honor, there has never been a time that James Crumbley has not acknowledged what happened in this case. He has felt horrific grief for not only the families, but for the people who have been affected. He's grieved for himself, for his own child. And while that may not be something that is a popular statement to make, he's grieved for the child that he believed he had. Not the child who pled guilty, but the child that he believed he had on the morning of November 30th when he dropped his son off at school. James could not have predicted what his son was going to do that day. He couldn't have predicted because he didn't know that it was going to happen. As James said, Your Honor, you sat through the trial, Judge. You heard the evidence that was presented. You also know that there was no indication given in the evidence presented that James had knowledge of what his son was planning. That James didn't know that his son had been accessing that firearm unsupervised, or that he had access to the firearm unsupervised. Judge, you heard that that firearm was stored legally at the laws at the time, in November of 2021. That there may be differing opinions on whether or not that firearm was stored responsibly, Your Honor, but it was stored legally. It was stored unloaded. It was munitions stored separately. Your Honor, James Crumbley did and made the decisions that he thought were right, based on the information that he had, even on the morning of November 30th at the school. You've heard multiple times that James had no knowledge of what his son was intending to do later that day. That even the school officials, the people who were trained, they talked about the special training that they had during trial. Even those individuals said that they did not believe that James's son was a threat to other people. That they had concerns about his sadness, Your Honor.
They had at a minimum concerns about his danger to himself, right?
Correct, Your Honor. Danger to himself due to his level of sadness, that they wanted him to go talk with somebody, but that it wasn't so emergent that he needed to be removed immediately.
And isn't it the reason they didn't want him to go home?
Your Honor, there's some dispute as to whether or not the testimony from the school is accurate as to what actually occurred in that office. And Judge, I don't want to try and retry the case. I don't think it serves anyone or benefits anyone. But I do want this court to be aware, and Your Honor, you observed James during the trial. You're aware that he had difficulties throughout the trial. He showed emotion. He struggled with some of the things that he heard and saw.
I don't know how anyone could have
I agree, Your Honor. I agree. And as I've acknowledged numerous times throughout this case and throughout the trial, it is an incredibly emotional trial. Today is incredibly emotional for everyone involved. I echo what Ms. Smith said. There are no winners here. Everyone has lost in this case.
I think that Ms. Smith said in her sentencing memo that it's possible to stand for everyone here, not just the victims from the Crumbleys as well. It is possible to stand for everyone.
And I agree with that, Your Honor. I did ask the court to sentence James to time served. I am going to echo his request for a period of supervision with a GPS tether. I understand that the court, we did object to some scoring. I understand that, again, the court has significantly strong pressure. The emotions run high in this case, Your Honor. I don't envy what you have to do. However, I am asking that you consider my request. Thank you, Your Honor.
Your Honor, I just have to correct some facts. The allegations that Jennifer and James Crumbley were left in the dark just are not true, and the evidence at trial does not show that. The evidence presented at trial that as late back as March, the 9th, 17th, and the 20th text messages about from their son to Jennifer Crumbley that he was seeing things. In April, his text messages to his friends indicate he asked for help. His mother laughed at him. April 26th, Jennifer told his friend's mother that he was depressed. There were multiple visits to the gun range. There was 2 guns purchased for him. The Crumbleys were aware that he was struggling in school, and in fact, they had a rather, I would say, critical fight the night before, which is all detailed, incidentally, and as well as where the gun actually was in the shooter's statements, his plea, and the multiple statements he made to the psychiatrist, the very same things. They stand here and say, oh, if only we could have called them. Well, calling those individuals would have resulted in all of the claims that's inconsistent with what he said, and it's inconsistent with what the psychiatrist testified to in the Miller hearing. So I had no intention of addressing this, but it was brought up, so I feel as if I have to, and I have a duty to do so. They were concerned. The evidence showed that. They were very concerned. They were concerned about the drawing, and they were concerned based on the fact that they were called to school. Jennifer Crumbley's own statements acknowledges she was called to the school. They wanted him to get help. She said she had to go back to work, but they said that he could stay. None of that, by the way, is in dispute, and that she left. This insinuation that if only I had known he was sleeping in class and teachers might have been concerned, then none of this would have happened, is at the core of why you saw 6 people standing here and saying there's no remorse or accountability. And I want to be clear, remorse does not sound like I feel really bad. I'm sure they do. I don't dispute they feel bad. I don't dispute they have grief. That's not the kind of remorse and accountability these victims are looking for. What that looks like is we messed up. We should have done this and we didn't, and we are very sorry. And that has not happened, which is what we're talking about here, and what you heard the victims say. I don't want to belabor any more that we had to in the trial. I have a deep respect for Ms. Lehman, but the facts of this and the elements of this case simply are not that the prosecution had to show that he had actual knowledge and he could predict and he knew exactly what his son was going to do. Those are not the elements of the crime. It's not what the jury was required to find, and it has nothing to do with their actual conviction. Jennifer Crumbley and James Crumbley were not convicted based on a narrative. They were not convicted because somebody thought they were a bad or good parent. Those 2 trials involved multiple motions and objections over evidence that the court sustained. We did not allow the jury to present the information about Jennifer Crumbley that her lawyer made a strategic decision to, in the middle of the trial, say, open the door, you can bring it all in, was not due to the prosecution's requests or actions. But you can't seek to exclude evidence and then allow somebody to testify to an inconsistent with the evidence. The last thing I want to say is there is case law that the court's aware of about what the court can consider in fashioning a proportional sentence. And we don't give power or authority to victims to decide or render verdicts, with good reason. But we should not, and we cannot, sanitize their pain or the weight of the impact or chalk it up to it's emotionally charged, as if everything that's happened here is because people sitting here are too emotional and they pressure people, because that just simply isn't true. And not only should you consider the weight and the impact of the defendant's actions and inactions, you are required to, pursuant to the case law. It is one of the factors to consider, the severity and the impact of the crime. We've heard a lot about it's not what happened in the school. And while I understand that the negligence, the gross negligence that occurred happened before what happened in that day when he left that bathroom and started firing the 9mm and killing 4 kids. I understand that. But it is absolutely about what James and Jennifer did and what they didn't do, and the gross negligence that caused those acts. This is what it looks like. This is what it looks like. When 2 parents have the ability and are in the best position and have the most knowledge and need to protect other kids, and they do nothing. This is what it looks like. They do nothing, and then they come here today, and they claim they're victims of the school, of the prosecution, of the emotional tensions of public opinion. But there were 2 long and rigorous and detailed trials that included multiple victims and witnesses who testified under oath with hundreds of exhibits presented to the juries with the safeguard of this court allowing what they could see and what they couldn't see, and they were defended by 2 attorneys aptly and vigorously. That is what this conviction is about. And when fashioning a sentence, it is absolutely critical that you listen and consider the impact of what that gross negligence cost. So we're asking you to exceed the guidelines, because I believe all of the factors pursuant to the case law, with the necessary consideration of the impact of these crimes, justifies you to do. We're asking you, the people are asking you, Your Honor, to consider the devastating impact of their gross negligence that was foreseeable. Help me. Blood everywhere. The world is dead. All the while, a 9mm had just been purchased for him, and 50 rounds of ammunition. Both things can be true, Your Honor. You can fashion a proportionate sentence, but not ignore the unimaginable loss and a grief that these parents are enduring. Because they will never get back another moment with Tate, or Hannah, or Justin, or Madison. And this is what it looks like. Thank you.
Thank you. I guess I would like to say briefly to the families, considering your immeasurable grief, it's completely understandable understandable to hate everything associated with these proceedings. I spent both trials looking out at all the family members, and I wondered to myself, I was looking straight on at Mr. St. Juliana, whether or not he'll ever smile again. And that's very difficult. I'm very aware of my job in this situation, very aware of my job to not be swayed by public opinion, by media, by any of those different things. I can't and will not pretend to understand the pain the families are experiencing, but I did sit through these trials with you. I saw what you saw, I heard what you heard, so I can and will offer my deepest and most sincere condolences for your unfathomable losses. It's as I just said, it's not my role, it's not the role of the court system to make an example of the defendants. However, it is a goal of sentencing to act as a deterrent. These charges are not jury edicts about gun ownership or keeping a gun in a private home. All of the jurors in both trials agreed that they understood that. Parenting is a complex job. Parenting practices around the world share the goals of ensuring health and safety, preparation for life as a productive adult, and transmission of cultural values. Parents are not expected to be psychic. But these convictions are not about poor parenting. These convictions confirm repeated acts or lack of acts that could have halted an oncoming runaway train. About repeatedly ignoring things that would make a reasonable person feel the hair on the back of their neck stand up. Opportunity knocked over and over again, louder and louder, and was ignored. No one answered, and these two people should have and sure didn't. Mr. Crumbley, it's clear to this court that because of you, there was unfettered access to a gun or guns, as well as ammunition in your home. You characterized yourself as a martyr and threatened the well-being of the prosecutor. Mrs. Crumbley, you glorified the use and possession of these weapons. Your attitude toward your son and his behaviors was dispassionate and apathetic. Your response to the school staff after a 12-minute meeting was, "Are we done here?" During your trial, you announced that you wouldn't do anything different. I understand that that might have been misinterpreted, but it did cut the victims deep. Because of both of your actions and inaction, among many, many other things, the world is missing out on a top college university will miss out on Tate's star quality football skills. I met Raina, who's wise beyond her years, and she's told us that among many, many other things, the community will be denied Hannah's kindness, creativity, and sense of humor. Among many, many other things, the world will miss is Madison's kind and loving soul and the light that reflected her beauty both inside and out. Although a hero in death because of his organ donations that helped so many, we will never know where Justin, an excellent student with vast skills and interests, described as a mentor and a leader, would have left his giant imprint. The impact statements given here and the written statements provided to the court describe the cataclysmic impact the deaths of these children have had on their children. With regard to each defendant, this court has spent night and day thinking about this case, as you can imagine. I've prayed about this case, I've thought about this case, and I've considered the possibility for rehabilitation, the need to protect society, the penalty appropriate to the conduct and goal of deterring others from similar conduct. I have reviewed the pre-sentence investigation reports. I am, of course, sadly familiar with the facts and circumstances of these cases, as well as those surrounding each defendant. The advisory sentencing guidelines in this matter do not capture the catastrophic impact of the acts or inaction in these matters. The guidelines do not take into account the complete lack of insight both defendants have for their behavior to this very day. The guidelines do not account for the severity of the circumstances in this matter. The guidelines ignore the survivors, including shooting victims Phoebe Arthur, Elijah Mueller, Riley Franz, Kylie Osage, John Asciutto, Molly Darnell, and Aiden Watson. They were deeply wounded, both physically and emotionally. In addition to the 7 wounded, each of the defendants' gross negligence has caused unimaginable suffering to hundreds of others as a result of what happened that day. Each act or inaction created a ripple effect. Therefore, an out-of-guidelines sentence is appropriate and proportional. The court uses the useful tool of the legislative guidelines, which embody the principles of proportionality, while also taking into account the nature of the offense and the background of each defendant. I believe that the following sentences would be in the best interest of justice and are reasonable and proportionate to the seriousness of the matter and the circumstances surrounding each defendant. With regard to Jennifer Crumbley, it is the sentence of this court, Ms. Crumbley, that you serve 10 to 15 years with the Michigan Department of Corrections. You will have credit for 858 days. State costs are $272. There's a crime victims' rights fee of $130. You and your agents may not have any contact with the families of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. I will issue another ruling with regard to contact with your son, the shooter. Excuse me. As to defendant James Crumbley, it is the sentence of this court that you serve 10 to 15 years with the Michigan Department of Corrections, that you receive credit for 858 days, that you pay state costs in the matter of $272, that there is a crime victims' rights fee of $130, that you or your agents have no contact with the families of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. Ms. Wheeler, have I left anything out with regard to sentencing? No restitution has been requested by any of the families at this time, correct?
That's correct.
Thank you. I would like to advise both defendants that you are entitled to appellate review of your conviction and sentence, including that the sentence exceeds the guideline range. This is done by filing a claim of appeal by right, or when you are not entitled to file a claim of appeal by right, an application for leave to appeal. If you cannot afford to hire an attorney to represent you on appeal, and you request an attorney may be appointed for you. You may request an attorney by completing the request for appointment of attorney section of the form that will be provided for you, and by returning the form to this court or to the Michigan Assigned Counsel System at the address on the form. If you wish to preserve your automatic right to appeal, the form must be received within 42 days after sentencing. If you do not submit the form within 42 days from today, you may still file an application for leave to appeal if the form is received within 6 months after sentencing. Do each of the defendants acknowledge receipt of their appellate rights?
James acknowledges receipt, Your Honor. He's completing the form as we speak.
Your Honor, my plan is as well. Would the court like the forms here, or would you prefer us to?
It doesn't matter either way.
Okay.
Either way.
Thank you.
Thank you. I'm going to ask that everyone remain seated while the defendants are taken out of the courtroom. I think they're going to finish their appellate rights.
They are going to, Mr. Crumbley is going to finish his form,
All
Your
right,
Honor.
we'll wait for that.
Thank you, Your Honor.
I would just ask that no one stand up. It makes the deputies nervous.
Let me know if you change your mind.
Thank you.
Right there.
You said right here?
Is when she hit me, yeah.
And that's when the female hit you?
Yeah. And she was coming from another group over here. I don't know how many people were in there.
Were these guys stopped?
Yes, in very shallow water.
Okay, so it's really shallow over here.
Shallow there.
Okay.
Pretty much the two sides are shallow. Yeah.
Was it, how deep do you think it was when you were like snorkeling around with the
Oh,
phone?
4 or 5 feet.
Okay.
Not very deep. And the water was very murky, so I could not see anything
Really?
through my goggles. But those goggles are lost. We took them, we grabbed them off my face and threw them in the water.
We found the goggles
Oh, good, thank you.
and the snorkel.
Yes, yes,
Yep.
yep,
Are they connected?
yes,
Oh, okay.
yes.
And they're just like regular snorkel
Yeah.
goggles, right?
Yeah, I had
Okay.
them over when I went to the Caribbean.
Okay.
Yeah.
What do they look like? Just to make sure we have the right ones. White?
Well, transparent plastic with the white snorkel.
Okay. All right.
Yeah.
I think-
Is that it?
I think we have them. Was there any? Did it seem like these groups were together?
After they came after me, I don't know. Yes.
Okay.
Yes, I think so. I mean, I feared for my life. Tell you the truth, when they started hitting me and pointed a knife at me, and then another kid pointed a knife, I thought that was it for me. Luckily, I took it from one of the young kids, and I think that's when I swung back.
What did you do with it?
I don't even know.
Okay.
I don't know. Absolutely, I don't know. I don't know if he got it back. I have absolutely no idea.
Did you hit him? Like, did the knife make contact with him?
That I don't remember.
Okay.
You were so close.
Sure.
And one had it in his hand, so I took his hand and I bent it and I poked him with his own hand. And then I took it from his hand and then I went and swung like this. So I don't know who I hit. I just know that I took the knife from one of the kids.
Okay.
The other one, I don't know what happened to. I didn't get hit. Because as soon as this happened, I started running across. So I went across to my group, and then my group was wondering what just happened. And I didn't want to tell them anything.
Just because you didn't want to.
I didn't want to get anybody aroused. I didn't want my group to go say, well, we're gonna go talk to those kids. No, they were too drunk. I believe they were too drunk and too set on going after people. I think.
What were these guys doing? Did
They
they
were
know?
just-
Did they know anything was going on?
No.
So they didn't know you were getting punched or.
Well, they saw the scuffle because at one point Ernesto was coming towards me like, hey man, did you find anything? And I said, no, I didn't. I don't know. These guys must have it or something. I don't know. And he says, okay, well, he will just get another phone on Monday. You were concerned about getting the phone. And like, okay, so what are you doing? I said, I don't know. I'm just gonna go late to sit in my thing. And then Sandy said, okay, are you okay? And said, I don't want to talk about it. You know, and then they asked me, hey, what do you want to do? You want to stay here? You want to go down? And I said, I want to go down. And then some girls from my group heard that something was happening over here, and they said, well, we're calling the police. And I think they called the police.
Okay.
One or two, I don't know.
Did you see any of that? What was going on?
No.
When they decided to call the police?
No.
Okay. Did you have a knife with
No,
you?
no, absolutely. No.
Okay.
I had one earlier that I used to cut, but right at the beginning, and I left it I don't even know what I did with it. I think I either gave it to one of the people, or I put it back in my truck.
Okay.
Yeah. So it may have been. I tell you the truth, I don't even know.
And that was after you cut the string?
Yeah, we needed to have something to cut the string over there. They don't have any knives. So,
But you have them with you today, right?
The what?
A knife to cut. How did that,
I think it's in my car.
okay.
Yeah. I think.
Did you drive or did Sandy drive?
I did.
Okay,
Yeah.
okay.
I don't even know where it's at, to tell you the truth. It may be in one of the bags we had with us. It may have been in I don't know. Maybe I left it, put it back in the car. Because I went back with a bunch of, I had straps. I didn't want to pay for string. But they say string
You
is
can't.
cheap.
Well, they probably don't want you to have straps.
But they told me, they said, yeah, if you have straps, there was a kid over there. If you have straps, no problem, but the string is free. So I said, okay, I'll take the string.
Okay.
You know, and then I took the straps back. So, because straps can puncture the...
Yeah.
So I had a whole bag of straps that I took back to my car.
Okay, and so maybe the knife was with the strap?
Probably.
Do you have any cuts or marks on you? Have you had a chance to like look at your
No.
torso or?
Somebody was telling me that I'm bleeding from my ear, from my left ear.
Who told you that?
Oh, I think it was Amy. They said, Nick, you're bleeding from your left ear. I went like this, I went in the water, I cleaned, and then I don't see any blood. You know, and I don't know if you see any cuts, but
I don't.
Yeah, so I don't know why I was bleeding from my ear.
But Amy saw blood?
I think she says you're bleeding from your ear, Nick. And then I cleaned and I said, look, there is nothing. Oh, okay.
Okay.
Yeah. Yeah, I don't know if it was blood or if it was weeds she saw. I have no idea. We were like, she was on the other side and I was just...
Yeah, so she's over here, right?
She's over here, yeah, right here.
Oh, so she's closest, Amy's over here, closest to the shore?
Yeah.
Okay.
With the nestle right here. And I was over here somewhere in one of these.
Okay, and you got back in that tube then when it was time to go?
Got back in my own tube, yes.
Okay. Did Ernesto come and get you?
No.
Like, did anybody know that you were getting
No.
punched or
No. No.
was anybody?
They wanted to talk to me about the phone, if I found the phone, and what did those guys say, and I said, they probably did, they don't want to give it up, they attacked me, and that's it. And then I said, let's go, I don't want to be here.
Yeah.
So they don't know what happened here.
You didn't tell anybody?
No.
Okay.
No. You're the first one to know.
Okay.
That's why probably Amy and everybody else is so surprised.
Well, they're worried about you.
Yeah.
I mean, and even Ernesto was like, I don't know how the hell this happened.
They don't know anything because I didn't know what to tell them.
Yeah.
I really don't know. Everything happened so fast. I really don't remember why they attacked me. I don't know why they took my snorkel away. I don't know why one of them wanted to pull my pants down. I don't know why they were being so mean. I just don't know.
Yeah.
I just don't know. And why did they want to scare me with a knife? I just don't know why they're scaring people on the river. It's a family-oriented river with knives and you know what they did.
So was it two males that had knives?
I
Or
saw two
men?
males.
Okay.
Yes, yeah.
And were they both from this group, or do you even,
No,
do you even know?
well, that I don't know.
Okay.
One of them was from this group. The one
Okay.
that I took the smaller knife from, I think was from this group.
Okay, so you took the smaller knife.
From one of them.
And is that the one that you said that you kind of went,
Yes.
basically like?
Oh, I was going like this. I wanted out. They were coming and they were punching me and they were circling me and they came really close. They were pushing me in the water and I just grabbed the kid's knife. I didn't even know if I was holding it right. I just grabbed it from him because he tried to poke me with it. So I feared for my life.
It sounds like.
I was very shocked. I was extremely shocked. I couldn't even say anything to anybody. I had locked jaw. I don't know. Right now, I don't even know how this happened, how I got away from all that.
So when they were pushing you in the water, did you go underwater or did you remain standing?
No, I tripped.
Okay.
I tripped and I fell in the water a couple of times, yes.
Where on your body did they hit you?
In the back of my back. And I know one of the girls came over and slapped me right over my right ear. I couldn't even see what they were doing because I was tripping over the stones, and I was falling down, and they were just jumping on me.
I'm going to show you a picture and see if you...
I was fearing for my life. I'm still fearful that they're going to find out who I am and go do something to Sandy. And possibly some of these people over here. I fear that somehow they're going to find out who I am and continue their whatever that was. And I don't know why they're so hateful. And I just don't get it. I mean, this is the second time I come to the river, the first time for my wife, and I promised her it was going to be a beautiful outing and nothing to fear. We had lots of booze. She didn't drink because she was the designated driver. But most of us did, and there was another girl that didn't drink on the other party because they wanted to drive home. We ate well, we had music, everything was so good, so good, so good. Of course, I had a lot of alcohol, who doesn't, you know.
Well, you had a sober ride. So,
yeah.
And I don't smell it on you. Were you drinking beer or vodka or what?
No.
Okay.
We don't do hard liquor because then we dehydrate too fast and we get cramps.
Okay.
So after my quadruple bypass, I still have cramps.
Oh, yikes. Quadruple bypass? How long ago was that?
A year and a half ago.
Wow.
Yeah, so if you see any wires in my chest, in my sternum, that's from the wire.
Really? You have a pacemaker in there too or anything? No?
Mm-mm. I tell you the truth, I'm scared because I'm not in the best of health, okay?
Yeah.
I'm just going down the river. Probably should not have even drank that much beer, but the doctor never said don't drink.
Sure.
You know, especially beer, you can have as much as you want in moderation. I was in cold water, you know. So, but, you know.
Yeah, yikes.
And then missing vein here, and then from my leg.
That's what they used to...
Yeah, take it here, take it from here, cut it in half, that's two. The same thing from my leg, cut it in half, use the other two, so it's quadruple bypass.
Wow.
Yeah, I was dead. My heart stopped 5 hours.
Wow. Have you had a heart attack that prompted that? Okay.
Yeah.
Yikes.
So I was in pretty bad shape.
It sounds like it.
Yeah.
I bet Sandy was pretty scared.
She was, because I was in the hospital for quite some time.
I bet.
At Methodist Hospital. But they did a great job, you know, and Methodist Hospital is probably one of the best hospitals for heart surgeries. If you know somebody, I'll point them to Methodist.
Yeah, my father-in-law had heart surgery there too. He had a heart attack a few years ago, and that's where he went.
Yeah.
Do you need some more?
No, that's it.
Are you sure? I got an extra fresh bottle here. So you want it?
Yes, please.
I can't travel without one. It's brand new too. I didn't drink out of it yet. So
thank you so much.
I probably am going to drink out of it now. So you can have that, and this is going to be my part.
I really appreciate it. Thank you.
Yeah, I take a medication that makes me really, really thirsty. So I have bottles of water rolling around in my back seat. I've got them in the door pocket.
I'm supposed to take mine, but they're at home, and I don't know when I'm going to take them.
Okay, so you have medication that you need?
Oh, yeah.
Okay.
5 medication.
Because I can call Sandy and see,
Oh, I'm not going to have her drive over here.
well, I might be able to send somebody to go get them,
Oh.
just so that they get back here. And I mean, I'm
She's so
sorry.
shaken right now, she is probably...
Yeah.
Yeah,
Well, but we need to make sure you have your medication.
Yeah, but like I said, I wouldn't have her drive.
Yeah, yep, I might be able to send somebody there to get them. What medications do you take, Nick?
Oh, my God.
Are they all heart-related, or some do different
Well,
things?
2 of them are heart-related.
Okay.
Yeah. One is aspirin.
That's heart-related, right? The
Yeah.
blood thinning?
Yeah.
Yep.
Potassium, because I'm getting lots of muscle cramps.
Okay, that's 4.
There is one. There's another one. I'll tell you when I remember.
Okay, no worries. Were you on your phone at all during your day today? I know that Sandy didn't bring her phone.
I took some pictures.
Okay.
Then I put it away. Sandy does not like to take a lot of pictures because then they get posted on
Facebook or Instagram or something?
Yeah. But I'm okay if they take them, if they post them. Yeah. I did take a few, didn't have a chance to do anything with them.
Okay.
Yeah, but I was not on the phone, I didn't call anybody.
Okay, did you use your phone around the time,
No.
like right before, you know, you were looking for the phone or anything like that?
Not me.
Okay.
Not like these guys, they're constantly on their phones. That's why IDL lost his.
Because he was on it too much?
People can't enjoy life nowadays going down the river without being on their phones. Of course, they take a lot of pictures, but the picture is not the same experience as being there. So, I don't know.
So do you think the pictures that you took were like at the beginning of your journey, or where do you think?
We did take, I took a couple of group ones where they have that music place in the bathrooms.
Okay.
We made a stop there to eat sandwiches. There were a lot of people over there. That beach was completely full. Lots of people there, lots of people. It was a beautiful day, except
It was.
this. And this now, we'll probably close that place down.
You think so?
Yes. Well, I don't know what resulted of it, because I don't know.
Is this you?
Yes.
Okay. What do you think was happening at that time?
They were fighting me. They pointed the knife at me. They pointed the knife at me. Both boys pointed the knife at me.
Okay. Did you see anyone take this picture of you?
No, God, no. I was actually very scared.
Yeah.
I was very scared. I didn't know what to think. I didn't know what they were doing and why. I mean, I understand they were drunk, but you get drunk, I get drunk, we all get drunk. We don't do that kind of stuff, especially on a family river like this, family outing. We don't do that kind of stuff. But I was very, very scared. I didn't know what was going to happen next.
Did you see the woman that hit you in the ear? Did you see her at all?
No. I turned around, she hit me again.
Okay. Do you remember what her bathing suit looked like?
No.
What she was wearing?
She was just yelling at me and calling me child molester. That's how it all started. They kept calling me a child molester. I don't know, out of the blue. And then they wanted to beat me up because they said I'm a child molester. And then my argument back to them was, if I'm a child molester and you're children, you shouldn't be drinking. You should not be out here drinking, okay, and doing what you're doing. Where are your parents?
Did they look like they were young?
I don't know. I think they look pretty young to me.
Okay.
I don't think they were of the age of drinking.
Really?
Yeah. I think. I mean, I don't know. I don't hang out with people like that. My generation and people I hang out with are much older people.
Like Ernesto and Sandy.
Like Ernesto and Sandy and Amy. Yeah. Yeah. Amy's probably one of the youngest ones there.
Sure.
45, and Sandy is 61.
Yeah.
So I'm younger,
So you said that they were standing really close to you.
They were on top of me. They were pushing me, shoving me. I tripped. I fell down. I got up. And that's where I saw the one of the kids there. It was the closest kid with a knife, and I grabbed it from him.
And that was the smallest?
Yes.
And he was in front of you? Was he as close as we are? Or
he was closer. He was closer. But as soon as he came with the knife, I grabbed the knife from him. And what I did then, I mean, I shouldn't show you, but I grabbed, twisted his arm and poked him with his own knife. Then I took it from him and I started swinging.
Okay.
So I swung. I don't even know who I hit.
Okay.
I don't know if I hit the girl that hit me twice in the head from behind. I don't know if I hit another kid. I don't know. They were just on top of me. They chased me, hitting me and yelling at me and calling me, insulting me. That's it.
Okay.
So I don't know what knife they had. I don't know. I just saw two knives. That's it. The longer one and the shorter one. I don't know where they are. I don't know who's got them. I don't know.
So what I'd like to do is I'd like to get a sample of your DNA, because if these knives don't belong to you, I would imagine your DNA is not going to be on them.
Well, I touched one of them.
Yeah, you touched the one you grabbed.
Yeah, from the kid.
him.
Yeah.
Would you be willing to give me a sample
Yes.
of your DNA? Okay.
Yeah. Is that a good thing?
Well-
I mean, I mean, I don't know. I don't have a lawyer over here to ask.
Yeah, and certainly, so...
Should I wait?
Well, I've got a colleague that's in the process of writing a search warrant, so we're going to get it one way or another. I just thought if I could ask you, and we could just do it right now, I'll show you how to, what we would do.
I know what it is.
I would just get your DNA
Well,
sample. Yeah, it's like a big Q-tip.
Yeah.
We'd also like to do an exam, have a nurse examine your body.
That's absolutely okay.
Okay, and I want her to look in your ears, and I want her to look at your back, and, the people that are in these groups, we're going to try to collect evidence from them, because they might have your skin underneath their fingernails, or, we're going to do our best to get any evidence to, we
Yeah,
still know what
of course,
happened.
yeah. I mean, and I know everything that happened in the river, so.
Well, yeah, there's that part of it too, but,
Definitely.
okay,
Yep, yeah.
okay,
You can call me.
okay.
I just don't know if I had a lawyer present, what he or she would say.
Well, I just want you to know that we would get it anyway.
Okay.
I've got a coworker that's writing a search warrant.
If you would get
for the
it
judge.
anyway, then let's do it.
Okay, with the court order, or just let's do it now and get it done?
No, let's do it now and give you what you need to start your proceedings or your search. Yeah.
Well, and if you sound like you were really afraid.
Yeah, I have a quadruple bypass. I have been out of shape. I have been in bed for a long time, for 6 months at least. I couldn't go to work. I'm not in the best. I was just floating down the river. Nothing much. Every once in a while I got up so I could pee, because I can't pee in the thing there. Shouldn't tell you that on camera, but yes, most people have to get off the thing. So I got out. I would get up and then hold on and then get back in. I don't do anything to stay in shape. I'm a guy that wants to survive and keep working at Ritchie Engineering, and why these things happen, it's beyond me. I don't understand. Why would that many people come down on one person that didn't absolutely do anything, take his goggles, almost one wanted to pull my pants down. So
Did your trunks have a drawstring?
Yeah.
So they didn't come down?
Oh, no. They came down a little bit, but no, because I have a drawstring on it, so yeah, they couldn't pull it down. But why? All of a sudden, they were like wolves around me, and they were attacking me from all directions, and I truly feared for my life. I didn't know what to do. These guys were talking over there. I didn't know what to say. I was just.
Which guys are you talking?
My
Okay.
guys. So, and they were quite a bit distance, so they didn't see anything. I don't think they saw anything. And.
So when you go back to your tube, do you guys get the hell out of there? Or
No.
do you what do you do?
We stayed there.
Okay.
Yeah, the girls called the cops. We didn't know what to do. And we stayed there for a long time. There were people coming. We even saw the sheriff coming, and they kept saying, oh my God, they didn't know what happened. So they said, oh my God, what happened? There was a fight, And I said, yeah, I don't know what was going on after that. I thought they were still fighting. Personally, when I came back, I saw a whole bunch of people coming over there and yelling at each other, and I thought they were still fighting for some reason. I didn't know what was going on. So I personally wanted to stay and watch to see if the cops get them for fighting, for whatever they were doing.
Sure. Okay.
So I wanted to be a witness to them fighting.
Gotcha.
Or if the cops needed a witness, I wanted to sit there for as long as possible. And then the group said, well, there's so many people there. I don't know, let's just get going. We don't want to get involved in that. I was just in there. They attacked me. Yeah, but look at them now. They're attacking each other. I don't know what they're doing. So cops came, and we stayed there for, I don't know, another 10, 15 minutes.
When the police were there?
Yeah.
Okay.
Yeah. And then we decided we'll go. Nobody asked me anything, and I said, I kept my mouth shut, and down the river we went.
Okay.
So I was very shocked. I didn't know what just happened, really, to tell you the truth.
Well, Sandy said that you were quiet
I was very quiet.
and you didn't really talk.
I didn't know what to say.
Yeah.
I mean, I get my, excuse my French, my ass kicked by a whole bunch of kids. What am I going to say? I just got my ass kicked by this kid, now the police is on top of them. Well, I think something is going to come out of it. So I thought the police was there because they were fighting, because these were just boys. And they were being obnoxious, not only picking on me, then these girls came over and hit me.
So these are girls over here?
Well,
Mostly?
mostly.
Okay. And this was all guys?
Yeah, I didn't know who was in this group, but I know these were all guys because I was snorkeling back and forth, and I asked them if they found something, and they said, well, they started calling me a molester. Then I got up, and one of them took my goggles, threw me in the river. I went after them. One of them wanted to pull my pants down, and there you go. So what happened? Can you tell me what happened?
Yes. 4 people went to the hospital with injuries,
Oh my God.
and 1 person died.
Oh no.
I don't know any of their names, and I don't know any genders, so I don't know.
Was that because they fought each other, or is that
I don't know. I don't know what their injuries are. I was with Sandy the whole time, and then when I kind of turned Sandy over to Ernesto and Amy, then I came here. So I have no idea what their injuries were.
Oh my God. Oh my God. Oh my God.
So we just need to be able to piece this together. In your statement,
What other pictures did they give you of me?
it's just that one. That's the only one I have.
They didn't take. They
Well-
have lots of cameras. You should take their cameras.
Yes. And so I have colleagues,
Yeah.
investigators that are talking to all of those, the people in the group and the other witnesses. So yes, we are trying to collect. And I told Ernesto and Amy, because they said that Rosie was taking a lot of pictures.
Yeah.
Okay.
But I don't think she took any pictures of those guys. There was at the stop up here.
Yes, but
Yeah.
you were snorkeling. They might have been taking a
Oh,
selfie or
I
something,
see it.
and
Yeah,
we
yeah,
could have
yeah,
gotten,
yeah,
we
yeah.
could get these guys in
Yeah.
the background that they don't even realize they have it. You know what I mean?
Yeah, I see what you mean.
So I asked them to go through their photos so
Right,
that we
right,
would
right,
be
right.
in contact with
got
them.
it. I was, all of a sudden you say that, like, why would they take pictures of me going over there?
No, you just never know what you get in a picture.
Yeah.
If they're sitting here waiting for you and Ariel to find the phone,
Did you find his phone?
I don't know. again, I've been with Sandy pretty much the whole time, and now I came here with you. So I do know, I did get a message that the goggles and the snorkel were found. So that's all the information that I have about, like, items that were located.
No, my whole life is down the tubes.
Well, I don't know if that's the case. Because people have the right to defend themselves.
I know, but this is Wisconsin.
This is Wisconsin.
Okay. You continue on. I usually know that people that defend themselves, they end up being accused of being this and being that.
Well, I think if you'd asked me what I would have done,
Yeah,
I mean,
let's not say
I don't
that
know.
now. Yeah, you don't know.
I don't know. I would have been scared shitless, I can tell you that.
When that many people
Yeah.
try to pull your pants down and hit you, and and two boys had knives on them. They didn't find any of those 2 knives?
I don't know. I don't know, but we're looking. And, you know, we're looking before it gets dark out. Okay, right now it is 8:40.
I'm glad I actually took that kid's knife. He would have stabbed me. He was not there to scare me. He was there to harm me. At least I'm here, but I'm sorry for how it ended up. Still scared, like I said. I'm scared that they're gonna be finding out where I live, and they're gonna be hunting us at night, and they're gonna be hurting my wife.
Well, I will call Sandy as soon as I leave here, okay, and just check in on her. Find out about your medications. Have you had any medicine this morning?
No, I take them in the evening.
Okay, you take them in the evening. What would happen if you don't take them
Nothing.
tonight?
Nothing. I'm not even hungry to tell you the truth.
Okay. But if you don't take your medication tonight, is that life-threatening?
I don't think so. No, I mean, granted what happened today, I was shocked. Yeah, but I don't know. I don't think so. I just can't believe what happened. They need to maybe do sobriety tests on minors on that river. Maybe they need to put an end to drinking, underage drinking and doing drugs. The river over there is turned into a sewer. My second time, and I have dragged my wife out of there, pretty much against her will. I promised her it was going to be the best day. I made promises. We're going to have a great time with this.
But she didn't want to go?
No. She always says, places like this, all they do is smoke pot and do this. Yes, there is a lot of pot smoking over there. We don't know who's legal, who's illegal. I don't know anything about Wisconsin laws, but you can smell it. It was everywhere in the air.
Yeah.
And I don't know what people do, because you do the DNA, you can find out, what type of drugs are in my system. I've never done any of that stuff, so I don't know. I'm very clean, as clean as they go. You looked at my criminal record, you can keep digging, there is nothing there, because I don't have anything, not even one parking ticket, not a speeding ticket. I'm as a law-abiding citizen as they come. But I fear for my life too. I mean, I went through a very serious surgery to be alive, to be knifed down by a bunch of kids on the river.
Yeah, well, I understand.
And I'm not blaming the police. I believe that's a private land. They have to have their own security there, and they need to do better.
So what I'm going to do is I'm just going to rub these along your lower gum line and kind of inside your cheek. I'm gonna do them both at the same time. It shouldn't hurt at all. If it does, let me know. I'm gonna put them in this box, and then I'm gonna seal this bag while we're sitting here, so you see that I sealed it, okay? So I'll just have you open up your mouth. Let's see here. Shouldn't, like I said, shouldn't hurt. All right. And you're okay with having the nurse do the exam on you, taking pictures if you have any lumps on the body? You're okay with that?
Yeah. These actually are from trying to get out of the
Okay.
the tubes in shallow water.
Okay.
You know, I had a hard time trying to stop the drain.
Yeah. Can I just, I know the nurse will too, but I'd like, can I take a picture of it?
Yes.
Okay.
But this was not from the confrontation.
Oh, this wasn't?
No.
Oh, I'm sorry, I misunderstood that.
No, these are from scrapes on the river bottom when I was
When you were snorkeling?
snorkeling.
I got
Yes.
you. Okay, perfect.
Yeah, please don't use that, yeah. I didn't touch those kids. I did not swim, nothing. No.
Okay. I'm gonna seal this up, because I told you I was gonna do that. And then I'm gonna go call the person that, has the nurse kind of on standby, so that we can, get that taken care of. I'm also gonna give Sandy a holler. Oh, look at that, the tape just.
Oh, no.
For the love of God.
Is this good?
Well, I didn't like it, because it's all, and it's not gonna be big enough to do what I need to do here, so we'll try it again. Worst case scenario, I can always bring it to my office next door and do it in the evidence room. But I'm gonna try to take care of it here.
Probably dries up. When it dries up, it's probably...
Well, and then it's real sticky and it's real finicky, so if you get it stuck on something, it's, you know, it's meant to not, be able to be tampered with. So, and there, it ripped on my finger. So I'll just,
It dries so fast.
okay. So I'm gonna go call my supervisor, who had been in contact with the nurse, and just let them know that we're gonna do that. And then I will be back. Do you have any questions now?
I just not, I need to go potty.
You need to go potty. All right, I can make sure that happens. I'm just gonna write your name on here so that. Today is 7/30/22.
MIU.
Yep, that means no middle initial.
Oh,
And then
I see.
Oh, did I spell it wrong? It's
No,
MIU. Yep, I did.
yeah.
It's MIU. There we go. Okay, that's yours. I will be back in a minute. In the meantime, I'll have one of the jail staff bring you to the bathroom. And are you still doing okay? Do you need, how's your water there?
I have plenty for now.
Okay.
It's going through a lot faster than I thought.
All right. Be right back, Nick.
Thank you so much.
Can you use the restroom?
Lieutenant Hart, was that the interview you did with Nikolai Mew at the jail?
Yes.
At the point where you left, was that the end of your questioning on him?
Yes.
While you were talking to him, you showed Mr. Mew a photo on your phone.
Yes.
What was that photo?
That was a photo that had been disseminated to us of the suspect.
You know where it came from? At the time, did you know where it came from?
Probably. I believe dispatch had emailed it out.
Was it a photo from the video? Objection. Or from something else?
Sustained.
You know where the photo originated from?
I do.
Where did it originate?
From Jawan Cockfield's video.
Strike that. While you're talking to Mr. Mew, you were referring to a diagram?
Yeah.
Yes.
Lieutenant Hart, I'm showing you what's been marked as Exhibit 16. You recognize that?
I do.
And what is it?
This is the diagram that I asked him to draw me while we were talking.
Did he draw portions of that?
He drew all of it. I put the words on there.
All right. Your Honor, I move for admission of Exhibit 16.
Any objection? 16 is received.
If I can publish to the jury on Yellow.
Yes, you may. While you're standing there, would you also retrieve the Exhibit 24?
And just to clarify, is the only thing you added the words on the diagram?
Yes, he put the 100 feet or inches, but I wrote Amy, the mostly girls, shallow, all males and female, and then that is my handwriting on the lower right-hand portion where I put the date and our agency case number.
Also in the video, you appeared to be taking a buccal swab.
Yes,
Did you do anything with those swabs?
I logged them into evidence at the sheriff's office.
Were those the swabs that were sent to crime lab?
No,
Which swabs were sent to the crime lab?
the one in the kit that the Sartners had taken.
While you're speaking with Mr. Mew, did you notice any signs of impairment?
No,
That's it. Nothing else. Nothing further.
And we need a break? Still doing good? All right. One vote for break? All right. Let's take a short recess then. We'll come back at 10:25.
All rise for the jury.
sure.
Okay. And would you agree in your training and experience that highly stressful events can impact someone's ability to recall what had happened?
Yes,
Both for the complaining witness or victim as well as the person who's accused. Would that be fair?
fair.
And you'd agree that doesn't mean that the person is necessarily lying. Sometimes these stressful events kind of cloud memories and make it difficult for them to recall events, correct?
Yes.
Speculation.
Overruled.
I think you said yes?
Yes.
And would you agree that based on your training and experience, how long someone suffers from a stressful event, meaning how they react to it, that can depend upon, I mean, it can differ in terms of timing, right? What I mean by that is you might suffer the same stressful event as I suffer. You might be over that stressful event in a much shorter time than I would be over it. Is that fair?
Yes,
And because it's a criminal investigation and you're working at a quick pace here, you're not given the opportunity to kind of let things calm down before you do your investigation, right?
I don't know if I understand your question.
Okay, so let me give you an example. So in an example, if this fact pattern involved an officer, that officer would have an opportunity before they had to give a statement, correct? Officers don't have to give statements immediately after stressful events. They're allowed to kind of calm down and think about it before they're required to provide a statement. True?
Objection irrelevant.
Sustained.
Did you give, or was Mr. Mew given an opportunity in terms of timing to calm down from the situation, kind of make sure that he had all his faculties before he provided a statement?
I don't know, other than the 4 hours between the time he was taken into custody and I spoke with him.
And those, I'm not being critical of you here, I'm asking you, you don't know whether or not those 4 hours he was still under the stress of the event, right?
I don't know.
Okay. And I'm not going to ask you about what you saw in the video, but what I'm going to ask you about is, you're aware there's a video in the case, right?
Yes.
Okay. And when someone gives you a statement about what had happened, it's helpful for you as an investigator to be able to go back to that video and kind of determine the accuracy of that person's statement, right?
Sure.
Okay. And while you're able to determine whether or not the person's statements are accurate, what the video really doesn't capture and what you need to try to figure out is what the person was feeling or what their beliefs were at the time, correct?
I don't know if that's up for me to decide.
No, but in terms of your investigation, you'll ask people things like, how did that make you feel when something was happening? That you'll ask them questions about their emotions because their emotions might not be borne out on a video. True?
True.
And people will tell you, I was afraid, I was worried, I was stressed. They'll make those statements to you when you ask those questions, correct?
Yes.
Okay. And tell me if this is fair. So you, after conducting the interview with Mr. Mew, you've watched the video, right?
The video of the incident?
Video of the incident?
Yes.
Okay. And you agree his statements regarding how he got the knife, those are inaccurate, correct?
Yes.
Okay. And you did ask Mr. Mew what his beliefs were or how he was feeling while all this was going on, correct? Do you remember that during the interview?
I guess I don't recall if I asked him how he was feeling, but he articulated that to me.
Okay, he had mentioned to you how he was feeling, true?
Yes.
Okay. And would you agree that once you kind of get into the meat of the interview, first thing out of Mr. Mew's mouth is that he was acting in self-defense, right?
Yes.
Okay. And he says that, if I have it right, 3 times in his first statement to you it was self-defense.
Yes.
Okay. And he told you in that first portion of the interview that they were hitting him, right?
Yes.
And that's true, correct? That's borne out on the video, yes?
Objection, Your Honor. The video speaks for itself.
Sustained, is it? Sustained.
Can I ask you this? Although some of the things that Mr. Mew had talked to you about regarding how he obtained the knife, we agree that was incorrect. Would you agree, based on your interview with Mr. Mew, he never wavered in his claim it was self-defense, correct?
Correct.
He never wavered in his claim that he was fearful, correct?
Correct.
And he never wavered in his claim that he was attacked, correct?
Correct.
If I told you, and I don't know if you've counted, I counted approximately 20 times during that interview that he claimed it was self-defense, he was fearful, or they attacked him. Sound about right?
Yes.
Okay. And you've sat through, I know you weren't here yesterday because you weren't feeling well, but you've sat through the trial of every other witness other than when you weren't here, right?
Yes.
Okay. And you've listened to times when witnesses had to be corrected or shown something that turned out not to be true based on the video, right?
Yes.
Okay. Do you have any information through your investigation that contradicts Nick Mew's belief that he was in fear during that incident?
Objection, Your Honor.
Come on up. The objection is sustained.
Lieutenant Hart, in terms of what had happened that day in your interview with Mr. Mew, okay, the recorded interview we just watched, he didn't make any other statements to you that would give you any reason to believe that he wasn't in fear, correct?
Objection, you're on the same grounds.
Overruled.
Can you ask that again?
I don't know. Based on your interview with Mr. Mew on the day in question, right? When you interviewed him on the
Yes,
tape, he told you he was in fear, yes?
he did.
Okay. Did he provide any other statements to you that would contradict that statement that he was in fear?
No,
And to be fair, he told you multiple times in that interview that he was in shock about what happened and didn't remember everything. Is that right?
correct.
Okay, and that, based on your training and experience, that wouldn't be unusual, would it?
No,
Okay. You've had that with other people who have been complaining witnesses or victims of offenses?
yes,
And have you had that with people who have been accused of crimes?
probably.
Okay. Tom, if you can answer this. So, he never denied that he defended himself with a knife, correct?
Correct.
What he got wrong was how he got the knife, but he told you that he used it on other people, correct?
Yes,
Okay. And he told you other things that you actually found out to be true, right? Like, he had a snorkel and goggles, right?
yes,
Okay, and you found those, not you, but your police found those, right?
yes,
Okay, so that's true, right?
yes,
He told you that he was looking for Ariel's phone, correct?
yes,
You guys found Ariel's phone, right?
yes,
Okay. He told you that people were calling him I think he says the word child molester. But it's true, people were calling him names, correct?
yes,
Okay. And I think he also told you on the tape that they were attacking me from all directions. Is that right?
he did say that.
Okay. Do you, in your investigation, do you have any evidence through interviews of witnesses or anything else that that's not correct?
Objection, Your Honor, please approach.
Yes. I'll sustain the objection on foundation grounds. Mr. Trofasi, you may continue.
Lieutenant Hart, can you just give me a brief synopsis of the investigation that you've done in this case?
Yes, I interviewed Sandy.
Okay.
I interviewed Mr. Mew.
Okay.
And I coordinated the translation and transcription of Hispanic-speaking statements and 911 calls.
Okay. So the investigators who have testified, you're their boss?
I'm their supervisor, yes.
Okay. In an investigation like this, do those reports pass over your desk? Do you see those?
I would say a majority of them, not all of them.
Okay. So you're aware, well, tell me if you're aware, that there has been multiple interviews conducted in this case by your investigators, right?
Yes,
Of multiple eyewitnesses or people who claim to be eyewitnesses what has happened, right?
Yes,
And have those reports passed over your desk?
not all of them.
Have some of them passed over your desk?
Yes,
Okay. Based on the information that you have seen, the reports that you've seen, the interviews that you've conducted, any other evidence that you've been able to look at, my question to you was, is there any evidence that contradicts the statement that Mr. Mew had made to you on that interview, that he was surrounded in all directions?
I don't know.
You don't know?
Well, I haven't read every single report for this case.
On the stuff that you've read. I can't ask you about things you don't know. What I can ask you is on the things that you've read, the reports that you've reviewed, the interviews that you've conducted, there's nothing that contradicts his statement that he was surrounded, right?
Your Honor, I'm going to object because it's fair against the time. There's a 3-minute period here.
Overruled. Can you answer the question?
So your question is if I've seen any of the reports that I've read?
I'm asking you if any of the evidence that you've reviewed in totality, whatever you've reviewed in the totality, okay? There's nothing in the evidence that you've reviewed, the witnesses that you've spoken to, that contradicts Nick's statement that he was surrounded when he told you that, right?
Yeah, he's the only interview I've conducted.
You've reviewed other reports though, right?
Yeah.
Okay. And I think he said in his interview with you that he said, all I want, guys, did you find a phone, right? You remember that?
Yeah.
Okay. And through testimony you've seen and witness statements that you've read, you know Joanne Cockfield's holding a phone, correct?
Yes.
Okay. And through your investigation, you'd agree there were no little girls in that area at the time, right?
Not that I'm aware of.
Okay. So would you agree there's nothing factually in terms of evidence that you know about that would support the claim that people have said that he was looking for little girls? There were none, right?
There were none. Nope.
If you would have suspected he was impaired, would you have followed up on that?
Yes.
Okay. How? I mean, just tell me what you would have done.
Well, I probably would have applied for a search warrant for his blood.
Okay. Because that would, if a person's intoxicated in this in the situation that happened, this incident, knowing that would matter to you, right?
Yeah.
Just one moment, Judge, I think.
Yes.
It's all, Judge. Thank you.
Mr. Smestad.
Lieutenant Hart, as you were interviewing Mr. Mew, did he at any point say anything about being strangled?
No.
Did he say anything about having an injury or pain to his neck or throat?
No.
Did you see any injuries on his face at all?
No.
How many feet away from him were you during that interview?
However wide a table is,
Can you describe the lighting in the interview room?
it was well lit.
Did Did Mr. Muse say anything about hearing anybody threaten him with a phrase similar to, "You've got 10 seconds"?
No.
At the time that you interviewed Mr. Muse towards the end, when he asks you what happened, did you know that he had already been informed that he was under arrest for homicide and attempted homicide?
Objection, speculation.
I'm asking if she knew.
I'll sustain the objection. You'll have to rephrase the question.
Did you have any knowledge as to what he had been informed of with regard to charges when he was arrested?
No.
When Mr. Muse asked you what happened, and you told him that someone had died, what was his response?
I believe he said, "Oh no."
Did he appear to be surprised?
I'm going to object.
Sustained speculation.
At one point in the video, you see him put his head in his hands.
Yes.
Did you see any tears?
No.
Mr. Trofsky asked you about the stress that a victim can undergo, and in your opinion, you said, yeah, that sometimes that happens. The same go for 17-year-old kids who saw their best friend get stabbed to death?
Yes.
And same goes for the people who actually were stabbed?
Yes.
Did Mr. Muse ever waver in his claim that he did not himself have a knife on the river?
No.
Do you know how many times he denied having a knife on the river? If you remember?
I don't remember, but it was more than once.
Did he ever waver in his claim that two of these boys pulled knives on him?
No.
Did he appear to recall details of how that all happened?
Yes.
At one point in the video, he asked if anybody had found a phone. Do you recall that?
I do.
You know what phone he was talking about at that point of the interview?
Objection, speculation.
Sustained.
During your interview, did he specify whose phone he was looking for?
Yes, I believe he told me it was Ariel's.
Nothing further.
Mr. Trofsky?
Because he didn't tell you anything about hearing somebody say you got 10 seconds, you're not saying that means it didn't happen, right? That somebody didn't say that.
Right.
Okay. And because he didn't mention to you that he had been strangled, you're not saying that that means it didn't happen, right?
No.
Or complain about neck pain or being hit in the face. You're not saying that because he didn't say he wasn't hit in the face, or however he was hit, you're not saying because he left something out that that didn't occur, right?
Right.
That's all.
Thank you, Lieutenant Hart. You may step down. Mr. Anderson, does the state have more evidence?
No, Judge.
All right, the state rests. Members of the jury, there are a few items that I need to discuss with the attorneys in private, so we're going to have a recess. This may be a little bit longer than some of the earlier recesses, so please be patient. We will get back to you before the lunch hour. Please take the jury out.
All rise for the jury.
Please be seated. We are outside the presence of the jury. I am meeting with the attorneys and with Mr. Mew in open court. Mr. Nelson, is there anything that you want to address? Yes, Judge.
So Judge, I would, and I'm not looking at the information, so I apologize. But as it relates to, I'm going to do it by the names.
Yes.
As it relates to Dante Carlson and Anthony Carlson and Riley Madison. Those three people, Mr. Mew is charged with an attempted homicide on those counts. And in reviewing the requirements for an attempted homicide, and this will be short, Judge, I'm not going to waste your time, but what it says is it requires the defendant did acts toward the commission of that crime which indicate unequivocally. And unequivocally is defined as it means no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. So, which indicate unequivocally under all the circumstances that he had formed that intent and would have caused the death of the intended victim except for the intervention of another person or some extraneous factor. Extraneous factor is defined as something outside the knowledge of the defendant or outside of the defendant's control. There has been testimony from Dr. Meyer yesterday. Dr. Meyer was only asked about one of these people, and that was A.J. Martin. And that question to A.J. about A.J. Martin was, without medical intervention, would A.J. Martin have died? And his answer was yes. As it relates to Dante Carlson, my recollection of the evidence was he said he fixed a hernia. There was no testimony as to anything regarding Anthony Carlson. As it relates to Riley Madsen, I believed there was questions surrounding that, and what he had said was that eventually she could have suffered an infection. I think he mentioned sepsis that would have occurred. But I would argue to the court that based on the evidence, and you have to take the evidence under all the facts and circumstances, that based on the actions of Mr. Mew, based upon the testimony regarding the injuries to the people I'm mentioning, Dante Carlson, Anthony Carlson, and Riley Madsen, I would argue that it is not possible to say that no other inference can be drawn, but that he intended to kill those people. And there's actually no information that Dante Carlson or Anthony Carlson would have died from their injuries anyway. So without any other extraneous factor which would have prevented Mr. Mew from doing this. So we have one, you heard the evidence, you can figure out how you would view the movements. But I would argue that the facts and circumstances presented to the court and to the jury here do not support the claim that he unequivocally intended to kill these people. Riley Madsen said she thought she was punched. She initially believed it was a punch. And I don't think although not the deciding factor, I don't think their injuries support the claim of an attempted first-degree intentional homicide. So I would move for dismissal on those, whatever those counts are, Your Honor.
Thank you. Who's going to argue for the state?
I can, Judge. So I think this case, it's similar to if you compare it to, say, a shooting case where somebody walks up to somebody, shoots them in the torso, in the chest, and it happens to miss vital organs, and they just need stitches. I think it's a difficult argument to make that they didn't intend to kill them, and it's the same thing here. He's stabbing all these people in the area vital organs, veins, blood vessels. His intent is based on all facts and circumstances. He sliced AJ up the belly. He stabbed Isaac directly in the heart. He stabbed Tony, Dante, and Riley in the area of all the vital organs. Dante was stabbed right below where his heart is. Tony was stabbed twice. One he blocked. That's certainly something out of Nikolai's control. Riley was sliced across her side, damaging her stomach and her diaphragm. And so I think given all the facts and circumstances, there's clearly enough for it to go to the jury. But for the chance that he didn't happen to hit vital organs, I think that the jury can still conclude his intent was to kill them.
All right, this motion is being made after the close of state's evidence. There is a particular standard that I have to apply. In fact, the motion must be denied if, considering the state's evidence in the most favorable light, the evidence adduced, believed, and rationally considered is sufficient that pertain to this motion. I am satisfied that the motion must be denied. The state has presented credible evidence that Mr. Mew formed the intent to kill by inserting a knife into the torso of the three individuals during a physical confrontation. The torso, as we all know, contains vital organs, blood supply, nerves, and other anatomy that, if injured, could lead to death. I believe that the risk of death is self-evident when faced with a knife stab to that area. There was an intervening event, and I think the state has presented evidence about the individual's fortitude to defend themselves, to resist injury, the intervention of first responders, and intervention of formal medical treatment in a hospital setting. So for all of those reasons, I am satisfied that the state has presented sufficient evidence to warrant the case to continue. The motion is denied. Is there anything else at this moment?
Judge, it's the defense's opportunity. The defense intends to call Nick Mew to testify. If we could just take a 5-minute break to make sure I go through the colloquy with him privately, and then we can come back and do that here in court.
Very good. Have your conversation. We'll come back at 11:05.
And good morning again from the Fox 9 streaming studios. You, of course, are watching our gavel-to-gavel coverage of the Apple River stabbing trial from Hudson, Wisconsin. We have reached an absolutely critical stage in this trial. The state has rested its case. You just listened there. The defense had moved to dismiss the attempted murder charges against Nikolai Mew is facing for the stabbings of what I would describe as the 3 lesser injured, though Riley Mattson did suffer some horrible injuries from the knife wound that day. But Riley Mattson and the 2 Carlson brothers, Tony and Dante, the judge denying the motion to dismiss those counts. So those counts continue right now. And then in that last moment there, Aaron Nelson, defense attorney, confirming Nikolai Mew is up. This is the defense case. My understanding is he is their last and final and only witness to go today. We've taken a couple of their witnesses out of turn. Nikolai Miu spending these few minutes during this recess getting ready to take the stand, and I could not think of another attorney I would want to bring in right now to get some thoughts from. This is Eric Nelson. We've introduced him several times during this trial. Eric represented a young man in Wisconsin about a decade ago, self-defense claim, knife attack along the St. Croix River in Wisconsin, and won an acquittal there where his defendant got up on the stand, Levi Aker Kendall, and told his story, and the jury eventually found Mr. Aker Kendall not guilty. Eric, Nikolai Miu now just minutes away from testifying. What is going on between him and his attorneys during this 5-minute recess?
Right now, they're just making sure that Mr. Miu does fully intend to testify. They're going to have to go through a colloquy, which is just making sure that he understands all of his rights, his right to remain silent, the fact that he can testify if he chooses, and if he chooses to testify, he'll be subject to cross-examination. So I think what we'll see when the court reconvenes is that Mr. Nelson, Aaron Nelson, will go through the rights that Mr. Miu has, and Mr. Miu will have to make a formal waiver of those rights. That's what they're just discussing kind of last minute. Are you sure you want to do this? And discussing the strategy and the importance of his testimony.
And of course, I may be jumping the gun just a tad, but the defense did say during openings he was going to testify. The jury was out of the room there. I do want to point out there is still a last minute, if he gets cold feet, they don't think it's right, but coming out of that damaging, interrogation where he's making up stories and lying and misleading the investigator, someone has to clean that up. Is it the right call to put Miu on the stand right now?
I think it's the only call that they can really make at this point. Short of him not testifying, I mean, again, we got to get inside of his mind. We have to know what he was thinking that day as well as during that statement. So it's going to be an important decision. Of course, it is Mr. Miu's decision. It's not his lawyer's decision. It's his decision, and he's got to be the one to make it.
2 years he's waited to tell this story. I know we've spoken about how, at least if not in these 5 minutes, they're not certainly, putting pressure on him, pretending to do cross-examination at this point. That's all been done. Could you just describe how perhaps the attorneys may be working with a client like this over the last couple weeks? He's been in jail. He's been locked up for nearly 2 years. We don't know, how he's doing mentally. Obviously, we can just see physically he's lost a lot of weight. He's lost a lot of color from what we've seen from the day of the stabbing. But what has the last few days, or maybe the buildup, have they been meeting after hours to practice, to talk about this, to go over certain questions?
I would venture the vast majority of that was done prior to the trial, where they have reviewed evidence with their client. They've talked about the types of questions. They've likely done mock cross-examinations, mock direct examinations. And what's happened during the course of the trial is, yes, I would expect that the lawyers would be meeting with Mr. Miu after hours in the jail, kind of going through the day's events, talking about the evidence, and making sure that they are going to address every single thing that needs to be addressed.
Eric, before we took that break, you heard defense counsel attorney Corey Turafisi. They're asking to dismiss the 3 attempted murder counts against sort of the 3 lesser injured, though, as I pointed out, Riley Madison was badly injured on that day and spent several days in the hospital, surgery, diaphragm damage, but perhaps the 2 Carlson brothers lesser injured. Is that type of argument made in every case? You try to get rid of a couple of these counts, or did the defense really have a sound argument on those 3?
To testify.
Has anybody forced you or threatened you into making that decision?
No.
Has anybody made any promises to you or offered you anything of value to arrive at that decision?
No.
Are you presently under the influence of any drugs or alcohol?
No.
Do you suffer from a mental health condition that is affecting your ability to think or process information today?
No.
Have you had enough time to make your decision?
Yes.
You need any more time?
No.
Have all of your questions been answered by your attorneys?
Yes.
At this time, I find that Mr. Mew has made a free, voluntary, and intelligent decision to waive his right of silence. He's choosing to exercise his right to testify and present evidence on his own behalf. Mr. Trofasi, Mr. Nelson, how do you intend to proceed from here? Will Mr. Mew be the next witness, or do you have others?
Yes, Judge, the plan is to call Mr. Mew. I have a PowerPoint that I would like to go through. The PowerPoint includes exhibit number 104, which is the photo of the map, and includes exhibit 108, which is the photos of Mr. Mew in the hospital previously entered. There's 3 screenshots from the 9-second video in exhibit number 2, and then the rest of them are screenshots from the frames in the video, which are from exhibit number 2. So all of the items in the PowerPoint have already been exhibited. I've tried to put up some white screens in between so that pictures don't linger. So my preference would be to just have it on my computer the entire time, and if there's a long break, I can move to a white screen.
Okay, because what we have been doing is once the video is no longer being used, we usually take it down.
I'm not going to use the video at all. I'm just using screenshots.
But the monitor, I meant.
Sure. However, I mean, again, my hope is to not have things linger. If you want to take it down, obviously, court controls that. If you want me to move it to a blank screen, just tell me to do so, and I will.
Okay, let's just follow our regular practice, and hopefully the two of you will get into a rhythm, and it'll be presented seamlessly. Any objection to the material that he intends to present?
No.
Sounds like it's already been received into evidence. Is there anything else that we can do outside the presence of the jury?
Real quick, we didn't make a record. We ended the video of the jail interview of Nikolai at 56 minutes and 10 seconds. 2 other things regarding his testimony. Because he's waiving his right to remain silent, the rest of Sheriff Knutsen's body camera would be a proper subject for impeachment, so we plan to publish that during his cross. And then we have a number of jail phone call translated transcripts, which defense also has. I think it's going to be difficult to cross him on that without saying their jail phone calls. With Sandy, it was easy because she was the other person on the call, so we could just ask her what he's told her. With jail phone calls, part of the relevance is how long it's been, because part of their claim is, well, he was in shock. So if it's 6 weeks later that he's saying things, I don't want the jury to wonder if we have his phone wiretapped or something like that. I think they should, and I think frankly it's probably obvious. I mean, we just did his jail interview. Some of them had raised their hands that they'd seen some of this on the news. It's been well published that he is in custody, so.
All right, let's break this down. The first part was the rest of Sheriff Knutsen conversation. Mr. Nelson, any objection or comment?
I think Your Honor's already made rulings on that, so no additional objections other than the objections that we've originally filed, and Your Honor's made rulings, and I believe your ruling was, it was a Miranda violation, but it was voluntary, and therefore that's Your Honor's ruling, and I think the state's recitation of the law is correct.
Yeah, I don't remember making that express ruling because I've been holding back because I don't want to start judging things that aren't performing. If I made that suggestion, it was intentional because that's where this was all heading. I mean, I saw the video. I made the ruling. I did not see anything in the video that would suggest that the statement was coerced or forced or made under some sort of threat. It was a voluntary statement. So although there was a Miranda violation, Mr. Mew's decision to testify means that the balance of the statement could be used for purposes of impeachment. So I will allow the state to show the balance of the Sheriff Knutsen video. And then the second part.
Jail calls, Judge?
Oh, jail calls. Yes.
I expect my direct's going to be 45 minutes, so I expect it's going to take us to lunch. So we can certainly take it up now, or we can take it up over the lunch hour. I'll defer to Your Honor, but I'd like to be heard on it whenever we take it up.
How long are the jail recordings?
We wouldn't be admitting the actual recordings because they're in Romanian. So we have, they're translated by a translator. He's on our witness list, so if Nikolai denied saying the things in there. We'd call him on rebuttal more than likely. But it'd be using the transcripts that translator prepared from listening to the jail phone calls for impeachment.
So
when we get there, we're going to object to those transcripts because unlike the Spanish transcripts, which have transcribed the Spanish words and then translated the Spanish words into English, these transcripts leave out the Romanian words. And so we're not agreeing to the accuracy of the transcripts in any way, shape, or form.
Okay. So what I'd like to do then is get through the direct examination, break for lunch, hopefully at the conclusion of the direct exam, and then we can take up the outstanding matter of cross-examination over the lunch hour. All right. Anything else?
No.
All right, hearing none, let's bring the jury in.
All rise for the jury.
All right, please be seated. All right, thank you, members of the jury, for your patience. We are ready to resume. The state has rested its presentation of evidence. Now we'll turn to the defense and see if they have evidence to present. Mr. Nelson.
Judge, the defense calls Nick Mew.
Mr. Mew, please stand. Raise your right hand. The clerk will administer the oath.
Do you swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat in the witness chair. Mr. Nelson.
You're the Nick Mew we've been talking about for the past 7 days?
Yes, sir.
Nick, I want to right away talk to you about exhibit number 104, if I could have the screen. You were on the Apple River on July 30th?
Yes.
I want to ask you about this exhibit, which says it's from frame 2592 at 149 into the video. Have you seen this before?
Yes.
Do you remember that time in your life when you were on the river in that position as shown in that photograph?
Yes.
Sometime after that, did something happen to you?
Yes.
Were you punched?
Not,
attacked?
not
After-
before
sometime
that.
after this, were you
After
punched?
that, yes.
Okay, I want to talk about the time between this and the time that you get punched, okay?
Okay.
Exhibit number 104 there is on the, with it. Where are you on that?
I'm standing in front of two ladies.
In which, if you were going to just describe the symbol on exhibit 104 symbolizing you, which one is that?
The one with the M.
Okay.
Do you
What
want
color?
Do you want the
Blue.
annotator?
At that point in time, you said there's two people in front of you. Who are those two people in front of you?
A blonde lady to my left and a red hair lady to my right.
Were there other, does this accurately reflect how you remember roughly people in general around you?
Yes.
The blonde lady in front and the other woman, you understand now that through the trial that the blonde woman is named Madison Cohen?
Yes.
Can we use her name when possible?
Yes.
And the, you said red-haired woman, her name's Riley Madison. Can we use her name when possible?
Yes.
Possible? So when Riley and Madison are standing in front of you at that point, just before you get punched, right? What are they doing?
They're yelling at me. At one point, they were pointing downriver and saying, go, go, get away.
What are they doing with their hands?
They're touching me.
When you say touching you, is that something gentle?
No, they're pushing. Madison, she pushed against my left shoulder. She pushed against my chest. She was pointing her finger right at my face. She was yelling at me, very close to my face. Riley had one of her arms, I believe it was left hand, on my right arm, squeezing and pushing me back.
And when you just gave that description, you put your hands distance apart. Can you show us that again? How far away were they?
About a foot.
Okay.
Less than a foot.
You've heard it described through trial as in your personal space. Would you agree with that?
Yes, right in my face, I would describe.
When that was happening, what did it sound like to you?
The volume was very, very high.
Let me ask you about how your body was responding in that moment when people are pushing you, poking at you, the volume is high. How's your heart? Could you tell us about what your heart rate was?
Oh, yeah. My heart rate was getting really high. My breathing was getting very high. I was...
How about your vision? Did you have normal vision in that moment?
No. At that moment, because of the situation, I was getting tunnel vision.
And can you describe what you mean by you say in tunnel vision?
I couldn't see peripheral vision, but I could see center and right before my eyes.
How about hearing? Could you hear the noises?
I could hear the volume very high, but I couldn't understand what they were saying. The noise became garbled. I mean, the sound became garbled.
Did you feel threatened at that point?
Yes.
Did you have your knife in your right hand?
Yes.
What did you do with your left hand? Tell us what you did with your left hand.
Yeah, with my left hand, I pushed her away from my face.
Can you show us what you did with your left hand? Why'd you do that?
She was very close to my face. She was in my personal space. She had been there for a while, and I felt threatened.
Did you intend to harm her in some way?
No.
Did you try to harm her in some way?
Absolutely not.
Do you know where, if at all, you had contact with her body when you raised your left hand in that manner?
No.
Do you think you had contact with her?
No.
Okay. I want to take us out of that space now for a second, okay, Nick?
Okay.
If I could have the screen again. You were here in court when we talked about, when we watched the video of you speaking with Brandy Hart, is that right?
Yes.
And I think you told her about your health condition. Can you just tell the jury now, what was your health like on July 30th of 2022?
It was very poor.
Okay.
Yeah.
Had you, I think you mentioned to her again, had quadruple bypass surgery before?
Yes, sir.
And when did you have that?
2020, about the same month, so about August.
Showing you here what's been marked as exhibit number 108. Can you tell us what those are pictures of, starting just on the left?
Yep, on the left it's me right after the surgery, holding a red heart pillow against my surgery.
What was the purpose that you knew of for that red heart pillow?
That was to protect my surgery from hits, bumps.
Was that something that the hospital provided? It looks like there's like almost a picture of heart and lungs on there.
It is. The hospital provided that.
And then the picture in the middle, what is that?
My first walk, my new life.
Did it take you some time to recover and be as active and mobile as you were before?
Oh, yeah.
Do you think you ever reached the same level of mobility and fitness that you were prior to the quadruple bypass?
Never.
What's the picture of you on the right there? You can tell us.
My baby.
Okay. Is that a dog?
Yeah.
Is that dog important to you?
My angel.
And that's the cushion's helping you to enjoy time with her, but still keeping your chest safe.
Yes, sir.
Okay. You've had other surgeries in the past, is that right?
Yes.
Did you have a hernia surgery?
2 hernia surgeries.
Have you had back surgery?
Yes.
And again, in general, would you consider your fitness on, if you were going to put it on a scale for July 30th, what would you consider your overall health and fitness on July 30th of 2022?
With my weight and very poor.
I want to ask you now about moving on to the Apple River on July 30th, okay?
Okay.
On that, this was a planned trip, is that right?
Yes.
Did you get a call from your friend Ernesto sometime before that trip?
Yes, sir.
What was that call about?
He wanted to remind me to bring my knife to cut string when we tie the tubes together.
Okay, when you say, do you have a pocket knife?
Yes.
Okay, can you tell us about that pocket knife?
I owned it for about 10 years. I have it a lot on me. I use it as basically a dual tool. I call it my Swiss Army knife, basically because I use it as a screwdriver. I cut insulation when I do electrical work. I use it pretty much everywhere.
Okay.
I'm an engineer. My tool.
Is it something that you've carried on your person, I don't want to say all the time, but somewhat routinely?
Yeah, when I knew I was going to work on something or need it for something, yes.
Okay. Now I want to skip ahead again now to the river, okay? At some point, did Ariel lose his phone?
Yes, he did.
Did you go to look for that phone?
I volunteered to go look for it.
When you went to go look for that phone, what were you wearing?
Before that?
Nope, right when you left your group to go look for that phone, what were you wearing?
So I took my goggles, my snorkel, and my swimming trunks.
Did you have anything on your feet?
Yes, I had, on my feet, I had a pair of really, really torn up sandals.
Can I approach, Judge?
Yes.
Showing you what's been marked as Exhibit 113. Is this a packet of 9 photos of your sandals?
Yes.
You've seen those?
Yes.
Does that accurately show the condition of the sandals that you had?
Yes.
Can you just move to the admission of Exhibit 113?
Any objection?
I don't think I've seen them, Judge, if I could take a look at it.
Yes.
Oh, pardon, never mind, Mr. Anderson.
All right, 113 is received.
These weren't taken by you, were they?
Pictures? No.
No, these were taken by the Sheriff's Department, correct?
Yes.
Permission to publish, Judge?
Yes.
Can I, just because we're going to go through the PowerPoint, can I?
Yeah,
pass
just
them?
pass them to the jury.
Can you use your words? I know we have a picture that better does it, but just briefly, describe the condition of those sandals.
Horrible.
Okay.
They were just coming apart. I couldn't walk on them unless I tried to mend them.
Okay.
As you can see, I used string, leftover string to mend them.
When you left wearing those sandals and your shorts, did you have your pocket knife with you?
Yes.
Where was it?
In my right pocket, clipped to my...
Did you have that there pretty much all day?
Yes.
You were here when we watched the video of your interview with Brandy Hart, is that right?
Yes.
When you spoke with Brandy Hart, were you truthful to her about the knife?
No. I lied about the knife.
Was that your knife?
Yes, it is. It was.
Did you bring it with you when you went to go look for the phone?
Yes, I did.
When you went to go look for the phone, did you have any intent to harm anybody?
No,
Why'd you go leave your group?
to go look for the phone.
Okay. At some point, did you have some contact with a group of teenagers?
Yes,
And you were here in court when we saw the 9-second video, is that right?
yes.
I want to show you just a couple of slides from that, if I could. Do you see those slides up there?
Yes,
Are those from that video?
yes.
What are you doing in those 3 slides in general?
I was scanning the water looking for the phone.
And are you, in that position, are you walking upriver or downriver?
Upriver, away from that group of boys.
Did you hear them say some things to you?
Yes,
Prior to your walking upriver and them, did you hear those words that I have written on that slide?
yes.
Prior to your hearing those words when you were walking upriver, had you had verbal contact with that group?
I think
They-
so. They asked me what I was looking for, and I told them I'm looking for a phone, a lost phone.
Did you ever tell them that you were looking for little girls?
No,
Were you looking for little girls?
absolutely not. It's pathetic.
When you, at the end of this, when you watch the video, at the end of the video, where I'm not going to play it, but do you remember what you did right there at the end?
At the end, I was walking away.
Did you eventually turn around and face in the direction of the group that was yelling at you and calling you a raper?
Yes.
When you,
Yes. I'll sustain the objection. The question was leading. Please continue.
what did you do at the end of the video?
I was walking away.
At some point, did you ever become in a position where you were looking at that group of teenagers that had yelled at you?
Yes.
What did you see when you were looking at that group of teenagers after the end of this video?
I saw one of them holding a phone in a bag, and I believed it was what I was looking for, so I turned around and I started approaching them.
Why did you approach them?
I wanted to get a closer look at the phone to see if it was the one that belonged to Ariel.
Did you eventually get near them?
Yes, I started walking, then I rushed the pace, stumbled, and fell on my knees, held on to their tube, at which point I lost my goggle and snorkel kit in the water.
You saw in the video, or excuse me, you saw during your interview with Brandy Hart that you said things different than what you just said now about what happened to your snorkel and goggles.
Mhm.
Is that right?
Yes.
Is your memory sometimes different than what you see in the video?
Yes.
Was your memory, in your memory, what happened to your goggles?
In my memory, the goggles got
knocked away?
Knocked away, yeah.
Objection, leading.
So, got,
One second. When there's an objection, just wait on your answer. It is leading, sustained. Next question, please.
His answer was stricken.
It's a leading question. Let's move on.
Is your memory perfect?
never.
Now that you've watched the video, do you realize that you were wrong about that?
Yes.
What happened to your goggles?
My goggles fell in the water.
When they fell in the water, what did you do?
I started looking for them, searching right where they fell.
If I, oops, it's on already. Showing you here some slides, 220, 225, and 279. Can you tell us what you're doing?
I'm searching for the goggle kit.
And where are you in relation to the 6 teenagers' tubes? Are you on the side? Are you upriver? Are you downriver? Are you in some other position?
I'm upriver. So, yeah.
I'm going to then show you another group of slides, 575, 600, and 625. What does that show you doing?
So what I did from that point, I went around the inner tubes to the other side, and I continued looking for the goggle and snorkel set.
Why did you walk around from the one side to get to the other side of the tubes?
Well, I thought that the water current would bring him over to the other side, and I was walking away from the boys at the same time.
Okay. During that time that you walked in that direction, did you have any physical contact with them?
No.
Were you confronting them?
No. Didn't say a word.
This next set of slides, what does this show you doing here?
I'm walking away from the group. Still,
go ahead.
Still looking for my goggles at that time.
When you were doing that, did you ever hear the kids say anything?
They gave me a warning.
What'd they say?
You got 10 seconds.
In response to that, what did you do?
I ignored them, and I actually continued doing what I was doing.
Okay. I can show you the next set of slides here. Were you in a position to see here 963, 1140, and 1155, what the teenagers were doing behind you?
They were getting closer and closer to me. They were walking towards me.
Were you in a position to see that? Was that behind you, or had you turned around?
Well, I could hear their voices. I could hear that they were getting closer. At some point, I may have turned my head and witnessed that. They're coming towards me.
Showing you 1170, 1213, and 1284. What's happening here?
I'm at an angle to them, but I could say I have my back at them, still scanning the water, and they were right behind me. They got that close. Within seconds, they were right behind me.
At some point, did you see other people from another group?
Yes.
What did you see?
I saw what seemed to me at the time adults coming over from the other side of the river.
And when you saw adults coming over from the other side of the river, what did you do?
I walked towards them. I walked towards this. The first one was Madison.
When you walked towards Madison, where were the 6 teenage boys that had been yelling at you?
They're following me.
Okay. Were you in their path as you walked across the river towards Madison?
No.
Did they have as far as you know, did they have a clear path down the river if they wanted?
More than plenty.
Can I? Showing you this next group of photos, what's going on here?
So in this frame here, the first adult that came to me was Madison. She already had her finger pointing downriver and yelling at me and used some awkward words, ordering me to go down.
We see it looks like you're doing something with your right hand. Do you remember, what are you doing with your right hand?
Yep, I was trying to explain to her what I'm looking for.
When you tried to explain to her what you were looking for, did you get the impression she was listening to you?
No, her voice was too loud to...
As to what Madison had as an impression.
Okay.
Hold on, wait a second. Sustained. Speculation.
I'm asking about his impression, so did you get the impression that Madison Cohen was going to listen to your words?
No.
Why not?
Because she was too loud. She never stopped to give me a chance to talk, and she kept pointing and ordering me to go downriver.
We've all heard the tape, but was she using polite language?
Polite? No.
Did you hear anyone saying anything behind you when you walked over to Madison Cohen?
Yes, they're all calling me names.
Okay. Showing you the next set of slides here, 1776, 1840, and 1824. What are you doing here in this set of slides?
I'm turning my back towards Madison and the rest of the people.
Why did you turn your back to Madison and the rest of the people?
It felt to me like I couldn't have a conversation with her at that point. She was not listening, and I didn't want to interact any further.
Had you at that point found your snorkel or goggles?
No.
Had you at that point found the phone?
No.
Did you hear anybody saying anything while you stood there with their back to them?
Oh, yeah.
What did you hear?
They were still yelling, he's looking for little girls.
Were you looking for little girls?
Absolutely not.
When you heard them, did you consider that to be a lie?
Objection, Your Honor. Leading.
Sustained.
I asked, did you consider that to be a lie? I don't.
Yes,
think
of
that's
course.
Hold on, please.
Don't think that's legal.
I sustain the objection. Please move on.
When you heard that, did you consider it to be truthful or did you consider it to be untrue?
Untrue.
And when you heard someone say an untruth about you, did that change how you were feeling?
I felt frustrated. I felt annoyed. They kept saying it over and over, so it annoyed me and frustrated me.
And when you heard them say this untruth about you, did it appear to you as if the other group that had come over agreed with what these the teenagers were yelling about you?
Objection, leading.
Sustained.
Did you think anybody in the other group was going to help you or listen to you when you were being called these names and accused of being a pedophile?
Objection, leading.
Sustained.
How did you feel?
Well, I felt overwhelmed at that point. I felt still annoyed, frustrated. I felt like she wasn't listening. She was the adult I thought I was going to reason with or get help from. She obviously didn't even attempt to reprimand the children from yelling.
Showing you another slide here, some 1838, 1846, and 1865. Is that you?
Yes.
What are you doing?
Judge, can we approach?
Yes. Just one moment. Ready? Okay.
Yes, sir.
Let's continue.
Showing you photos 1838, 1846, 1865. What are you doing in those? Do you remember what you were doing?
Yeah, I had my back towards the group of people.
In the two photos there, which direction are you looking?
I'm looking downriver.
Okay. Are you looking at, there's two different groups, if I recall, from Exhibit 104. Is that right?
Yes,
One came from one side of the river and the other one's on the other side of the river.
correct.
Where are you, in the photo on the upper left, are you looking at one particular group as opposed to another group?
Yes, I'm looking at the boys group
And why are you looking at the boys group?
because they were yelling at me.
And what were they yelling at you?
They were yelling things that were not true and pointing at me.
When this, I want to, after that happened, showing you the next group of slides, 1875, 1883, and 1889, do you remember what Madison did, if anything, to you?
Yeah.
What did she do?
She grabbed my right arm and she pulled me towards her and I lost my balance, so I moved towards her.
Did you consider that in that circumstance to be a gentle or a gracious touch?
No, that was not a gracious touch. No, not at all.
Had she been using any gentle or gracious words with you?
Not that, no, not that I remember.
In those photos, can we see the footwear that you were wearing on that day?
Yep, those sandals that we saw earlier.
Did you have confidence in your footing in that area with those sandals?
Objection, leading.
Sustained.
How did you feel about your footing in that area?
Very unstable.
Want to show you the next set of slides here. Do you remember what you say to Madison after she pulled on your right arm?
Yeah, I told her not to touch me
And why did you tell her that?
because she pulled on me without my invitation.
Did you say that in any particular tone?
No, not in a mean tone, but I made it sound so she could hear me. Don't touch me.
Okay. Why didn't you want her to touch you?
I didn't give her permission to do so.
Sure, but why did you not want to give her permission to do so?
Because she was one track mind. She just wanted to get me away from that, point me downriver and tell me to go there.
What's your comfort level at this point?
On a scale from 1 to 10, comfort level is very low.
Okay. Are you, if you had that same thing, a scale of like a fear scale, a 1 to 10 fear scale, right? And so
Yeah.
with 10 being the most fearful you've ever been in your life and 0, let's call 0 to 10 being the most safe you've ever felt. Where are you at here on a fear scale?
In that particular,
Yeah.
about 1.
Okay. So you're more uncomfortable but not necessarily afraid, is that what I understand?
Correct.
Where was your group in relation to you then?
Was upriver.
And did you do anything in order, in relation to your group? What did you do?
I turned to them and I called them. I was trying to call them to come over and help me.
Are these slides, does this 2127, 2140, 2131, what does that show you doing?
I was waving at them and calling them to come over.
When you say you were calling them, did you do something physical or did you do something verbal or did you do both?
Physical.
Did you make any verbal comments at that point?
No.
Why not?
It was very loud. All around me was very loud. I don't think that anybody could have heard me 100 and some feet away.
With everybody else yelling, did you think your yelling was going to de-escalate or escalate the situation?
When everybody's raising their voice, I don't think having another raised voice would help the situation.
After you raised your hand to call for your friends, did you see Madison Cohn doing anything?
Oh yeah, she was looking towards her group, and then she waved to them to come over to her.
Is that what we're seeing here in 2261, 2262, and 2263? What do you see?
Yep, she's calling her group over.
Did you remember when she called her group over, did her group respond?
Yes.
Did they join that?
Yes.
Showing you now these slides, is that what you saw?
Yes.
I think we asked you questions before about Exhibit 104 with you with the blue dot and the other red dots. When you were, were you standing there with other people around you?
Yes.
When you were standing there in that moment with the other people around you after you've called your friends once, was that other group, did they appear to be afraid to you?
Afraid from me?
Afraid. Did they appear? When you look at them, do they look like they're in fear?
No, absolutely
What does it look
not.
like to you?
They're all laughing and enjoying themselves.
At whose expense?
At my expense.
And
Speculation as to what these other.
Sustained. Speculation as to what other people think. Next question.
how did you feel in that moment when they were around you saying those things? Did you think they wanted you to join in their laughter?
No,
Did you want to join in their laughter?
no, absolutely not. It was
Where, if this fear scale is going, is it staying at 1 or is it moving in a particular direction?
It's creeping up.
Showing you another set of slides here, 2328, 2311, 2382. Do you remember, what do you remember about that?
I remember the young boys are yelling, pointing at me, saying things that are not true.
Were you able to see, like in this next slide, this 2429, 2440, 2401, were you able to see as you stood there what everybody was doing? And were you able to scan and see that?
For a brief second, yes.
Okay.
They were very close. They were really close to me. I could see and hear them.
How about your fear scale there? Where is it? Where is it?
About 2 or 3.
Okay. I see in the one on the right there, you have your hand someplace. Can you tell me what you're doing with your right hand?
Yes, I'm reaching for my pocket knife.
Why?
Because at one point my fear was getting really high, and I was getting ready to pull it out.
Okay. Do you remember, other than what you've talked about, Madison Cohen pulling you, which we saw, do you remember anybody else touching, pushing, grabbing you in any way?
The 2 ladies, yeah.
Madison. Showing you here what's 2472, 2478, 2481. Do you remember what's happening in those photos?
Yes, yes. This one, the lady on my right side, she grabbed my arm and she was pushing against my arm.
And did that increase your level of comfort or increase your level of fear or something different?
So it decreased my level, the level of comfort, and increased my fear.
Do you remember, at some point, do you take your knife out of your pocket?
Yes, I do.
Do you know when that is in relation to these slides? Do you have a memory exactly of when that is?
Not exactly, but when they were pushing and poking at me, I remember I pulled it out then.
Okay. Do you remember, did you have it out before you were punched or after you were punched?
Before I was punched.
Okay. Showing you another set of slides here. It looks like do you remember doing something with your left hand?
Yeah, at that moment, I really needed my people to come over and help me, so I was trying to get their attention.
One more slide here. Do you, what's happening here in the slide?
Madison is pushing on my left shoulder and basically yelling at me right in my face.
And then on the next slide, we see something in your hand. Is that right?
That's a knife.
Why did you take out your knife at that point?
I was beginning to be afraid.
And what was it about that moment where everybody is that made you so fearful that you took out your knife?
I was surrounded. They were yelling. They had just pushed me. Well, the lady, they squeezed my arm. I mean, it seemed like they were not backing away.
Previously, you turned around. Is that right?
Yes.
Did you feel comfortable turning around in this situation?
No.
Why not?
They were too close to me.
What happened the last time that you turned around?
Nothing good.
Judge, this
Good place to break.
may as well be.
All right, it's 12 noon, let's break for lunch. You'll be taken downstairs to the assembly room again. Please, no conversation about the case amongst yourselves or with anybody else. Do not conduct any independent research or investigation. And, excuse me, do not use your devices to access any news reports or social media accounts about this trial. Please take the jury out.
All rise for the jury.
Please be seated. We are outside the presence of the jury. We had a couple of sidebars.
Mr. Mew, come, sorry.
Oh, yeah, I'm sorry, Mr. Mew, you can sit down at the table. We had a couple of sidebars concerning the PowerPoint presentation. Mr. Smestad objected to the text that was superimposed on the photographs. He believed that they prompted Mr. Mew's answers and thus formulated a leading style of examination. Mr. Nelson agreed to simply remove the text, and I believe that solved the problem. Anything you want to add?
No.
Mr. Nelson?
Yes, but I'll refrain.
I'd like to have the transcripts of these conversations so I can review them over the lunch hour and get a better understanding about what it is that you want to introduce and what the objections may end up being. So do you have those available?
Yes.
Okay, please give them to the clerk so I can read them over lunch hour. How much more do you have?
I think I'm on slide 27 of a 40-slide presentation, so 15 minutes?
Okay, so let's come back at 12:45 so I can take up the issue about the recorded conversations. Okay?
Understood.
All right, that's all.
Let's go back.
All right, good afternoon from our Fox 9 streaming center here for our Apple River stabbing trial gavel to gavel coverage. We have just seen the first portion of, they're going to divide up the defendant's testimony today. Nikolai Miu, you heard there His defense attorney has about 15 more minutes by his estimation. We'll do that after lunch. They're giving the jury lunch. They have some legal issues to talk about. And then obviously Nikolai Miu will have to face a withering, what we expect to be a withering cross-examination from the state. They too have now waited 2 years to really have this opportunity. Let's bring in criminal defense attorney Eric Nelson. Eric, your first assessment on Nikolai Miu and the story he is beginning to tell this jury.
Yeah, I mean, I think the defense is doing a good job of doing a couple things. Number one, they're doing a good job of humanizing him, you know, putting him into the perspective as far as having the heart surgery, the dog. They're making him to be a sympathetic person, physically weaker than the group of boys. And what they're also working on doing is trying to delineate between memory issues, inconsistencies, lack of recollection versus out and out lies that he told.
Eric, Aaron Nelson, no relation, right? I don't. You're not related. I don't think I've specifically asked you that question, but Aaron Nelson is Miu's defense attorney doing the direct examination of him. He literally went, you know, got his name out. You're the Nikolai Miu, but then right into the confrontation with Madison Cohen. We've talked about this ad nauseum in our coverage. But that just seems like the critical moment, and I think it was highlighted there with that strategy. If you're defense counsel, is that what you're doing? You going right to that moment physically between Madison Cohen, Nikolai Miu in the river, facing off with everyone yelling and screaming around them?
Yeah, I mean, I think it's an effective strategy. I think, you know, they've done a lot of the character type witnesses by taking people out of order. So they've able to really kind of establish a little bit more about who he is through his wife and friends. And let's just get right to the meat and potatoes of what we're here to deal with.
And before I go back and play a little bit of the testimony, just quickly, the state is objecting a lot to the leading questioning, and the judge is sustaining the objections, as if Aaron Nelson, I don't know, I mean, it must be delicate to elicit testimony from your own client. Could you explain legally what we're watching there and what Aaron Nelson has to do to make sure his questions can get legally answered?
Sure. Because he's doing a direct exam, he has to ask very general questions. What happened? What were you feeling? Versus leading questions, which generally the defense is more accustomed to doing. Leading question, the question itself implies or contains the answer that you're seeking. So it is a little bit difficult as a defense attorney to kind of switch hats and go into a direct exam. And so that these are really just sort of technical objections, you know, that the state is making, and they're being sustained because they are leading questions.
And again, before I get back to the soundbite on the witness stand from Nikolai Miu, I would just point out at different points over the last few days of this trial, defense witnesses were taken out of turn. So there were some reasons why that's important and who gets to ask certain kinds of questions. So with that, let's go back Nikolai Miu's first soundbite that we have queued up from this morning's testimony.
The noise became garbled. I mean, the sound became garbled.
Did you feel threatened at that point?
Yes.
Did you have your knife in your right hand?
Yes.
What did you do with your left hand? Tell us what you did with your left hand.
Yeah, with my left hand, I pushed her away from my face.
Can you show us what you did with your left hand? Why'd you do that?
She was very close to my face. She was in my personal space. She had been there for a while, and I felt threatened.
Did you intend to harm her in some way?
No.
Did you try to harm her in some way?
Absolutely not.
Do you know where, if at all, you had contact with her body when you raised your left hand in that manner?
No.
And I know, Eric, sometimes you don't always hear the soundbite in the way our feed is set up, but he talked about the noise being garbled. Remember, he talked about how loud it had become and the water's running, and he couldn't hear everything. He felt threatened. He had the knife in his right hand. He had his left hand, and I pushed her away from my face. I felt threatened. Again, the beginning there of his story about what he's doing as he's sort of squared up with Madison Cohen.
Right. Yeah, he is explaining a couple of different things here that are happening. One is a whole separate analysis that I think the defense covered a little bit before in terms of the tunnel vision, in terms of what he saw and hear. It's really dipping in their toe into the water of what we call force science and what happens to the human brain in a high stress situation. So you've got that kind of tail ended, and then sort of that confrontation, that initial confrontation, and he's essentially what they're doing is establishing that Mr. Mew felt threatened or was beginning to feel threatened, and used a moderate amount of force to just create a personal space that wasn't intended to be assaultive in its nature.
I know I'm going to bounce around because there's just so much to unpack from that first half hour, but how important is his health? The fact he did the quadruple bypass, he feels lousy. He's just, lucky to be alive, has, been on bed rest and, in the year or so before this. How important is the health component to what would transpire that day?
It's important. I mean, it's not the primary, focus, but it is important to take into consideration the things he's feeling, the things he's concerned about, the emotional response he's having to this situation. Again, because the jury instruction is so specific, that the jury, when they're analyzing the testimony of all of the witnesses and all of the exhibits, they have to look at it from the perspective of Mr. Mew. And the jury instruction is very favorable to the defense in this regard. So that's why they're bringing a lot of these things that may seem trivial or may seem somewhat distant, but if that's what he's experiencing and that's what he's concerned about, they want the jury to know that for sure.
And I think one thing that is new, it's been hinted at during the testimony up to this point, but why didn't you go to the group, right? We've seen that video. He's kind of free and clear. It picks up a little bit into, the initial contact with the teenage tubers from Stillwater, but he's definitely downriver, but he comes kind of marching back through the water. We now know he doesn't really like the sandals he's wearing. They're all beat up. The riverbed is slippery. But why did he go back? That I thought was sort of an important point. And I don't know if the defense purposely sort of left that sort of to be mysterious until this point. But he was clear today that the reason why he ran back is he thought he saw that lost cell phone, Ariel's lost cell phone. Remember, it's in the pouch. It gets lost. He assumes it's downriver, so he heads out in his snorkel and goggles looking for that phone. And I don't know if it's the way Cockfield was holding his cell phone off the, protective water bag lanyard, but he certainly thinks that the kids could have his cell phone, or his group's cell phone. So he goes towards them. That makes sense, right? If he thinks there's something he's looking for, a valuable object, and then that the kids might be taunting him about that, perhaps, he's entitled to go back and look. But then as he gets there, he slips. And then all of a sudden, that begins one of the first sort of steps in this kind of escalating confrontation that would then kind of blow up with Madison Cohen and Riley Madison coming over from the Carlson group. I'm just wondering, did you get the feeling like the defense kept that little sort of secret? Like, why did you run back? Or do you think that had been established enough and I just sort of missed it?
No, I don't know that it was an intentional effort on their part, but obviously a lot of the other witnesses wouldn't be able to testify about why Mr. Mew would have run or jogged or slipped in their direction, why he approached them for any reason. So, they would not have the ability to say what his intention was at that point. This highlights again, the importance of his testimony, right? Why did he jog? What was happening in that moment? And what was his perception of these events. So I think the defense intentionally had to wait for Mr. Mew to explain those behaviors. And I think that they did a really good job establishing he was looking for the cell phone. The kid was holding a cell phone. He thought he was being, offered the cell phone that they had found. On the rocks, drops the snorkel and goggles. And, then it escalates from there.
We're watching the video in the side screen now, full screen here. But you then see the snorkel and goggles go under, and then the boys, really start surrounding them. And what the Carlson group's impression of what's happening. I mean, a little step in this process, Eric, just escalates. You can think of so many moments where both sides, it did not have to result where it did. I'm curious. We haven't necessarily gotten to the point in his testimony. We know, he admits to where he pulled it out, why he pulled it out, why that moment he pulled it out. Does he have to explain why he doesn't say anything, why he doesn't offer a warning? If he cuts up and kind of holds up the knife, You know, I don't know. I mean, the perception of a juror could be no one's going to kill him right there in that river, but I've got a knife now, back up. He doesn't do that. Is that something, will he have to explain what he doesn't do in that moment once he pulls out the knife?
I don't know that he's going to have to explain why he didn't do that, why he didn't give them a warning. The law doesn't require him to give a warning to use force. The law allows even for a misperception of the potential threat to him. So he doesn't have to be accurate in what he's perceiving and viewing. I think this whole kind of chain of events right here really highlights some of the issues that lawyers deal with witness memory, witness perception. You know, you see him running towards this group, to a group of kids. It's a very strange reaction. Why is this grown man running towards us? But it also puts it into perspective from his point of view as well. So, you know, the law doesn't require him to kind of give a warning or anything. He pulls it out. I think that's a clear sign he was feeling threatened.
Let's go back. I've got another soundbite queued up from his testimony. In case you're just joining us, it's now 12:15 Central Time. We are on a lunch break. You might have heard Judge say they are coming back to discuss some legal issues at 12:45. We then anticipate the jury coming back at 1 o'clock. Nikolai Miu under direct examination, and then we would get to a state cross. Eric, bear with me. We're going to play that soundbite from this morning. Nikolai Miu testimony under direct examination by his defense attorney, Aaron Nelson.
I lied about the knife.
Was that your knife?
Yes, it is. It was.
Did you bring it with you when you went to go look for the phone?
Yes, I did.
When you went to go look for the phone, did you have any intent to harm anybody?
No,
Why'd you go leave your group?
to go look for the phone.
Okay. At some point, did you have some contact with a group of teenagers?
Yes,
And you were here in court when we saw the 9-second video, is that right?
yes.
I want to show you just a couple of slides from that, if I could. Do you see those slides up there?
Yes,
Are those from that video?
yes.
What are you doing in those 3 slides in general?
I was scanning the water looking for the phone.
And are you, in that position, are you walking upriver or downriver?
Upriver, away from that group of boys.
Did you hear them say some things to you?
Yes,
Prior to your walking upriver and them, did you hear those words that I have written on that slide?
yes.
Prior to your hearing those words when you were walking upriver, had you had verbal contact with that group?
I think
They-
so. They asked me what I was looking for, and I told them I'm looking for a phone, a lost phone.
Did you ever tell them that you were looking for little girls?
No,
Were you looking for little girls?
absolutely not. It's pathetic.
When you, at the end of this, when you watch the video, at the end of the video, where I'm not going to play it, but do you remember what you did right there at the end?
At the end, I was walking away.
Did you eventually turn around and face in the direction of the group that was yelling at you and calling you a raper?
Yes.
When you,
Yes. I'll sustain the objection. The question was leading. Please continue.
What did you do at the end of the video?
I was walking away.
At some point, did you ever become in a position where you were looking at that group of teenagers that had yelled at you?
Yes.
What did you see when you were looking at that group of teenagers after the end of this video?
I saw one of them holding a phone in a bag, and I believed it was what I was looking for, so I turned around and I started approaching them.
Why did you approach them?
I wanted to get a closer look at the phone to see if it was the one that that belonged to Ariel.
And Eric, I hope you heard that one, but that was part of the testimony about lying about the knife. He owned it there. I lied about the knife. Did you ever tell the young men what you were looking for little girls? He said, no, that's pathetic. Seemed, heartfelt, a legitimate response to some of the testimony that has come in, that it said at some point, I was looking for little girls. Seemed to swat that away, and then talk about
Mr. Nelson.
Thank you. Can I have the screen? Mr. Mew, when we finished, I think we were getting to the chronological space that we had begun the morning on, and so I want to start from there again and then move forward from there. Does that make sense?
Yes.
When I had asked you before, you talked about how you felt, but since that time, you've told the jury that you had this fear scale, okay?
Mm-hmm.
So I want to ask you about, at this time, what we see here, what you've previously described the scene, right?
Mm-hmm.
How were you feeling on the fear scale?
About a 6, 7.
Okay. And at some point, I think you told them before, but just so we can put it into the context here, did you do something in response to something that was done to you when you're standing there in this moment?
Yes. After I was pushed, and both sides, I would say, squeezed, I was afraid, so I pulled out my knife.
Okay. Did you do something with your left hand at some point?
Yes, I did.
What'd you do with your left hand?
I pushed her away. I
And when you
pushed
say you
Madison.
Pushed
away.
Madison away. Was the purpose in that to have contact with her and to get her to back up?
Yes.
Did you have a purpose to cause her pain?
No.
Were you trying to hurt her?
No.
What were you trying to do?
I was trying to push her away from my space. She was right in my space, my face.
Why didn't you just back up?
I couldn't back up at that moment.
Okay. When you say you couldn't back up, why not?
I
Because
would've-
you felt uncomfortable, or were you?
Objection leading?
Because I would have had.
Wait, there's an objection. Sustained on leading. Next question.
Wasn't done with it. Were you uncomfortable, or was there a wall behind you, or was there some other reason? Why did you feel like you couldn't back up?
I didn't feel safe turning my back on those people.
Okay. How about just taking a step backwards?
Well, I was standing my ground. I didn't move towards anybody.
Okay.
They were coming at me.
When you raised your left hand and you did that, do you recall when you pushed her away having contact with her?
I may have, yes.
Okay. Do you remember in particular where, if at all, you touched her?
No.
Okay. Would it surprise you if you touched her?
No.
Was that, in fact, your purpose in pushing her away?
Absolutely.
Okay.
She was in my space.
I want to move forward here. And you can turn the slide off, I guess. After you did that, right, did something happen to you?
Yeah.
Did people do something to you?
Yeah.
What was done to you?
Yeah, almost right away I got punched and fell in the water.
Where did you get punched?
On my face, on my side of the head.
Now, You've had a chance to watch this video, correct?
Yes,
Have you had a chance to see these 4,800 slides?
yes,
Prior to seeing that, did you remember everything?
no,
Have the video or the slides help you to refresh your memory in some way?
a lot.
Have you remembered everything because you've seen that?
Not everything, no,
Okay. Do you remember something different than what you see in the video?
no.
You don't remember any of the things different in that you see in the video, like you talked about the goggles?
Objection leading.
Overruled. We're just trying to reorient the witness to a place where examination can continue.
Are there some times when your memory is different from what the video is?
Yes, of course.
Okay. Now, this series that I want to show you is about things that were done to you, okay?
Yes,
Do you have a specific memory about everything that was done to you?
no,
Do you have a specific memory about everything that you did in response to what was done to you?
no,
Do you have a memory about how you felt in those moments?
I would say yes, I do,
Do you have a memory of what you believed in those moments based upon those feelings?
of course.
So I want to show you the slide here. Again, this is slide 2661, 2662, and 2681. That's fine. Do you remember how you felt when you fell back into the water?
I was, number one, I was stunned. That's why I fell backwards. I was very afraid, of course.
On this fear scale that you've talked about before, where are you on that scale from 0 to 10?
Right at the top, 10.
Have you ever been at that 10 before in your life?
Never been in a situation like this or a fight in my life.
Have you ever been at a 10?
Never.
When you did that, as we see on the right, what happened to your head?
Oh, well, I fell in the water. Obviously, that's a river, and I hit my head on river rock, and my whole body went under. Well,
Okay.
my head went underwater.
When you say your head went under, is that what it felt like?
Yes,
Did you feel water come over your face?
over my entire body.
Hold on,
Yes.
hold on. What's the objection?
Leading.
Sustained.
Where did you feel the water on your body?
Over my face, my mouth.
Okay.
I felt like I was submerged in water at the moment.
Did you try to get up?
Yes,
Why did you want to get up? Why didn't you just lay down there peacefully in the water?
to drown? No, I wouldn't want to do that. I wanted to get up out of the water.
At that moment, when you're down in the water, had anybody like A.J. Martin come up to you and said, just lay there and rest?
Somebody came from behind, yes, I found out later who he was, and pushed me down and to keep me in the water.
Before that, when you tried to get up, do you remember feeling anything before that? Did you told the,
Yeah,
did you feel anything to any part of your head?
yes, of course.
What'd you feel?
Felt punched in the head.
Showing you the next slides, is that 2701, 2705, 2706? What's happening to you there?
I'm getting hit on the head.
How many times at that point, is your memory of watching the video and your memory of experiencing this, have you been hit in the head now, but either by people or by the ground or by the water?
4 times at least.
Okay. At this point in time, where's your fear scale?
At 10.
When this happened to you, did you immediately get up, or did you fall back in the water, or did something else happen?
I tried getting up, but I couldn't.
Did you, at some point, did you feel something on your backside?
There was somebody pushing me down.
And when you felt that on your backside, did you feel anything else anywhere else?
I got hit in the face, in the front of my head.
And is that exhibit here, 2147, do you see that hand through the underarm there?
Yes,
Do you remember getting hit in the head there?
yes,
Was that a gentle hit?
no.
When you're getting hit in the head here again, where are you at on the fear scale at that point?
10,
Have you been able to get up out of the water?
no.
How many people do you know? How many people are attacking you?
At the time, I didn't know, but I knew there were more than I could handle.
Did it feel like it was, how many people did it feel like?
Like 10?
Okay. You've seen the video and you responded at some point, is that right?
Yes,
And you used your knife in response.
yes.
Why'd you use your knife?
I feared for my life.
Did you think you could get out of there without using your knife?
I couldn't even get up. You're pushing me down. No, so the answer is no.
In that time when you're down on the ground, did you think there was a way for you to escape?
No,
Did you feel like you could just crawl away or run away or walk away or do anything else to escape?
not in that position.
The next day after this, July 31st, were you in the, did you feel, how did your body feel the next day?
I hurt everywhere. My head hurt, my throat hurt, obviously my back hurt. I hurt everywhere.
You said your throat hurt. Is that something you remembered that day before when you were speaking with Brandy Hart?
Yes,
Okay.
yes.
Did you mention it to Brandy Hart?
I don't remember.
Okay. Did you see anything, when you felt the pain about your throat, did you see anything that refreshed your memory about what caused that pain to your throat?
After watching the video, yes.
Okay. What happened?
I got hit in the throat.
Do you remember
Really
that
hard.
now?
Yes.
If I can. Showing you the slides 2993, 2994, and 2997. Is that you?
Yes.
What's happening to you there?
Somebody is going for my throat, squeezing my throat.
Do you remember how that felt?
I felt pain. I couldn't breathe. Scared, afraid.
And showing you the next set of slides here, 2998, 99, and 3000. What did you think was going to happen to you in that moment?
The whole time I felt like I was going to die, so basically I feared for my life.
And in response to that, here's slide 3000. Did you do something in response to that?
I reached out and stabbed him.
When you used your knife, and again, this is open-ended, you can ask it any way you want. Were you trying to kill somebody?
Absolutely not.
What were you trying to do?
I was just trying to defend myself.
After this was, again, we've seen the video, you talked to Investigator Hart. So I want to ask you a little bit about that for a moment. Make sense?
Mm-hmm.
Do you independently, well, let me say, you've watched the video here in court, correct?
Yes,
And you watched the video prior to that. We've watched it together, right?
yes.
Does watching that video refresh your memory? Do you have an independent memory of that conversation with Investigator Hart?
No.
Do you remember what it is you said other than seeing things on the video?
Other than I lied about the knife, that's what I remember, afterward. Yeah, I lied about the knife.
Do you remember actually saying that in that moment, or you just remember seeing that and that's what you remember seeing?
I remember seeing it in the video.
Okay. Do you remember how you were feeling during that time at all? Do you have any memory about that?
Not much.
Okay. Just one other thing out of the timeline here. Since that time, we've heard testimony, you have a twin brother.
Yes,
Is he here in the courtroom?
yes.
Objection relevance, Your Honor.
Overruled. You may continue.
Just briefly, because I want to ask you about conversations that you may have had with your twin brother. Just briefly. How do you feel about your twin brother?
I love him.
Objection, that's irrelevant, Your Honor.
During this time, have you had conversations with your twin brother?
Yes.
Do you consider there to be anybody that you're really, maybe your wife, anybody you're closer to than your twin brother?
No.
You and your twin brother, when you speak, what language do you speak in?
Romanian.
Why do you speak in Romanian with your twin brother?
It's the easiest way to find words to describe what we're thinking.
Okay. Is that where you grew up?
That's the first language.
Are there times when you've spoke with your brother that you've talked about this, what happened to you on the river?
Yes.
Is your memory about what you did or what was done to you, is it any better when you talk to your brother than it is when you talk about other times?
No.
Are you always getting it right?
No.
How about your feelings? Your memory about your feelings?
Mm-hmm.
Do you get those right?
Yes, but almost all the time. The feeling is imprinted in my heart, my soul, my mind.
Let me, just for a moment, I'll bring us back to the river on July 30th, okay?
Mm-hmm.
At some, I think you'd said on the video and maybe you testified that people attacked you, is that right?
Correct.
At some point, did people stop attacking you?
No.
At some point, did people stop attacking you?
Yes.
Okay.
Yeah.
When people stopped attacking you, what did you do?
I walk away.
Okay. Why didn't you stay?
Oh, God. I walked away towards my group where it was safe. I was afraid of the people that I just had contact with.
When you're walking away, and you've talked about this fear scale. Where are you on the fear scale? Does it just go down right to 0? Does it stay at 10? Does something else happen?
No, as soon as I saw the people I trusted, my fear level started creeping down.
When you say creeping down, when you're walking back, can you give us where are you on that scale?
As I was getting closer to my group, the fear factor is going lower and lower.
But when you first start walking back, what's the number value?
About 8.
When you get back to the tubes, what's the number level?
About 4, 5.
I think we didn't talk about it. We've talked a little bit about your body response during this brief time. When you start walking back, how's your body responding to you?
I had cramps. I felt like I had diarrhea, so I felt like I lost my bowel.
Was that,
which I did.
Was that when you were walking back, or was that when you were in that 10 seconds of things happening to you and you responding?
I was when the action was going on, in the 10-second frame.
You got diarrhea?
Yes.
When you were walking back, what else is your body? What are you feeling with your body?
Well, heartbeat is getting, when I'm walking back, the heartbeat was very, very high. Now it's going down a little bit. Breathing, that's what I remember. I was super, super stressed.
How about your head? As you're going back, is your head clear? Is your head in a different state? How can you describe what's going on in your head?
My head was in a fog. It was like thick fog. I couldn't think. I couldn't realize what I've been through.
Were you trying to make sense of it?
I was trying, but there was no sense to be made. I was completely confused and in a fog.
And when you walked away, you had the knife in your hand, is that right?
Yep.
When you got to your group, did you still have the knife?
No.
What happened to the knife?
On the way back, I tossed it on the bank.
And you just made with your right hand kind of a underhand motion with your right hand from, at your side, raising up to maybe level with you. Is that fair representation of what you were describing?
Correct.
Why'd you toss the knife?
I don't know. I was afraid. I felt like I had to throw it away.
What were you afraid of at that point?
I was overwhelmed with just fear, residual fear. And I didn't want to have anything to do with that.
Okay. We've heard testimony that eventually you get back to the tubes. Does that happen?
Yeah.
Where's your memory about that? Right now, as you sit here, because we don't have a video about that, we don't have photos of that, what's your memory like about that?
Barely remember anything.
Okay. Do you remember talking to people?
I remember people trying to talk to me, but I don't know. I don't remember what I said.
Okay. You've heard some testimony about things that you might have said. Are you denying you said any of those things?
No.
Do you know what you said?
After watching the video, yes.
The video isn't I'm confused. The tubes, there's no video of you at the tubes. When you say,
After.
were you talking about Brandy Hart's statements?
Yes, yes.
Okay. About what you said to the people at the tubes, do you have any memory of that?
No.
Okay. When you're sitting there at the tubes, how were you feeling in your head? You talked about this fog, right? If you could put that on a scale, where is that?
I still couldn't, my head was in a thick cloud. I couldn't understand what just happened. Still trying to process everything. I was overwhelmed.
Did you think at any point you were just casual about what had happened?
No.
Did this feel casual to you in any way?
No.
At some point, you saw the video here, you had contact with the police, is that right?
Yes.
You had sat in the back of a squad car of the Sheriff Knutson, is that right?
Yes.
Do you remember much of anything about that?
No.
Do you remember, you've seen some of the videos today, can you tell us, what do you remember?
Nothing.
Okay. Nothing at all? How about a feeling? Do you remember a feeling at all?
Yeah, I was still very afraid.
Okay. When you say very afraid, what were you afraid of at that point?
Well, I've been through a horror situation, but in their presence, I wasn't that afraid, but I was stunned. I don't remember much about it.
Do you remember watching the video here in court when the police were talking about a guy with a bat?
Oh, yeah.
Do you remember anything about that?
A little bit.
Do you remember how that made you feel?
Oh, yeah. I felt very afraid of him. Very afraid.
We watched the video of you with Sheriff Knutson. That was about 23 seconds long. Do you remember that?
Yeah.
Have you watched a longer portion of that video with your attorneys?
I don't remember.
Okay. Do you remember saying more things to Sheriff Knutson after that?
I don't remember.
Okay, that's fine. We saw a video here about your being arrested and told that you were arrested for homicide. Did you remember that?
After watching the video, memory came back, but I don't remember that.
Okay.
Naturally.
When you're talking with at some point you go and you meet with Investigator Hart, is that right?
Yeah.
When they were talking about homicides and injuries, can you tell me what's your mindset? Did that make sense to you? Did you understand that?
No. I couldn't make any sense of anything that she was telling me. I just couldn't make sense of it.
Okay.
Plus, I don't remember the meeting with her.
Okay. Right now, as you sit here, you're like, I don't remember that.
Right.
The feelings, now, some of the times that you talk with Brandy Hart, you talk about what you saw happening or heard happening or what you did. Do you remember that?
Yes, yeah.
Do you get all of that right?
No.
Your feelings, when you were talking about your feelings about and how you believed and your fear.
I feared for my life. That's one thing I can't deny. That's embedded in my head forever. I feared for my life. I know that. I have nightmares about it.
You've talked to, tell us about those nightmares.
I have them every night.
What happens in those nightmares?
Objection, Your Honor. This point is irrelevant.
It's
His nightmares are irrelevant. The fact that he had them, maybe, but not the content. No.
Can I approach?
Yes.
Nick, I want to ask you some questions about those nightmares, okay? Just to put it in just this tight little box, okay? You've had nightmares?
Yes.
And the nightmares have been about what happened to you on the Apple River when you were attacked.
Correct.
And the nightmares are essentially a replaying of what it is that happened. Agreed?
Correct.
And when you have those nightmares, your body responds in
Objection, Your Honor, can we approach?
Yes. Let's continue.
Nick, those nightmares that you've had about what happened on July 30th, have you sought medical treatment for that?
Yes.
Just a couple of, I want to just make sure we check a couple of legal boxes, okay? When you used the knife, did you believe you were under attack?
Yes.
Why?
Because at that point, they've already been pushing and tugging and.
When you used the knife, had they done anything more than pushing or tugging? Did
They punched me, they pushed me down, they threw me in the water, I hit my head, yes, so.
When you decided to use your knife, were you using it to prevent an attack or stop the attack that was happening?
To defend myself,
Did you believe you needed to use that knife?
absolutely.
In that moment in time, again, as you've described it, they've pushed you down into the water, and you've been punched. That's the moment of time I want to ask you about, okay?
Yeah.
In that moment of time when you were down in the water, did you believe you could escape?
No,
What do you believe would have happened to you had you not used your knife?
I would have died. I believe I would have been killed that day.
Why'd
Or
you-
at that specific time,
Why'd you use your knife?
to defend myself.
Those are the only questions I have, Judge.
Mr. Smith-Stad.
I can approach, Judge. Mr. Leo, you've been drinking that day, right?
Yeah, I had a,
And
like,
showing what's been
beers.
marked as Exhibit 12A. You recognize that?
Yes,
That's the group photo of you folks from the beginning of the river?
Yep.
In fact, you're holding a beer.
correct.
Looks like everybody in your group has some sort of alcoholic beverage.
Looks like it.
You see numerous people in your group with these phone cases around their necks.
Yeah,
And as you're going down the river, you saw lots of people with phone cases around their necks, right?
mm-hmm,
All day long?
yeah,
In fact, River's Edge sells or rents out those phone cases, right?
I don't know that.
Did people in your group rent or buy phone cases from the tube rental?
I have no
stand?
idea.
All right. You've testified that you were told to bring the knife before you left your home, right?
Correct,
And the reason for bringing your knife on the river was to cut strings or ropes for the tubes, right?
correct,
And that was the reason you brought it.
correct.
In fact, you told the police that after your tubes were tied together, you thought you put your knife back in the car, right?
Correct,
But in fact, it was in your pocket.
yes,
Was it in your pocket the whole day?
no,
All right, well, we're going to get to that. Once the tubes are tied together with the rope, and you said that you thought that you put it back in your car, you don't have a reason to have the knife anymore, right? It accomplished its purpose, right?
I didn't know that at the time.
All right. Did you tell the cops, that the police, that you didn't think you were going to need it, and that's why you thought you put it in the car?
I may have.
All right. Were you present when Steve Kaufman, who owns River's Edge, testified first day of the trial?
Yes,
And you heard him say that they sell pre-cut cords for $1, right?
right,
All right. And then, did you see in the picture, when you got on the river, you were wearing that long sleeve camo shirt, right?
mm-hmm,
A hat and sunglasses?
correct,
All right. Ariel's phone was in one of those cases, right?
sure, yeah, I can see it.
All right, and is it your understanding that those cases are float cases?
That's what I was told,
All right, and you told, in fact, you told Lieutenant Hart that it was in a float case, right?
correct,
Once the phone disappeared, there was conversation amongst the folks in your group about whether it was even worth it to go look for it, right?
That's what I learned.
And in fact, you were told that they didn't care about the lost phone because they had insurance to cover it, right?
That's what I learned here, but I don't remember that as a conversation.
Nobody asked you to go look for the phone, right?
Correct.
You chose to do that on your own.
I volunteered.
And in fact, members of your group were a little annoyed that you were stopping again so quickly after having been at the hideaway where you'd stopped for lunch.
Objection, speculation.
Sustained.
Did you hear anybody in your group say, why are we stopping again?
I didn't stop the group.
The group stopped when you decided to go off on your own to look for this phone, right?
Objection, speculation.
Overruled.
Right?
They already stopped. I got off the tube to look for so I didn't stop them.
In any event, you're the one who insisted on looking for it. Nobody asked you to do that, right?
Objection, asked and answered.
Sustained.
And when you left to go look for the phone, you had your goggles and your snorkel, right? You knew that the phone was in a float bag, at least that's what you told police afterwards, right? Is that a yes?
Yes,
So the bag, the phone and the float bag would have been floating, right?
supposedly,
All right, and so you wouldn't need a snorkel and goggles to find a phone floating on top of the water, right?
I wasn't sure if it was actually floating or not, and never tested it.
All right, well, you would agree that a phone has some weight to it,
Yes,
and if it wasn't a float bag, it would sink to the bottom, right?
yes,
Where it was dropped.
correct. Well, or, remember, it's a river, so it could have flown down.
The river has current, right?
Right. So it could
If I
have
can
flown.
approach, I'm gonna draw something here.
Yes.
Now, you remember when you met with Lieutenant Hart, you drew a diagram of the river. All right, and this is your group up here at the sandbar, right?
Mhm.
This is the boys' group down here. And I'll put initials IS for Isaac Schumann, right?
Correct.
This is the diagram that you wrote, drew for Lieutenant Hart. The phone was lost over here, right? Instead of looking downstream for it where the current was going, you went this way, across the current,
No,
to look for the phone. You made contact with Isaac Schumann's group on the other side of the river.
but that's not where I started looking for it, straight across the river.
That's where you ended up making contact with
I
them.
ended up there, but I didn't start there.
All right, the phone would not have floated across the current, right?
Well, I don't know where he lost it. That's where we pulled over. He could have lost it minutes before we even anchored.
So when you testified a minute ago that the phone was lost, where your group was labeled M, now you're changing that story?
In that vicinity.
Objection. Mischaracterized his testimony.
Again, members of the jury, what the attorneys say is not evidence. Rely on the witness's testimony. Next question, please.
In any event, it's your testimony that you had reason to go over to the south side of the river where Isaac Schumann's group was, to look for a phone. That's your story?
I had reason to search in that area. I didn't know where that phone fell in the water. I don't think even Ariel knew where he lost it. We didn't drop the phone when we anchored. He dropped the phone before we got there.
Fair to say that at that point in the river is 150 feet wide,
Yep,
and Isaac Schumann's group was on the south side of the river?
correct.
Your group's on the north side of the river?
100 feet.
Rather than searching the north side, you went to the south side of the river. Is that fair to say?
I already looked in that area.
That's not what I'm asking. You went over to the south side of the river, right?
Objection, asked and answered.
Overruled. You can answer the question.
You did, right?
What was that question
You
again?
went over to the south side of the river to supposedly look for this phone, right?
I ended up there at that point, yes.
And you chose to go over there and look for it, where these boys were.
Asked and answered.
Overruled. You can answer the question.
Oh,
You chose to go over to where these boys were to supposedly look for this phone, right?
Chose to look in the area, yes.
There was other areas of the river where these boys weren't located that you could have searched until they floated past. Right?
A million other spots.
Sure. But you chose to go to that spot.
I didn't even notice those boys there at the time when I was searching.
You were present in court when Eric Williams, who was a member of your group, testified, right?
Right.
You heard him testify?
Yes.
And you were here when he testified that he had some concerns about you going over to snorkel by this group, Isaac's group?
I heard him.
And one of his concerns is that he thought that they would think you were a predator, right?
Objection, irrelevant.
Sustained.
He testified that you didn't have your knife in your pocket the whole time, right?
Correct.
When you decided to go snorkel over by Isaac Schumann's group, you had the knife in your pocket.
Yes.
Did you go back to your group and get it?
No, I had the knife. I testified I did not have the knife in my pocket the whole time. When we pulled over there, I fixed my shoes. Then I left it in my pocket.
All right, but somehow, so when you get ready to snorkel,
Yes.
you've taken off your shirt, right?
Yes.
Your hat,
Yes.
your sunglasses.
Correct.
You left the knife in your pocket.
I forgot it in my pocket.
Well, on the video, we can see you touching your knife, right? You knew it was in your pocket.
Well, when you walk, it starts, yeah, but
It has weight,
Right,
right?
yeah.
So you can't forget it's there because it's got weight. Correct?
at some point, I forgot I had it in my pocket when, yeah.
You
when
weren't
you
gonna,
walk.
you were not going to need your knife to snorkel and look for a lost phone.
Correct.
Overruled.
You weren't going to need your knife for that task that you set out to do, right?
I wouldn't even need anything.
But you brought it with you anyhow.
It happened to be in my pocket, yes.
When she got over to where Isaac Schumann's group was, they made it readily apparent they did not want you over by them, correct?
That's not true.
They didn't call you names?
Yes, but they asked me what I was looking for. And I thought they were polite people. I said, I'm looking for my lost phone.
They did not want you by them, and they told you that, right?
At some point, yes.
And that's the short video. You turn around and you're walking away, right?
Yes.
But then Joanne Cockfield calls you a raper, right?
Yes.
And then you turn around
Yes.
and you were angry.
I was not angry.
Oh, you were not angry that someone called you a raper,
No.
all right? You look at Joanne, who's filming you, right?
Yeah.
And for some reason, your testimony is that even though many people on the river have these phones and these float cases, you decided that was the phone and you needed to run up and check.
Objection, argumentative.
Sustained.
Your testimony earlier was you thought he had the phone, right?
I thought he had the phone, yes.
Right.
I wanted to investigate.
And you, instead of walking up and saying, hey, is that the phone I'm looking for, you ran up on these boys, didn't you?
I ran up and stumbled, and then I fell right by their, yes.
That's my next question. You're claiming now that you stumbled.
Yes.
You've never said that before today, ever, to anybody, any law enforcement or anybody else. Right?
But I have seen the videos now.
Well, we're going to take a look at the video. And since you reviewed the video, you know that before you ran up on them, you were touching your knife in your pocket to make sure it was there, right?
I don't remember that.
All right, well, let's take a look. That's you with your right hand touching your pocket where your knife was clipped in, right?
It appears so.
What is he on? Whoa! 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 Get away!
So you're claiming today that where you reach down and grab at these boys' legs where their tubes are, that was a stumble. Is that your story?
Objection argumentative.
Overruled. You can answer the question.
I know I hit a stone, yes, but I grabbed onto their inner tubes.
And you know where you grabbed onto their inner tube is where two of these boys had their legs draped over their inner tubes, right?
I see that.
And you made contact with their legs, didn't you?
I don't remember that.
Did you see it on the video?
I see it on the video. I don't remember actually making contact.
And as soon as you did that, these boys jumped out of their tubes to get away from you, right? You remember that?
Yeah.
And you held onto their tubes so that their tubes couldn't float away.
For how long?
Well, I'm asking you. You did.
Yeah, it looks like for a brief 1 second.
And you were searching through their tubes.
Or what?
You walked around their tubes. Rather than letting their tubes go so they could get back in their tubes and be on their way, you walked around their tubes.
So after my goggles dropped in the water, I went around their tubes to go to the other side and look for my goggles.
Let's talk about your goggles for a second, because you told the police, specifically Lieutenant Hart, that these boys knocked your goggles off your face and that you were looking for your goggles at that point, right?
I don't remember my interview with her, correct?
But you heard yourself say it in the interview.
Yes, yes.
And in fact, that nothing of the sort ever happened, right?
So the interview with Brandy Hart was not accurate.
What you said at the time is what you wanted the police to believe happened, right?
That's what I remembered at the
Okay.
time.
And from the video, you can see that you actually put your goggles in your mouth so you would have two free hands to be able to grab onto these boys' tubes, right?
Yes.
So you were preparing for your stumble before it actually even happened?
I wasn't prepared for anything.
These boys were calling you names to go away, right? After you grabbed onto their tubes, touched their legs.
I don't remember any of that stuff.
All right, you
But-
don't remember them calling you, asking you what you were doing?
Watching the videos, yes, but unnatural remembering, no.
Do you remember as you're running up, they're saying, whoa, 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 what's he doing?
I don't remember that.
All right, but you've seen it on the video.
Yes.
And then once you've made contact with two of these boys' legs and grabbed onto their tubes, they started calling you a pedophile, right?
I don't remember when they started calling me.
Do you remember them calling you a pedophile at all? Or do you just know that from watching the video?
Correct.
You testified that they were calling you names earlier, right?
Right.
And that upset you.
It did not upset me.
Okay, we've talked, your attorneys talked about your comfort scale and your fear scale. Let's talk about your anger scale, okay? At the time you were called a raper, what was your anger scale at?
Maybe 1.
1 out of 10?
Yeah.
And that was enough to get you to run up on these boys, grab onto them, stop their tubes at a 1. Is that what you're saying?
Objection argumentative, that's not what he said.
Sustained.
You don't like being humiliated, right?
Nobody does.
Your attorney has said that these boys were humiliating you.
Objection as to his making.
Sustained on the form.
You're claiming that you were being taunted.
Objection, he did not testify to that.
Sustained. Form.
You had testified earlier that your shoes, there was problems with your shoes, but as you can see from the portion of the video we played so far, those shoes didn't prevent you from running up on these boys, right?
Yes, they did. There was, if I had better shoes, you know, I could walk better, but I could still walk.
If you had better shoes, you would have been able to run up on them faster?
No, I mean, I could walk better. I wouldn't stumble. I wouldn't have a hard time walking.
All right, we're going to watch the video again, and I want you to, if you can, point out for everybody where you stumbled.
What is he on? Whoa! 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 Get away!
Did you watch it?
Yes,
So the stumble, is that something you remember or something that you think you see in the video?
something I remembered.
After you grabbed onto their tubes, stopped them, walked around their tubes, you took a few steps downriver and stood in the path they were floating in, right?
Has to form multiple.
Overruled. You understand the question, Mr. Mew?
Could you say it again?
After you left their tubes that first time, you took a few steps downstream and stood in their path where they would need to float, where they were floating, right?
For a few seconds, yes.
You didn't walk off to the south shore, which was close at that point, right?
I thought I walked far away from them, that they, I mean, I didn't even watch them anymore at that point, so I don't know where they were you know, at that point in time. But I was still looking for my goggles now.
Are you denying that you stood right in the path of their tubes?
Overruled. You can answer the question.
At that moment in time, yes.
Now, when you ran up on these boys and grabbed onto their tubes and made contact with their legs, you weren't saying anything at that point, right?
No.
You didn't say anything like, hey, I think that's my phone, or Ariel's phone?
I don't remember saying anything.
You've seen the video.
Right.
You just ran up and grabbed onto them, right?
It appears that.
Was saying nothing. We can go up to the screen. We're going to look at some more frames here. We're starting 22nd mark, I believe. You stood in front of their tubes, right? This is at the 23-second mark.
For a brief moment.
All right, keep going. Stop. At that point, you had the entire river open to move in any direction, right?
Right.
You chose to just walk a few steps directly downstream from where their tubes were, right?
Correct.
The boys were yelling at you at this point, right? You remember that?
Yep.
They were making a commotion, right? They were loud.
Mm-hmm.
And that attracted the attention of the folks in the Carlson group, right?
Mm-hmm.
You've testified that Maddie Cohen walked over, right?
Yep.
You walked towards her.
Yes.
And the water level at the spot that you had contact with Maddie was about ankle deep from the video?
From the video, yes.
And you told Lieutenant Hart you were standing in really shallow water, right?
Yep.
Maddie told you to leave the area, right?
She didn't say it that way, but yes.
She said, go, go, go.
And?
She swore at you too, but she was telling you to go, right?
Yeah.
You didn't go.
I was trying to communicate with her what I was doing in the river.
You didn't leave, right?
No, not down the river.
Hold on.
Protection irrelevant, no legal basis that it.
Overruled. It's it's relevant.
You did not leave, right?
I
At the
didn't
time
go
that
in
she
the
came up
direction.
and,
No,
when she came up and said, go, 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 you chose to stay, right?
I wanted to talk.
You didn't like that she was yelling at you, right?
I only had like 2 or 3 seconds of direct verbal or whatever.
And you clearly didn't like she was swearing at you, right?
Right.
And what you told her was not that you were looking for a phone, but that these boys took your goggles, right?
I don't remember what I told her.
If it's on the video, did you say it?
If it's on the video, yeah.
You never mentioned you were looking for a phone.
I don't remember my conversation with
And
her.
in fact, after you told her that they took your goggles, you never said another word, right?
After that?
Right.
Of course I did.
Talking about your anger scale, at the point where Maddie Cohen was yelling at you and pointing at you and swearing at you, where was your anger scale?
1.
And even with your anger scale being only 1, you started touching, fidgeting with the knife in your pocket, right?
I don't remember that.
Let's take a look at the video. We're ready. It's timestamp 135. That's you touching your knife in your pocket, right?
Correct.
And at this point, you've got your back to the 2 girls who were yelling at you, right?
It's possible.
So even though you were fearing for your life, you turned,
Objection. Not what he said at that time.
Overruled. Let's get the question out.
you turned your back on these folks, right?
Where am I in that location as reference to the other people?
I get to ask the questions at this point, okay?
All right.
You're back at the 135 mark that we just watched. You've turned your back on these folks, right?
Okay.
Is that true?
Yes,
You
I
saw
see
it,
that, yeah.
Right? You're touching your knife, but you got your back to them, right?
I see that in the picture.
And so at that point, you wouldn't have turned your back on these folks if you had fear of them, right?
Objection, mischaracterizes his testimony.
Overruled, overruled. You can answer the question. Yes.
We'll play a
Mr.
clip
Smestad,
here.
next question, please.
We're going to play a clip here, Judge. Go back. We're starting at 126. Just play it. We can have the screen. Stopping at 135. So in that clip, that's the point where you had waved at your friends, right? You had turned your back on the groups of people that were in the area, and you're touching your knife, right? And at that point, you called out to your friends because I think you had said, and maybe I'm wrong, that your fear scale was going up at that point. Is that not right?
I see lots of people around me, and I wanted somebody to be on my side.
Right. Your fear scale was going up, so you tried to wave your buddies over, right?
Creeping up, yeah.
And as it's creeping up, you're fidgeting with your knife.
It appears that way.
At some point, and even though your fear level is creeping up at that point and you've called for help from your friends, or at least waved for help, you turned your back, right?
Yes.
At one point, you turn your head and you stare at the group of 17-year-old boys, right? Do you remember doing that?
I don't remember it, but if I could see a video.
Put it into context, it would have been at the point when Maddie Cohen tried to turn you away from those boys. Do you remember doing that?
Yes.
And, one second. Right there. If we can get the frame up. We're at timestamp 116. That's the look that you gave to those boys, right? At that time, at 116?
Yes.
That's the look on your face.
Yeah.
That's an angry look.
Not to me. I was annoyed, more than frustrated, but not angry.
At the point where you looked at the boys with that expression on your face, whatever it was, you had the entire river in front of you open to walk to, right? That's true?
Correct.
And instead you chose to turn back around where Maddie Cohen was, right?
I stood my ground. I basically stayed in the same location.
Right.
I didn't go towards anybody at that point.
You didn't take a step away either, did you?
No.
And at that point then, that's when Riley Madison joins her, and you've got Madison and Riley standing in front of you, right?
I suppose that's the time, yeah.
Two girls.
Yeah.
And these two girls standing in front of you touched your shoulders somewhat, right?
Mm-hmm.
You never said yes?
Yes.
You never stumbled backwards or anything like that?
It wasn't somewhat, but
Well, let's take a look at the video. We're going to start a little bit earlier than the part I wanted to start at. It's at the 135 mark again, if we can put this screen up. You take the screen down. Starting at 134. So at that point, you're touching your knife before Maddie and Riley are standing in front of you, right?
Appears that way.
Stop. You had said that your fear level was rising.
Mm-hmm.
You had waved to your friends, right? That was the look on your face at the time, correct?
Mm-hmm.
You're smiling.
I'm confused.
You're smiling.
I'm confused.
You're not smiling?
That's not a smile.
Yes, let's move on, please.
Should I turn the screen off? Can we get the screen back? All right, so you had been fidgeting with your knife multiple times. You've got Riley Madison in front of you. I believe her testimony was she's a 115-pound woman. You got Maddie Cohen on your other side. This is when you choose to pull out your knife, right?
Objection as to form.
Overruled. You understand the question?
What does her weight have to do with me?
Sir, you don't get to ask the
Oh, I'm
questions
sorry.
at this point. You pulled out your knife at this point with these two girls standing in front of you, right?
Yes.
And you held it down by your belt line, right?
Yes.
And you opened it up, right?
Yes.
And this is before you had been punched or anything like that. You had that knife ready with these two girls standing in front of you.
Objection as to use of the term girls or women.
Women, pardon me. Right?
Mm-hmm.
And you didn't hold it up and say, hey, I have a knife, right?
To me, that would be a threat.
Well, I'm not asking you that. You did not hold it up.
No.
And you didn't, in fact, you held it down by your side, right?
Objection asked and answered.
Overruled.
Isn't that what you did?
Yes.
You didn't take a step back and brandish it and say, hey, back up, I have a knife, right?
Correct.
You opened it down low, and then you held it down low by your side, right?
Correct.
And as you're doing that, you're smiling, right?
That's not a smile.
Well, let's take a look at the
I'm-
video.
I'm overwhelmed and annoyed.
And that's you holding your knife down by your belt line, right?
Yes.
When you pulled it out and opened it up, you held it with the blade facing up, right?
I didn't pay attention, but in the video, yes.
And it becomes important later when you stab AJ because you didn't try to cut him down, you cut him up, right? Right?
That was not my intent.
Objection as to form.
Overruled. I believe the witness answered the question.
You had the knife blade up and you're saying you didn't know that?
I didn't pay attention.
As you're holding it there, you've got your thumb on the bottom of the handle, right? Right?
Yeah,
Blade up.
I see that.
Blade's pointing at, looks like at Maddie Cohen, right?
Yes.
Nobody else. I'll strike that. After you opened that knife, would it be fair to say that your fear level went down a little bit because now you had your knife open?
No.
All right. Was your fear level going up at that point? I think you said that earlier.
The whole situation was boiling up.
So when you have your knife open, You take a couple step backwards to get away from the situation?
I stood my ground. I stayed in place.
You never backed up one step, did you?
No,
You had your knife out and you were prepared to use it.
to defend myself.
At that point, there's nothing to defend yourself from, right?
I didn't know that.
If I understand your testimony today, now you're acknowledging that you did do something to Maddie Cohen, which started off this fight, right?
Objection argumentative.
Overruled. You can answer the question.
Objection, police probe.
Yes. All right. Mr. Smestad, would you please rephrase the question?
I will, Your Honor. You're testifying today that you did actually make physical contact with Maddie Cohen, right? Before you were punched or anything else, right?
I may have.
You don't remember that?
Well, I remember what I said, but I went over to push. She was right in my face, right in my space, yelling, and I could smell the alcohol in her breath.
But you had been drinking too, so it might have been your breath.
I didn't have vodka and all the other garbage.
My
Right.
point is, today you testified that you did something physical to Madison Cohen before you were punched, right? Correct?
I don't know if I touched her or not. It's possible that I did.
If your friend Sergio testified last week that he saw you push her and she went flying back a couple of steps, that's what happened, right?
Objection as to form.
Sustained.
Were you present when Sergio testified?
Objection as to form irrelevant.
Sustained.
After you pushed Maddie Cohen, only one person ever punched you, right?
From the video?
Right.
That's what I see. I don't remember what happened there at that time.
I'm not asking you what you remember, I'm asking what actually happened.
I got punched.
Objection, no foundation.
Sustained. Rephrase the question.
You
Start.
saw in the video that only one person ever punched you, right?
Yes.
Objection. Me-
It's cross, it's not
Hold
legal.
on.
Can I approach?
Yes. Objection sustained. Let's move on.
You testified that you went down and you fell down in the water when you were punched, right?
Yes.
And you indicated, I think, that you were punched in your jaw, I think on your left side of your body.
Yes.
You testified that you fell back in the water and hit your head, right?
Yes.
You did not drop your knife.
No.
Right? You held on to it when you fell down into the water.
Yes.
when Dante Carlson hit you, he was holding a can of beer in one hand, right?
Yes,
He was fighting you with one hand.
yes.
You never suffered any kind of bruising or cuts to your face from this incident, right?
On the inside of my cheek?
You cut the inside of your cheek.
Yes,
You never had any bruising on your jaw, right?
I don't remember. I mean, I had a beard, I couldn't tell.
You weren't bleeding from your face anywhere.
No, not that I know.
Let's play the video of him stabbing you. Once you're knocked down in the water, AJ Madison comes up to you and pushes on your back, right?
Objection, no foundation.
Sustained.
We'll play the video. You were pushed in the back by AJ Madison, right?
Objection, no foundation.
Overruled.
In response, you got up out of the water, right? You take your knife in your right hand with the blade up, right?
Objection is in narration.
Overruled.
That's what you did, right?
Still in my hand, yes, that way.
You jabbed it into his belly.
About the same time he hit me in the throat.
That's not what I'm asking.
Yes.
You jabbed it into his belly, right?
Yes,
Instead of pulling it out, you pulled up, right?
because I had so much time to think about it.
You pulled up.
I did not pull up.
Okay,
Look at the angle of my arm.
We're stopped at timestamp 156. You see your knife,
Yes,
how close it is to his jaw, his chin?
yes.
That's because when you stabbed him, instead of pulling out, you went up, right?
I was falling backwards with the knife in my arm, in my hand, and the angle of my arm was about the same. Just got hit in the throat.
In this frame of the video, the knife's pointing straight up, right?
Yes,
You went in, pulled up, and it's by the time you got done up by his face, your knife's pointing straight up.
Objection, asked, sorry.
Overruled. You can answer the question.
it's straight up.
At that point, Tony Carlson came in to break up the fight.
Objection, speculation. He doesn't know what Tony Carlson's doing along.
Overruled. You can ask the question, he can answer.
I don't know what he was doing.
You know that he told Dante Carlson to back up, right?
Objection, no foundation.
Overruled.
Do I know from video and from testimony? Yes. At the time, I didn't know.
After you stabbed AJ Madison, you were pushed back into the water, right?
Just sorry, it's AJ Carlson.
Pardon me. No, it's not. It's not.
AJ Martin.
It's AJ Madison. He's not part of the Carlson family. AJ Martin.
Thank you.
Pardon me. After you stabbed AJ Martin, you were pushed back into the water, right?
In the water, that's a timestamp in a filing cabinet that says this is what I suffered.
Do you exactly, go ahead, sorry to interrupt you.
Yeah, it's something I would love to erase from my memory, but unfortunately, there are lots of those feelings, very strong feelings I can't erase.
How confident are you in the accuracy of your feelings?
I know my feelings. I lived with my feelings for 54 years.
How about this feeling? How confident are you in the accuracy of this feeling that you're
100% confident that that is my feeling. 100% confident.
Even if you can't remember the details of everything you saw?
Correct.
Even if you can't remember the details of everything you heard?
Right.
Let me, because there were some questions, and I want to just make sure we cover it, right?
Mhm.
AJ, Mark, do you remember each of these acts that you're charged with, each of these acts of stabbing?
No.
Do you remember the particulars, that is, I should say, the particulars of like, X person did this, or Y person did this, or Z person did this?
No.
Do you remember, do you have any memory of just randomly stabbing people?
No.
What is your memory as to why you did what you did?
I was afraid for my life, and what I did, I had to do to defend myself.
Do you have a memory of stabbing anybody that didn't come towards you or attack you or touch you or push you or hit you?
No.
Did you ever just randomly go up and hit somebody?
No.
Do you have any memory of Tony Carlson trying to break anything up?
No.
You were asked about that, but I know there's some frames on that. Do you remember the frame in which Tony Carlson's coming up from behind and pushing you?
I didn't know who it was, but I remember being held in the water. I mean, it's a feeling that it gives me the nightmares, the trauma that was caused by that. That's the trauma that I remember.
There were asked some questions there at the end about the Larry and Davis video. Could you make anything out in there?
No, I thought I was looking at Sasquatch.
Do you remember anything about Dante? Dante Carlson is the person on the video previously that we saw here that had hit you. You know that, correct?
Yeah.
And he's the person in those two-tone shorts, correct?
Yeah.
Do you have a memory of how it came to be that you defended yourself against him that's not on the Jawan Cockfield video?
No.
You remember him coming up to you?
I remember lots of people coming onto me. I couldn't distinguish who. I don't remember color of shorts or anything like that.
Did you ever swing or hit the knife out of anger?
No.
Why'd you use the knife?
Because I'm a mechanical engineer, I use it as a tool. But what I used it for that day, I used it to save my life, for self-defense.
That's all.
Mr. Smestad?
So, Mr. Mew, we hear over and over again that there was 13 people there, and you're there by yourself, right?
Apparently, yes.
But we know that's not true because Ariel was behind you.
Objection.
Sustained.
13 people did not attack you, correct?
Looking at the evidence, correct. In the picture at the time, I didn't know that.
13 people were using words that you didn't like, right?
In action, right?
2 women touched you on your shoulders and arms, right?
They didn't just touch me on my shoulders and arms. You know that.
You were 250 pounds at the time, right?
Yes.
And these women touching your arms caused you to fear for your life?
They're not touching.
Objection.
What's the objection?
That's not the evidence. That's not what he said.
Again, members of the jury, disregard what the attorneys say because what they say is not evidence. What the witness says is the evidence that you rely on. Next question.
You said the time slowed down for you on redirect, right? You said the rules didn't apply, time slowed down.
To me, at that time, everything felt different.
If time had slowed down, you would have time to consider your actions, right?
If it did slow down, yes. So I was wrong when I said it slowed down, but yes.
But that's what you said, right?
I understand.
You never told the SART nurse that you had been drowning, right?
Objection beyond the scope.
Overruled.
I don't remember what I told the doctor.
You ever told Lieutenant Hart that you had been drowning?
I don't remember.
Nothing further.
Thank you, Mr. Mew. You may come back to the table. You need a few minutes?
Just a couple minutes, yes, please.
All right, let's come back at 3:45. Please take the jury out.
All right, for the jury.
We're in recess, 3:45.
Colonel, I just want to talk to you about expected general essence. Do you have anything?
We'll have to chat real quick.
And good afternoon from our Fox 9 streaming center. You've, of course, been watching our Gavel to Gavel coverage of the Apple River stabbing trial. Watching the defendant Nikolai Miu on the stand for hours today, answering some tough questions from the state. He survived. He may have been looked at as on the ropes at some point, but he did make it through. What this jury makes of his testimony and his lack of memory there on certain things, certain interviews, remains to be seen. In case you haven't joined us, let's go right back. I have some sound I have queued up, an important exchange on the stand. Here's Nikolai Miu.
Tony Carlson never punched you, correct?
Correct.
He never kicked you, never pushed you.
Objection. Mischaracterize the evidence.
Overruled.
No.
And you turned around and you stabbed him twice, right?
I couldn't see. I couldn't hear. I didn't know who was punching me, touching me, shoving me, nothing. I was fearing for my life.
You stabbed the guy who tried to break up the fight twice, right?
Objection. Form.
Overruled.
That's what happened, right?
That's what happened.
And luckily for him, he was able to block your first stab, so you stabbed him again, right?
I had milliseconds to think.
Riley Madison, after you stabbed Tony Carlson, you turned around, you got up, you turned around, and you sliced Riley Madison through her left side of her body, right?
Yes.
She wasn't punching you or kicking you.
She came at me. She had her hands on me.
At the time you stabbed her, she had her hands on you.
Yes.
This 115-pound woman attacked you while you're standing there holding a knife.
She could have been 500 pounds. I don't know. I'm sorry, sir, but
You've never told anyone ever that Riley Madison attacked you and that's why you stabbed her, right?
No.
You're saying it today for the first time.
I don't remember this whole thing.
After you stabbed Riley Madison, Isaac Schumann tries to push you, right?
And he lands his hands on my throat, yes.
But his hands originally weren't anywhere near your throat. They were on your shoulder and your chest, right?
I didn't take measurements, but yeah, from the picture, yes.
And as soon as he touches you, you stab up into his heart with your knife, right?
Objection, no foundation.
Overruled.
He went for my throat, and I defended myself. Yes.
You heard him there, Nikolai Miu. He went for my throat, meaning Isaac Schumann, and I defended myself. You're taking a two-screen look. Of course, the state seal there in Hudson, Wisconsin. They are on a short break. We'll stick with you for that break just to set the stage here. I don't exactly know 100% certainty what comes next. There's a possibility the state may have a rebuttal witness of sorts. There is a slight chance the defense has a witness or two. Their list does suggest one or two more names. Or the defense could rest, and we could sort of head towards closing arguments, which would then get underway tomorrow morning. I'm seeing some heads move in the courtroom. That usually suggests that the parties are ready to go or getting their stuff, their things in order to come back in, and we'll see where we go. Nikolai Miu, by my count, nearly the 50th witness called when you combine both sides, 47 by my count. We are 7 days into this trial, a trial that was initially slated to last about 2 weeks. They had booked and told this jury to go all of last week and then through Friday this week. As we know now, they are ahead of schedule. Nikolai Miu there wrapping up his testimony. One piece of evidence that did come in on rebuttal, I'm a little anxious whether we should show it to you or not again, but let's give it a shot, and we can always dump out it if we need to. A key conversation Miu had with the sheriff of St. Croix County on July 30th, 2022. Miu is under arrest. He's in the back of the squad car. He has not been Mirandized. So initially this interview did not come in, but to impeach his witness testimony, the state was allowed to introduce it during their cross-examination. Let's go back again, July 30th, 2022. Nikolai Miu said on the stand today he didn't even remember this conversation, but here he is talking to the county sheriff shortly after the stabbings.
Still doing all right?
Yeah.
Okay.
What's going
Temperature's okay in here?
on? Yeah.
Okay.
I hear somebody got stabbed. And I fit the description.
Yes, you do.
All right.
Yep, so we're working through that now. Did you see that fight on the river?
I heard about it.
You heard about it?
Yeah, and I seen people gather around it.
Okay. All right.
And I went over to talk to see if somebody saw anything, but that's about it.
Okay.
Our whole group was pretty interested in finding out what happened.
Okay. And that's your whole group over there?
Yeah.
Okay. All right.
All right, well, Judge Michael Waterman keeping punctual as he has for the 7 days that we've been in his courtroom. He's back at 3:46. He said 3:45. The jury is coming back into the room. Let's listen in and see what they want to do for the rest of the day. But he does not go beyond 4:30. So we are certainly in that last
Please be
phase of
seated.
the afternoon.
Mr. Trofficy, is there another witness? Mr. Nelson?
The defense rests.
All right, defense rests. Mr. Anderson, will there be a rebuttal?
No.
All right. Members of the jury, that means the evidence is closed. We're almost at the end. I have some matters to discuss with the attorneys. It would not be practical to keep you here and try to push through closing arguments and end up working into the night. So I'm going to release you now. I'd like you to come back tomorrow morning, 8 a.m. What is going to happen tomorrow morning is we'll all come back into the courtroom. I will give you the jury instructions. The attorneys will deliver their arguments, and then the matter will be handed over to you for your deliberations. Again, the reminders are the same. No independent research or investigation. Do not talk about this case among yourselves or with anybody else. Do not consult news reports or social media posts about this case. Enjoy the rest of your night, and we'll see you tomorrow morning at...
Can we just approach
Yes.
the timing?
Correction, 8:30. 8:30 tomorrow morning. All right? Anything else? All right, please take the jury out.
All rise for the jury.
Please be seated. We are outside the presence of the jury. Mr. Nelson, Mr. Trapassi, do you have anything else concerning the evidence? Motions?
Yes, Judge, we would renew the motion that we'd made before. The arguments are the same. I believe the burden is different. And so if Your Honor wants additional arguments, the facts haven't really changed. It's just the burden has.
I think the burden is the same, but the evidence that I can consider has expanded, correct? I can consider the entire body of the evidence, not just what the state offered.
Fair enough.
All right. Mr. Anderson, is there anything that you want to add?
No.
All right. Again, that motion is denied. I stand by my earlier rulings. I think the evidence that has been presented thus far is sufficient to warrant this case going to the jury. This morning, I handed the attorneys rough draft number 3 of the jury instructions. Have you had an opportunity to look at it, or do you need some time?
I need some time.
How much time?
Me too, Judge. I haven't looked at a page of it.
Are we going on the record or not?
Well, I'd really like to get it done if we could. I don't know how much time you need.
I haven't even looked at it. I apologize, but obviously it's been a full day. And so there are 29 pages, you know, can you tell at least 4:15?
Will that be enough time for you?
Well, I'm going to defer to Mr. Anderson. He's looked at them a little closer than I have.
Should be, Judge. I know that the one, it doesn't need to be lengthy, but I think would be appropriate is something on defense of others, because there's testimony that Dante and AJ were responding to Mew punching Maddie when they responded. So,
Okay. Let me just kind of recap where I think we are. I had initiated a rough draft of the jury instructions. Includes instructions that I knew were going to be required, ones that I anticipated the attorneys would want, and instructions I thought the evidence would justify. The attorneys and I have discussed the draft. We spoke most recently yesterday. There were some areas where I needed input. I got the input. In the draft you have now, it reflects the changes that we had discussed yesterday. The areas that are in red are areas that remain unresolved from yesterday or were added based on Mr. Anderson's submission late yesterday regarding the lesser included charges for counts 2 through 5. So it should look familiar to everybody, with the exception of the portions in red. Just give me a better understanding about the defense of others instruction, how you see it fitting in, where do you want it?
So the testimony from Dante and AJ was they saw Mew punch Maddie, so they were defending her. So I think the jury should be able to know that not only is it legal, is self-defense legal when justified, so defense of others.
What's your reaction, Mr. Trapassi?
Never heard of an affirmative defense being given in a criminal case for a victim. And I haven't looked at it. It strikes me as completely convoluting everything we're doing. But I would need to know, are they saying that gets rid of the right of self-defense? I don't know what it means in terms of how the jury is supposed to consider that evidence. If they consider that, are they saying, if you find it's defense of others, then self-defense doesn't apply? I don't think it strikes as self-defense.
Yeah. Mr. Anderson, how does it fit into your argument?
I think when I was reading this before, I think there's a spot where it could be added in very succinctly, but I just want to be able to tell the jury that, look, you have these jury instructions in Wisconsin. It's legal to come to the aid of others, and that's exactly what Dante and AJ did. And it also intertwines with
But has it reflect on Mr. Mew's guilt or not guilt?
his provocation is what responded them to come to the defense of Maddie, and then he starts stabbing people. And they had a legal right to come to her defense under the theory of defense of others.
So, if I may, Judge?
One question, are you proposing the pattern instruction, or do you have something custom made?
I think it could be more succinct. I could come back with a...
Yeah, why don't you do that so that we're all looking at the same language? What did you want to add?
The only way, again, I agree with Mr. Troxy, I just don't see how this comes in. The only way would be as it comes in under that red paragraph on page 3 under provocation in some way, but then it doesn't make sense because the issue is whether Mr. Mew's conduct was unlawful. Whether Dante Carlson's conduct was lawful or unlawful has no bearing whatsoever on whether provocation occurred, and whether Mr. Carlson or A.J. Martin's behavior is lawful or defense of others. That has no bearing on Mr. Mew's beliefs or the reasonableness of his beliefs, because there's zero evidence that has been presented that Mr. Mew had any impression, understanding, or knowledge that what was being done to him was legally the defense of others. And so it's irrelevant, it's prejudicial, it's confusing, it has nothing to do with Mr. Mew's beliefs, which this entire case is about.
All right. Let's put it on hold. Give me the proposed language that you want to have me consider. I'll give you 20 minutes to review the most recent draft. I'd like to, if we could, I'd like to finish the instruction conference today so that we can come in fresh tomorrow morning. But if the clock prevents us from doing so, we may have to adjourn it till tomorrow morning. So we'll reconvene at 4:15.
And are we on the record at 4:15 or are we?
That's my intention, yes. Yeah.
And good afternoon once again from our Fox 9 streaming center. You, of course, watching our Gavel to Gavel coverage of the Apple River stabbing trial. Huge developments there. Defense has rested. There are no rebuttal witnesses from the state. The state has rested, as it did earlier today. There is no more evidence to be presented to this jury. Now the two sides have to go over jury instructions. We watched the discussion there, and then closing arguments tomorrow. I want to bring in our legal analyst today, Eric Nelson, local criminal defense attorney. Thank you, Eric. You've been watching with us this afternoon. Could you help us sort out, I know it's confusing, so it might be even too much for you because it clearly baffled the defense team there. Help us understand what the state might be trying to get at with this defense of others and how it could play into what this jury ends up getting presented tomorrow.
Yeah, it's a very confusing motion on the part of the state. It's not anything I've ever seen. The teenagers who allegedly or purportedly came to the defense of the woman who was struck, they're not on trial. Their actions are not ultimately going to be anything that the jury will really have to consider to render a verdict in this case. There's nothing that would prevent the DA from making an argument that they were coming to her aid. But it would just confuse the jury, I think, to include any sort of defense of others instruction as it relates specifically to their conduct. I mean, Mr. Mew is the one who's on trial, and it's ultimately what he believed and his use of force that is of issue.
And Eric, we've talked about it quite a bit with you. Maybe you're sick of talking about it, but the reason, one of the reasons I so enjoy having you on for this very specific conversation is because of your experience about a decade ago. It was a self-defense claim, a deadly stabbing along the St. Croix River, again, neighboring Wisconsin. You won an acquittal. You had a young defendant take the witness stand. No video in that case, but the young man was found not guilty. Levi Aker Kendall, a fascinating trial that I covered. at that point, or at some point at the close of that case, the state there did add a lesser included murder count. I'm not exactly remembering the specific on the statutes, but we are at this point in the Miu case. Would we have just heard about a potentially lesser included murder charge, perhaps a count of reckless homicide, or could that come tomorrow? When would we hear if the state is going all in on those first degree murder and attempted murder charges?
Well, what I heard the DA say, or the judge say, was essentially that they were looking for lesser includeds on 2 through 5, I think, were the counts. So it appears that the state is not seeking a lesser included on the homicide count, which would obviously have a life sentence. But it appears that they are seeking some sort of lesser included offense as it relates to the other 4 individual counts. That's what I heard say. I don't know what those lesser includeds are, whether they were assault type charges or attempted, reckless homicide rather than intentional homicide. So I'm not sure exactly what the lesser includeds are, but they're certainly gearing up